Good morning, everyone, and welcome to the Arizona State Board of Pharmacy meeting. It is October the 15th. The time is 8:31. Sorry, we're running a little late. We had a IT snafu, so we will call the meeting to order. Dr. Gandhi, if you can do roll call and conflicts of interest.
Thank you, Madam Chair. Mr. Braswell? Mr. Thorwald?
Here, no conflict.
Ms. Browning? Ms. Davis?
Here, no conflicts.
Ms. Walmsley?
Here, mine have been submitted.
Ms. Park?
Here, mine have been submitted in writing.
Mr. Hogan?
Here, no conflicts.
Mr. Al-Nassif?
Here, mine is 4K, item 4K.
Thank you. Mr. Anderson?
Present, and mine have been submitted 9B.
7 present, 2 absent, Madam Chair. And for the recusals, please identify the recusals when the agenda item comes up, just as a reminder.
Absolutely. Thank you. Thank you. A couple of housekeeping notes for those of you that this is your first time being here. Welcome. If you are interested in CE, make sure that you sign in the back. We do offer CE for the morning session and the afternoon session. If you want to get CE for the whole day, you'll need to sign in now and then again after lunch. We will move forward to tab 4, which is consent agenda complaints. I have notes to pull items 4G, 4J, and 4O. Is there anything else anybody would like to pull for further discussion? All right, hearing none, let's go ahead and go to item 4G. This one was voted by the committee to send for full board review. This is a complaint. Pharmacy continued to dispense a patient's former medication after her medical provider issued a new order with the revised directions. Does somebody from complaint review want to kind of start and tell us what your conversation was like and kind of where you're thinking?
Yeah, I like to start. Can you hear me?
Yep.
So for this case, I moved for a warning letter for pharmacists there. But given it more thought, I believe the old prescription is still active. And the discussion was the pharmacist, from my perspective, cannot discontinue something active. It's a legit prescription. And there is no evidence how this old prescription pulled out for filling. So part of the discussion, I believe, in nursing home setting or hospital settings or any other settings, not community pharmacy, providers discontinue the old treatment and initiate a new one. We have been seeing a lot of those, I don't want to issues in the community pharmacy because the providers do not do that as they do in other settings. So I'm not trying to underestimate what's happened here. It is an issue, but I believe this is a provider and it's shared responsibility between patients, providers, and pharmacists. So I just try to dismiss when I revisit it, and then we decide to revisit it now for more thoughts.
Thank you, Sharik. Additional thoughts?
So to make sure I understand, Tarek, what you're saying is you don't agree with an advisory letter because you believe there are mitigating circumstances in this case.
Correct.
Okay.
Correct.
I mean, I agree with where you're going with this. I mean, it's still an active prescription, so it's not like it's something that the pharmacist should have discontinued.
Yeah.
And they only have the information that they have to make the decision.
Correct.
But if I may, Madam Chair, they did have the information that the patient was on a new regimen, and they dispensed an artifact prescription that remained active and on hold on the patient's profile. When the newer prescription with the correct directions for use ran out of refills, they allowed that artifact prescription with the incorrect directions to be dispensed to that patient. So they really didn't do their prospective DUR and understand, why this why am I giving a dose reduction to this patient when they're on this new dose? So there is a concern there, and the pharmacist does have that information available to them on what the current regimen is and why they're allowing an artifact prescription that may still be valid to be rise to dispensing so that the patient then doesn't get the therapy that was most current and what was ordered by their provider. So that's the concern.
Any additional thoughts?
Mr. President?
Yeah.
Oh, this has turned up pretty loud. Steve Hyber, Compliance Officer. The only thing I'll add to Mr. Anderson's statement is the date of the one.
Recording in progress.
Oh, that was nothing.
Good.
Okay. I think we're good. The date of the prescription that was filled after, the one that it was placed on hold, the issue date of that was prior to the most current prescription. So that's sort of the mystery there. Why would you fill one with the different directions that was issued prior to the most recent therapy? Now, with that being said, the employees, the pharmacists rely on that computer system quite a bit. I think we all know that, those of us that have utilized those systems. And when a system does a certain thing, you incorporate that into your practice routine after so many thousands of cycles. From what I've observed is these systems don't really look at that second prescription and flag it, because I believe some of their statements indicated it didn't present a DUR alert. Now, we're all wise enough to know that the laws don't require a computer system. It's the pharmacist's own responsibility. But after many thousands of cycles of utilizing technology, you begin to rely on that. So I think the flaw is there. We don't really have anything in statute or rule we could charge the permit holder, but I think it's something that they probably need to be aware of to assist their employees in providing better service to their patients.
I totally agree with Mr. Hyber's comments, and I believe that this permit holder, the corporate permit holder, will be here later during the meeting to discuss a related or a similarly situated case that we discussed at the last meeting regarding ciprofloxacin, and where this has happened again. So it's a problem that needs to be addressed, and strictly dismissing it, I don't think is appropriate.
I agree with Mr. Anderson as well.
Yeah, and I think we had a lot of really great discussion around it during the complaint review, and honestly, I could go either way with it, with either a dismissal or advisory letter. I think there's maybe perhaps system enhancements that could take place, but it's still, I think the other question is how that refill came in. We don't really know if it was something that was the system did it, if it was a technician that looked at it, if it was the patient that requested it. There's so many different ways that we could request refills. So if it's active, and I can also see where there might be cases where we wouldn't deactivate a prescription. So you have to go based on the information that you have available, and it's not the complete picture. So it's, that's why I'm leaning towards dismiss.
Thank you. I'd just like also to add, the fact that we don't know how this prescription moved to fill queues, so that's why I'm moving for dismiss. If I would say if the patient had discussion with the pharmacist and pharmacist decide to give it to the patient, that's totally different story. But we don't know. I cannot hold people accountable with no evidence what's happened. And considering the patient has a right to keep this prescription active, because we don't know what the verbal agreement with provider. So let's go back to take once a day instead of twice a day. We don't know, right? And I'm glad that this permit holder, they're gonna come before us later today or tomorrow, so we can understand about their system. But from my knowledge, most of these vendors, when you have DUR, you overwrite once it will not come up every time. So unless you have a new DUR, I mean, that's standard for software. And that's why we're gonna hear from them today. So I don't want to like just keep bringing for different cases and it is the same issue, right? So they already coming to provide us more information in the previous issue, and then we can address if there is any concern.
Tariq, do you have a motion?
I mean, just like I move to dismiss the case considering there is no evidence for how that previous prescription took place. So I move to dismiss the whole case.
I'll second.
I have a motion and a second. Any further discussion? Hearing none, all those in favor? Aye.
Aye.
Any opposed?
Nay.
Motion carries. I think it was 5-2. All right. Moving on, we will go to item 4J. I am recused from that one, so I will step aside.
So this is complaint number 25-0272. Respondents are Jose Valdivinos, pharmacy technician trainee, Stephanie O's, pharmacist, and Walgreen number 12739. Type of complaint, a customer received another customer's prescription in their order. And we have Mr. Wagner and Mr. Leong here as compliance officers. Would you like to make a statement?
Thank you, Mr. Anderson. My name is Truman Leong, Chief Compliance Officer. At the Complaint Committee review, the board had asked for additional clarification on this specific scenario in DEA 106 and circumstances involved if there's a pharmacy error or pharmacy misfill, or in this case, a controlled substance given to the wrong patient. In those instances, does it trigger or require a DEA 106 form to be submitted? Dennis and I looked high and low through the DEA practitioner's manual as well as the CFRs. And unfortunately, we weren't able to find something that specific. I had called DEA drug investigator Erin Hager. She was okay with me using her information for the purpose of this public board meeting. And she stated that unfortunately, those situations for accounted for errors, controlled substances, in this case would be deemed professional judgment. It would be advisable to err on the side of caution when reporting, but nothing specific that would trigger a mandatory requirement for a pharmacy misfill and accounted for losses. That being said, she also advised the pharmacy that they could contact the patient's PCP for the person that did receive the incorrect controlled substance for notification and accountability purposes. And that was all the information that I had received from DEA. There was no other written information that we could find, but Dennis does have some additional information.
Thank you.
Dennis Wagner, Compliance Officer. Just to add on to Truman's comments, I did review the Pharmacist Manual and the Controlled Substances Act as Truman indicated, and could not find anything specific to misfills. However, I did return to the pharmacy and did find evidence that they did report the incident to DPS as well as to the Board of Pharmacy.
Thank you, Mr. Wagner. I know that was a concern of the Complaint Review Committee. We'll open the floor for any discussion.
Mr. Chair, if I may, just for conversation's sake, I think these situations, unfortunate situations that may occur where someone gets the wrong medication, that's a controlled substance, it may be advisable to let the board know so that we can at least monitor if there's a pattern of misfills taking place monthly of controlled substances. There may be something else going on that we need to look at versus not reporting it at all and being a blind spot for us.
Totally agree.
It's just I like to add to the discussion, and I'm glad they reported it and everything's fine. But reading the DEA code and the rules, they specified the loss as unexplained loss, right? And then I believe that's when the pharmacies or pharmacists sometimes get confused that they can't explain it, but that's why not needed for report. Now, also reading the DEA rules is always talk about the public safety. So just to bring it to people, like it's part of reporting, it's for public safety, right? So like when you have big amounts of narcotic in the wrong hand, you never know what you're gonna end up with. So I'm glad they did that, but just I agree with all of this. Like it's still like not clear, but we always, as Dr. Ganti, like we recommend reporting those things. So I believe so. The discussion was, Mr. Chair, about the permit holder, right? So
All three respondents, the technician trainee, the pharmacist, and the permit holder.
okay. So I can now, since we have the answer, so I believe the pharmacist has nothing to do with this error because it's got mispackaged by a pharmacy technician trainee, and the pharmacist has nothing to do with it, and the permit holder has nothing to do with it. So it's solely for pharmacy technician trainee. So my motion is dismiss permit holder, dismiss pharmacist, and 3 hours of continuous education for the pharmacy technician trainee regarding preventing error or patient safety.
Thank you.
And non-disciplinary.
Thank you, Mr. Nassib. Do we have a second?
I'll second.
All right, we have a first and second. Any further discussion? All right, all in favor, please say aye.
Aye.
Any opposed? All right, motion carries.
Which one?
Was it or?
Mr. Chair, we just learned that this individual currently may be working for Walgreens.
All right. So this is tab number 40. This is complaint number 24-0569, respondent CVS 10742, pharmacist Nathan Wenger and pharmacist Christina Bonillas. Type of complaint, the pharmacist failed to exercise corresponding responsibility when choosing to fill and dispense multiple controlled substance prescriptions. The complaint review committee asked for this to come to the full board today because we felt it was just way too big for the small complaint review committee to make a determination, and we wanted the expertise of our colleagues to make the appropriate determination here. So I'll open the floor for discussion.
Yeah, I mean, it's big case. You know what I mean? Like, I understand that like pharmacists may overlook like something like one prescription or some incidents, and I mean, they cannot catch fraud prescriptions. To me, I'm just struggling to understand how they made this decision for like a message over the phone. And you know the case, I don't want to go with details, you know what I mean? But to me, I mean, I believe like we need to address this in an appropriate way. Like, and we know the outcome wasn't like really good outcome. So it was a tragedy here. So, but on the other hand, I don't think there is a relation between the provider and the pharmacist. This is not, is that right, Mr. Castaneda? Just if you can.
Morning, board members. Ben
Good
Castaneda,
morning.
Compliance Officer, Arizona State Board of Pharmacy. So, Mr. Al-Nassif, that is correct. Both pharmacists denied any prior relationship with the provider.
Okay, that's
The Controlled Substance Act requires that prescriptions only be delivered to the patient or the patient's agent, and prohibits a prescriber from receipt of prescriptions unless it's just one dose. I don't know. I think that the pharmacist here had a responsibility to understand that a practitioner picking up so many controlled substances for various patients was not appropriate.
Agree. I think there's so much information here that making a determination at this stage, I would think a conference would be appropriate. I'll make that my motion.
Second.
All in favor, please, or any further discussion? All in favor, please say aye.
Yeah.
Aye. Any,
I'm sorry. I mean, but I believe the permit holder only for pharmacists, right? The permit holder has nothing to do with it, right? Or do you like to hear from everyone?
all respondents.
All responded? Okay, sorry.
Yep. So all in favor, please say aye. Aye.
Aye.
Any opposed? All right, motion carried. Welcome back, Ms. Walmsley.
All right. I forgot to take a motion for the minutes. Do I have a motion to approve the minutes for the last meeting? It was the emergency rule meeting, right? Dr. Gandhi, because we did the others at that meeting.
That was the hearing, right?
Yeah.
Was the hearing?
And the meeting. Okay, so the emergency hearing.
Yes.
To have a motion for that.
I move to approve.
I have a motion. Do I have a second?
Second.
All those in favor?
Aye.
I'd like to abstain since I wasn't present at the meeting.
And I also abstain.
No, I want to.
All right, motion still carries, so that's fine. Do I have a motion for the remaining items on the consent agenda, which are the remaining items we've not discussed in complaints, tab 5, 6, 7, 8, 9. I'm sorry, 5, 6, 7, 8.
I move we accept the rest of the items on the consent agenda. Second.
I have a motion and a second. Any further discussion? Dr. Gandhi, roll call.
Mr. Braswell? Mr. Thorwald?
Aye.
Ms. Browning? Ms. Davis?
Aye.
Ms. Walmsley?
I noting recusals on 4B, 4E, 4J, 4L, 4N, 4O, 4R, 6A, 8A, number 36.
Thank you, Madam Chair. Ms. Park?
Aye.
Mr. Hogan?
Aye.
Mr. Al-Nassif?
I noting my recusal 4K.
Thank you. Mr. Anderson?
Aye.
Ayes have it with 2 absent, Madam Chair. Noting all recusals.
Thank you, Dr. Gandhi. All right, that takes us to item 20B, I believe. Is that where we want to go, guys?
We may want to, we may want to hold off on that until after 10 a.m.
Okay, just because of the timing. Oh, yeah, because we've only got 20 minutes before they're unavailable. Okay, we'll go to 9B then. We'll skip around a little bit. 9.
Madam Chair, I'm recused from this one.
Okay, thank you. 9B is complaint number 25-0455, Brandon Hendrickson. Is Mr. Hendrickson present?
I'm here.
Are you able to turn on your camera?
Oh, sure.
Thank you. If you could please introduce yourself with your full name for the record.
Brandon Hendrickson, pharmacist.
Thank you. Ms. Brown, can you give us a brief summary, please?
Certainly. Jenica Brown, Executive Assistant to the Deputy Director. Brandon Hendrickson was issued an Arizona pharmacist license on July 30th, 2002. His license expires on October 31st, 2026. It is currently open and on probation. Board staff received a notification that Hendrickson was terminated from employment at Apostrophe Pharmacy on August 4th, 2025 for failure to provide the pharmacist in charge a copy of his consent agreement in board case number 24-0350. The agreement requires Mr. Hendrickson to advise the board immediately of any change in employment status by updating his online profile and submitting a written notification to the board within 5 days. It also requires Mr. Hendrickson to provide a copy of the executed consent agreement to his employer and PIC. Within 10 days of being provided with a copy of the consent agreement, the PIC shall submit a written acknowledgement to the board. Staff opened a complaint to investigate the possible violation of a board order and began the investigation by reviewing the information Mr. Hendrickson submitted in February 2025 related to his employment. He reported on February 3rd, 2025 that he obtained employment with Hims Pharmacy on January 23rd, 2025, and he supplied the PIC a copy of his consent agreement. An email was subsequently received on February 19th, 2025 from the head compounding pharmacist at Hims Pharmacy, indicating that he received a copy of Mr. Hendrickson's consent agreement. Staff sent Mr. Hendrickson a notice of complaint and requested a response to the allegations, in addition to clarification around his previous employment, as the notification of termination from Apostrophe Pharmacy did not align with his employment information on file. Mr. Hendrickson's response illustrates that he provided the consent agreement to his hiring manager and direct supervisor and notified him that the PIC would need to submit an acknowledgement to the board. He stated that he believed that the hiring manager discussed the consent agreement with the PIC. He did not know at the time that the hiring manager did not notify the PIC. Mr. Hendrickson further noted that he did not meet the PIC until several months after starting. He ultimately took responsibility for not personally confirming that everything was handled correctly when he first started. Mr. Hendrickson further acknowledged that he missed the 5-day window for the written notification of his change in employment status. With respect to the name of his employer, Mr. Hendrickson clarified that he discovered after several weeks of employment at Hims Pharmacy that it was licensed with the board under the name Apostrophe Pharmacy, and that he was told that Apostrophe Pharmacy was purchased by Hims a couple of years prior. As his hiring and onboarding paperwork did not contain any mention of Apostrophe Pharmacy, he felt that listing his employer as Hims Pharmacy was the most accurate description. Mr. Hendrickson's complete response is included in the board's files for review and consideration. This matter is before the board for discussion, consideration, and possible action regarding the facts of this complaint.
Thanks, Ms. Brown. Mr. Hendrickson, would you like to ask the board before we proceed with questions for you?
No, I mean, I feel like my response was pretty, had all the information that I wanted to provide, so happy to answer anything further beyond that.
Thank you. Board members, any questions, discussion?
I wonder, so it's proven that he violated the consent agreement. So, but I mean, I don't know, I can't remember what previously have we done on those cases.
I believe we've done a fine for something like this. It's like a failure to notify. It's not like he didn't do something with the monitoring program or whatever, but I believe we've done a fine.
And we keep the consent agreement the same. It's just like fine that way we did previously. Okay. I am good with that. I don't know if we have standard for this, like 250, I believe so. So, yeah, so I move, unless somebody else has any other idea, but I moved for 250 fine to fail to report to the board about his employment and to his BIC.
Second.
And this would be a consent agreement for disciplinary C, civil penalty or non-disciplinary?
It is My understanding is non-disciplinary, and that's my motion as well, non-disciplinary.
I think we might, staff, correct me if I'm wrong, but I think we might have done disciplinary since it's a violation of order in the past, or is it non-disciplinary?
The past two cases have been non-disciplinary.
Okay.
I'll amend my second to conform to that.
Yeah, it's non-disciplinary. I just like to mention, just because there is not like probation, like something, because we have done disciplinary before, but similar cases was non-disciplinary, that's why, so.
I have a motion and a second. Any discussion? All those in favor? Aye. Any opposed? Hearing none, motion carries. Next, we will go to items 9C and 18A, which is for Safe Chain Solutions LLC. These two items are related. We have the open complaint, and then we also have the renewal application. Is anyone present from Safe Chain?
Yes, Dakota Flowers.
Thank you, Ms. Flowers. What is your role with Safe Chain?
I am the current compliance manager, and I also have my Amanda Biggert, who is the COO at this time. Hello.
Thank you. Ms. Mitchell, if you could give us a summary of what we're looking at here.
Certainly. Safe Chain Solutions LLC DBA SC Wholesale was first permitted as a full-service wholesaler on May 8th, 2019. The business applied for renewal of their permit on November 11th, 2024. On the renewal application, the permit holder disclosed that the owners of Safe Chain Solutions were recently indicted in the U.S. District Court for the Southern District of Florida on charges related to counterfeit HIV drugs. The board considered the renewal application at its meeting of April 16th, 2025. After review and discussion, the board voted to offer the applicant an interim consent agreement for voluntary suspension of permit. Staff offered the ICA to the applicant on May 22nd, 2025, but did not receive a response. When the board considered the renewal application for Safe Chain Solutions, it was disclosed that the company had a sister facility, also called Safe Chain Solutions, that was affected by the indictment. It was also disclosed that the sister facility had been disciplined by the Nevada and Maryland Boards of Pharmacy. The Nevada Board of Pharmacy revoked the business's permit but stayed the revocation and placed the permit on probation for 3 years. The terms of probation included a $5,000 fine, $3,584.10 in fees, and an inspection at the permit holder's expense. The discipline was based on the business selling and distributing counterfeit drugs purportedly manufactured by Gilead Sciences, Inc. for the treatment of HIV-1 patients and transmitting falsified transaction records for each bottle of counterfeit drugs that fraudulently represented that the drugs could be traced back through the supply chain to an authentic sale from Gilead. The final consent order issued by the Maryland Board of Pharmacy reprimanded the business, required them to pay a fine of $100,000, required them to make a charitable contribution in the amount of $100,000, and required them to engage the service of LSpedia to facilitate compliance with DSCSA requirements. The discipline was based on the business purchasing HIV medications from an unlicensed distributor and selling them to a distributor located in California. On October 10th, 2025, staff received an email from the permit holder indicating that they would be closing the business at both locations.
Thank you, Ms. Mitchell. Ms. Flowers, would you like to address the board before we proceed with questions?
Just what she said, we are planning to close by the end of this month, actually next week.
And have you submitted those notifications?
Yes, ma'am.
Yes, we received them yesterday.
Okay, all of them are in good order?
They are, yes.
Okay. Thoughts, discussion?
I think we clearly need discipline on both these permit holders, even though that they are no longer continuing business. So I think we need some mechanism to be able to do that. Is that a denial for, 18A? And I don't know what the next step would be here.
Are they withdrawing their application?
Flowers, are you withdrawing? Ms. Flowers, are you withdrawing the application?
For the Utah facility, I think it was still in renewal, depending on, I think we extended the expiration date to, I believe, today or tomorrow. So we are withdrawing that one and non-renewing our Maryland facility. And currently, the court case is still pending. They have not made any traction, even though it started in September. And I guess they're estimating hopefully by the end of this month or at least the end of November.
Would you consent to the denial of your one renewal application and consent to the voluntary surrender of the other permit?
Yes, ma'am.
How's everybody feel about that?
I just have a question in that circumstance. What would be the process if the pharmacy attempted to reapply? I guess is my question. Is there any safeguard or just as a typical application at that point in the future?
So they could submit a new application in the future after 2 years. And at that time, they would be expected to disclose the outcome of the criminal matter, how has it been remedied, if there's new ownership, et cetera.
Okay, that satisfies my concern.
And they're considered disciplined too, right? So it's reportable.
That's correct.
Okay.
Just for clarity, Ms. Mitchell, do we have any evidence that counterfeit HIV drugs were shipped into Arizona and any Arizonans impacted by these firms, bad conduct?
I believe the board asked in April about that, and I don't believe we received an answer.
We only had one Arizona customer that purchased HIV products. And from my understanding, we never received a complaint, and none of the affected lots, I will say, deemed by Gilead were sent into Arizona.
Thank you, Ms. Flowers.
Absolutely.
I feel good about that. So Ms. Galvin, the motion would look like, what?
I believe with respect to 18C and
A.
Oh,
18A.
sorry, 18A and 9C, it would be to offer a consent agreement for the denial of the renewal application and a consent agreement for the voluntary surrender of the existing permit. And we would need a roll call.
And that would be for a 2-year time period if should we put a time period in there about surrender?
Yeah, statute says that they cannot cannot reapply for 2 years. And the board can make that a firm deadline or a firm bar by including that in your motion.
They would still likely be asked to appear if they were to reapply, right? For the board to make a decision.
I would
right?
expect that, yes.
Do I have a motion?
I'll move to denial the one application and voluntary surrender of the other, both under consent agreement with return in 2 years, which is the standard. Assuming they want to reapply.
Do I have a second?
Second.
Actually, because these are disciplinary matters, we need a roll call.
Go ahead, Dr. Gandhi.
Thank you, Mr. Chair. Mr. Braswell. Mr. Thorwald.
Aye.
Ms. Browning. Ms. Davis.
Aye.
Ms. Wamsley.
Aye.
Ms. Park.
Aye.
Mr. Hogan.
Aye.
Mr. Al-Nassif.
Aye.
Mr. Anderson.
Aye.
Ayes have it with 2 absent, Madam Chair.
Thank you for being present. That will take us to
Thank you.
10A, Vista Specialty Hospital. Anyone present from Vista Specialty Hospital? Good morning, welcome. If you can please unmute the microphone and introduce yourselves.
Good morning. My name's Sean Saleh, pharmacy, Director of Pharmacy at Vista Specialty Hospital. This is our CEO, Richie Burdell.
Hello, everyone. My name is Richie Burdell, and I'm the CEO for Vista Specialty Hospital.
Welcome, thank you. Shrug, if you want to give us a summary, please.
Hi, I'm Chirag Patel, Compliance Officer with the Arizona State Board of Pharmacy. So Vista Specialty Hospital of Tucson Pharmacy is a 34-bed hospital who has applied for a resident hospital pharmacy permit, and during substantive permit review, it was discovered that the current space of 286 square feet of pharmacy space does not meet the R4-23-655 requirements of 500 square feet required for a hospital pharmacy. The hospital pharmacy has been in operation since about March of 2015 and is currently going through a change of ownership with this permit application. This application is in front of the board for your consideration due to not meeting the square footage requirements. A deviation request to deviate from Rule R4-23-655 has been provided to board staff and included in the packet. They do meet the requirements of the sterile compounding area of 100 square feet or more.
You've been to this pharmacy?
I have not. Officer Truman Leong was a previous inspecting compliance officer. And
Are there any concerns based on your observations?
No, based on my observations, there were no other concerns.
Okay.
And I believe it's been since 2015 the same square footage. So I mean, I'm just totally fine with that. I mean, I just
Happy to give you the opportunity to speak if
Yeah.
there's anything you'd like to add to the discussion, but I think we're moving on.
Yeah, just to add to that, I've worked there a little over 2 years, and the space on a typical day, we have maybe 2 pharmacists, 1 technician. Currently, I have a second API student as well in the space, and we operate no issues, no
Just
no
fine.
bumping of elbows or anything.
Yeah. So unless anyone have any discussion, I move to approve the deviation.
Second.
Permit. Yeah.
I have a motion and a second. Any discussion? All those in favor? Aye. Any opposed? Hearing none, motion carries. Thank you for being here.
Thank you very much.
Thank you.
Item 10B, Prescription Lab Compounding Pharmacy. Is anyone present from Prescription Lab?
Yes, Brad Fryer present.
Good
And
morning.
Brandon Chaston's present.
I'm sorry, what was that again?
Brandon Chaston's present.
And what are your respective positions?
We are both co-owners.
Okay, thank you. I see we have B with us. B, if you could give us a summary, please.
Yes, good morning. I'm Beatrice Fuentes, Compliance Officer, State Board of Pharmacy. Prescription Lab Compounding Pharmacy submitted an application for a pharmacy permit reflecting a change in ownership. During the substantive review, it was identified that one of the owners is a listed practitioner, neuropathic physician. When asked whether he intends to write a prescription authored by himself to be filled at Prescription Lab Compounding Pharmacy, the practitioner stated that he does not intend to do so unless he receives written authorization from the board. The permit application is in front of the board because of ARS 32-1930B. The board shall deny or revoke a pharmacy permit if a medical practitioner receives a compensation, either directly or indirectly.
Thank you, Ms. Fuentes. Would either of you like to address the board before we proceed with questions?
I don't have anything, Brandon.
No, I don't think so.
Okay. Ms. Fuentes, we do have an assigned attestation that says that they are not going to send any prescriptions to the pharmacy, correct?
I got an email stating that they would not unless they got authorized by the board,
No, they should not.
but they did not sign an attestation.
Okay. That's our typical practice.
So
Makes sense. So is that a document that we need to sign and execute? I was not aware.
Yeah, so the board will not authorize them to allow them to prescribe to the pharmacy. We never done that, right? So they have to sign that they're not going to refer patient or send prescriptions to their pharmacy.
Yeah, I think we're more than happy to sign that.
Mr. Anderson, did you have a comment?
I did. Just the language in the statute. The board shall deny or revoke a pharmacy permit if a medical practitioner receives compensation either directly or indirectly. And then it further, comma, from a pharmacy as a result of the practitioner's prescription orders. Is it only from the prescription orders, or if he's getting other revenue from that pharmacy that's not from his prescription orders, shall we deny?
That statute has always been interpreted to apply only to the physician owner and the prescriptions that he or she may write that go to that pharmacy.
All right, thank you.
You could approve the change of ownership contingent upon receipt of the attestation.
I'll make that motion. Second.
I have a motion and a second. Any discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries.
Madam
Thank
Chair,
you.
Thank you very much.
You.
Can we circle back to 19C and 18A? In an event they don't sign the consent agreement, can we have direction to move it to hearing?
Do you mean 9C and 18A?
I'm sorry, 9C and 18A, yeah.
So you're looking for a motion to amend the consent agreements to move to hearing if not signed?
Correct.
Since that was my motion, I'll go ahead and add that to my motion.
So you need to recall again, or?
Do I have a second?
Second.
Do we need roll call for that part of it?
You do not.
All those in favor?
Aye.
Any opposed? Hearing none, motion carries. That takes us to 11B, Houston RX. Is anyone present from Houston RX?
Yes, my name is Bartu Wilson. I'm turning my camera on now,
Thank you.
so you can see me. I'm the pharmacist in charge at Houston RX. I also have the CFO, Will Utree, here as well in the meeting too.
Thank you. I see Mr. Castaneda's here. If you could give us a brief summary for Houston RX. I'm sorry, I skipped 11A. We'll go back to that one, but thank you.
Sure. I'm Ben Castaneda, Compliance Officer, Arizona State Board of Pharmacy. This is a non-resident pharmacy application. Houston RX applied for a pharmacy permit on June 16th, 2025. There's currently an open permit at the same address under BioHealth RX. During the substantive review, the applicant stated that the company underwent an ownership change back in February of 2025. Although there was non-disclosed discipline found on the previous owner, the pharmacist in charge stated there's no previous relationship between the two owners. In addition, the pharmacist in charge stated that they were not operating under a business management agreement with the previous ownership, nor had they shipped any product into Arizona.
Thank you, Mr. Castaneda. Someone from Houston RX want to add anything before we proceed with questions?
Yeah, so it was Houston RX was bought out, bought BioHealth out. When I took over as pharmacist in charge, wrote a statement, the form to Arizona Board of Health, letting them know that it's changing pharmacists in charge. And we was waiting until we got our Houston RX license to apply there. So the BioHealth was supposed to be dissolved.
My only question for you is, what's the relationship with the prior owners? Are they involved at all in your operations? I understand that they're not an owner anymore, but are they involved at all in the operations of the pharmacy anymore?
No, ma'am.
Thank you.
So we're dealing with the failure to report change of ownership, essentially.
I did not fail.
Board members, yes, the reason this application is in front of you today is because of a failure to notify the board 14 days in advance of the change of ownership. The ownership change occurred in February 25 and they applied in June 25.
Can I make a statement? So I wasn't the pharmacist in charge at that time. I didn't come on board until later on, and trying to make sure that everything is in line with compliance with you guys at Arizona and us here at in Texas.
Thank you for that.
No problem.
So what's the typical,
Fine.
yeah,
Fine for failure. to
Yeah, that's my
Notify and then approve the permit once received.
That's my question. I'd like to make a motion to apply a civil fine of $250 non-disciplinary for failure to report change of ownership in a timely fashion.
Second.
And approve the permit upon payment.
Yes.
Second.
Thank you.
Motion and a second. All those in favor?
Aye.
Aye. Any
Um,
opposed? Hearing none, motion carries. Thank you for being present.
No problem. When should I receive information so I can pay the fine?
It'll be a couple days probably since we'll be in the meeting, but the staff will reach out to you.
All right, thank you, ma'am.
Thank you.
All right,
All
bye.
If I can just make a note, on all these applicants that are here, whether it's businesses or individuals, if they can wait for staff to contact them, that would be helpful. I think last meeting, these individuals just jumped on the phone and inundated staff prior to them prepared to have a.
Well, don't we want them to be in compliance? Just kidding.
We
But
do,
yes,
we do.
noted. I mean, pretty much the whole staff is in this room, so they're not able to answer the phone call
Absolutely.
until they finish here. All right, we'll go back to 11A. I jumped the gun on my checking off things on my list here. 11A is all family pharmacy. I can't talk. Is anyone present from all family?
Yes, yes. Thomas Kunzler.
I'm sorry, what was your name?
Thomas Kunzler,
And what is your role?
owner.
Welcome, Mr. Kunzler. I see we have Mr.
Thank you.
Hyber. Mr. Hyber, if you could give us a summary, please.
I'd be happy to. Steve Hyber, Compliance Officer. Okay, this is a non-resident permit application for a pharmacy, all-family pharmacy located in Boca Raton, Florida. On March 12th, 2025, a new permit application was received from All Family Pharmacy. The facility on the application was located at 3350 Northwest 2nd Avenue, Suite A2 in Boca Raton, Florida. During the substantive review, a previous permit for All Family Pharmacy located at 3350 Northwest 2nd Avenue, so the same street address, but a different suite, suite number A34 was found. The permit was issued, and this is the one we found. The permit was issued October 18th, 2021, and closed for non-renewal on 10/31/2024. Additional information was obtained from the applicant, indicating the pharmacy had undergone a change of ownership back in November of 2022, as well as a relocation from Suite A34 to Suite A2 in March of 2025, late March of 25. The reviewing CO requested and received information of prescriptions filled and delivered to residents in our state, Arizona. The report provided by the pharmacy listed a total of 22 prescriptions, which were delivered into our state after the pharmacy had changed ownership and prior to the permit expiring. No prescriptions were delivered by the pharmacy after the permit expired. And no prescriptions have been delivered from the current pharmacy into Arizona. And that's it. Thank you.
Thank you, Mr. Hyber. Would you like to address the board? on behalf of All Pharmacy. All Family Pharmacy.
Yes. So we made a ownership change back in 2022. Basically, I purchased the pharmacy from my mother. It was a family matter. I didn't have the oversight to make that change with the permit. We allowed all the permits to lapse and then apply for new ones at a new location when we moved the pharmacy to a newer location.
Board members' questions?
So, Mr. Hyber, I do have some concerns. The URL was provided in the summary as well, or in the board book to this pharmacy, and I did go to their website. And their website does promote a number of off-label or unproven uses of drug therapies, bulk emergency kits with antibiotics and steroids, and fenbendazole not approved for humans, compounded ivermectin mebendazole capsules marketed for cancer. And they also have a process where it seems like they may bypass the patient-provider pharmacist relationship by relying on self-submitted forms to generate prescriptions. So I'm very concerned about that piece and Arizonans receiving medication from this pharmacy. Did you do any sort of deeper dive in your substantive review about those concerns?
This information came to us just prior to the board meeting. So you notice how the website has been inserted before the actual summary. That's usually an indicator of some information that we obtained prior to us being able to dig down further. We did want to make it aware to the board members because there is some, it seems to be a little bit different than some of the other websites that leverage telemedicine. It seems almost, if you look at it quickly, and we probably would want to dig in deeper, that if you want drug A, it's more like an Amazon website. You just put your order in for drug A, and the pharmacy will take care of all the rest. And whether that involves obtaining a prescription from a licensed practitioner or not, we haven't had time to investigate that.
Mr. Kunzler, can you comment on what that process looks like with your website?
Yes. So the off-label use, obviously, we don't promote the off-label use on the website. We do promote a calculator that allows a patient to take a medication that's weight-based, so they understand the dosage that's safe and effective for them. But when it comes to medical oversight, as well as prescriptions provided by licensed physicians, we do have contracted physicians that we work with, not on the pharmacy level. We actually sold off our website to a telemedicine platform. It's called All Family Health now. So we actually transitioned everything away into solely telemedicine, the realm there. Now on the pharmacy level, we do compound many drugs. One of them is ivermectin or mebendazole as a combination. And we do offer certain emergency kits. But again, these are prescription items that are required.
Okay, so can you elaborate a little bit more about that? So if I'm understanding you correctly, the patient would request some sort of prescription, then they are referred to a provider for a telemedicine visit, and then they would prescribe the medication based on the outcome of that telemedicine visit. Is that correct?
Yes.
Okay.
My only thing about calculating those, I don't like that.
And if I could just allude on the fenbendazole, at the pharmacy level, we don't sell fenbendazole. However, we work with a third-party supplier. It's a vitamin company that supplies it as a research grade only supplement. But again, at the pharmacy level, we don't have animal medications here. We're not a veterinarian pharmacy.
I have too many concerns to want to endorse allowing this pharmacy to provide medications to Arizonans. I think we deserve better here, and I think we need more time to review this pharmacy before making a decision. There's too much information that is unknown at this moment.
What other information would you like?
I need more information on this physician patient relationship, this telehealth. Ms. Walmsley, I mean, you talked him through the correct process. I want to hear specifically and see specifically what's happening, because what you walked him through sounds correct, but that's not what I saw on that website.
I would like to know the financial relationships between the physician and themselves as far as authorizing the prescriptions.
Remind me, this facility has an active permit?
No, they're applying for a first-time permit as far as we're aware of.
Okay. So I'm hearing that a good option here, Ms. Galvin, would be to table this and ask Mr. Hyber to come back with some additional information at a future meeting.
That's what I'm hearing, yes.
So moved on my part. Do I have a second?
Second.
All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Let's do 11C and then we'll take a break. Oops, come on.
I mean,
11C is Victory Medical Center. Is anyone present from Victory Medical Center? Max, do you want to go ahead with the summary here?
Sure.
Thanks.
Good morning, Board of Pharmacy. Max Jacobson, Compliance Officer. Victory Medical Center Pharmacy applied for a non-resident pharmacy permit with this board. During substantive review, it was discovered that the facility had undergone a change of ownership without notifying the Board of Pharmacy, without notifying this board. It was determined that no products have been shipped into Arizona during that time.
So we have a late chow with everything else in order, it looks like.
That's correct, just the late chow.
Okay.
So there's no application?
There is an application. This is an application.
Okay, so I'll make a motion to do a non-disciplinary civil penalty of $250 because they didn't apply for the chow in the proper time frame and approve the application.
Upon paying. I second.
Motion and a second. All those in favor?
Aye.
Any opposed? Hearing none, motion carries. We'll take a brief recess, come back at 9:45.
you
All right, welcome back, everyone. We will go to item 13A, which is Dutch Ophthalmic USA. Is anyone present from Dutch Ophthalmic?
Hang on. Hi, this is Mercedes Conley. I'm a QA specialist at Dutch Ophthalmic.
Good morning. I'm having a hard time hearing you.
Apologies, I'll make it louder.
That's better. Thank you.
My name is Mercedes Conley. I'm a QA specialist at Dutch Ophthalmic, based in Exeter, New Hampshire.
Welcome. Thank you. I see we have Mr. Wagner. If you could provide us a summary, please.
Good morning, board members. Dennis Wagner, Compliance Officer with the Board of Pharmacy. This was a review of an application for a non-resident wholesale permit due to a change of ownership. The applicant disclosed a discipline for the company back from 2018. This would actually reflect on the previous ownership group. The discipline was a $2,500 fine that was not reported on that company's 2019 renewal.
Thank you. Ms. Conley, would you like to make any statements before we proceed with questions for you?
Yes, I've just been here the last year, and preliminary research led us to the fact that we had that fine on our records, and we've been disclosing it ever since. I can't speak to what happened in 2019, unfortunately, but we wanted to be fully transparent by just, letting you know about this now. In the meantime, our change in ownership application has to be postponed because the share transfer was supposed to take place November 1st. It has not taken place, and we don't know when it's going to take place.
So from a time standpoint, staff, what do we need to do here? Because will the application time out? Should we ask them to withdraw and reapply?
Your second option is probably the best option, Madam Chair.
Ms. Conley, would you be willing to withdraw your application and reapply once that change of ownership goes through?
Absolutely, yes.
Do we need a motion for that, Ms. Galvin?
The motion would be to allow her to withdraw.
So moved. Do I have a second? Any discussion? All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Thank you, Ms. Conley, for being present.
Thank you.
We'll go to item 17A, GXO Logistics Supply Chain. Is anyone present from GXO?
Yes. My name is Charles Waddleworth. I'm trying to get my camera to turn on. I'm not sure if you can see me.
No, we can't, but thank you. What's your role with the company?
I'm in-house counsel.
Is that appropriate? It's a non-resident.
Yes. And if he is testifying or providing factual information only and not advocating on a legal basis.
Which is my which is my intent. There is a site, the designated representative for the site in Mississippi, from which the site that we're trying to get licensed. It was supposed to join this call, but I don't know if she was on earlier. I'm not sure.
I am on the call.
Oh, there we go. Hello, Stephanie.
Hi.
Good morning. If you could please introduce yourself.
Stephanie Sherman, Senior Operations Manager for GXO Logistics in South Haven, Mississippi.
Thank you. Mr. Hyber, if you could provide us a review of the application.
I'd be happy to, board members. Steve Hyber, Compliance Officer. This is a non-resident 3PL permit application for GXO Logistics Supply Chain Incorporated, located in South Haven, Mississippi. On November 19th of this past year, the board received an application for a non-resident 3PL permit from GXO, located at 2400 State Line Road in South Haven, Mississippi. The initial application was incomplete, and after receiving additional information, the application was assigned to myself for substantive review. And the clock started ticking. That was in June, so you can see there's a little bit of a time frame delay there already. During the initial application review process, GXO stated the facility had not yet obtained any customers, but later informed us that they did have an account for Intuitive Surgical. And that was the Intuitive Surgical that currently has a permit that will be coming up for next month for the board. That GXO disclosed previous discipline involving the distribution of product by another GXO facility into Alabama without a permit. Based upon the prior discipline for distribution of product without the permit, I requested a report for distribution out of that South Haven, Mississippi facility into Arizona. On July 14th of this year, a report of products owned by Intuitive Surgical and distributed into Arizona at the direction of Intuitive Surgical was received. After review, the report indicated a total of 51,364 prescription-only DME products were distributed by the applicant facility into Arizona. And that was for the time period of 11/1/24 to June 1 of this year, 2025.
Thank you, Mr. Hyper. Do either of you from GXO want to address the board before we proceed with questions?
No, ma'am.
No.
Board members, questions or discussion?
Since they distributed over 50,000 RX-only products without a permit, could we ask board staff to work out a non-disciplinary fine to settle this unpermitted activity? And once that's figured out and paid, then approve the permit?
I think it would either be a consent agreement, a negotiated consent agreement, or the standard fine if it's non-disciplinary.
May I explain what it is we actually distribute?
Sure, go ahead.
These are the sterile drapes that go over the Da Vinci operating machine. This isn't the labels do have RX on them, but they aren't sent to any consumer. These all go to hospitals. There's nothing over the counter. There's anything like that we distribute.
Mr. Harper, we still classify those as prescription-only devices that they would need a permit to ship into Arizona, right?
They would, and I think therein lies the problem why we're sitting here today. I think they didn't have an understanding as to what products and devices. They're probably just thinking like a lot of distributors do. They think drugs, RX drugs. But in this case, there was quite a substantial number, and you have the documentation in your board materials. And I think also I found that they also distributed not just to Intuitive, but to other hospitals as the testifier testified. So
Thank you, Mr. Hyber. Was that a start of a motion?
Yeah, I'd like to make a motion to direct board staff to communicate with this licensee and agree on a fine, non-disciplinary, this would be disciplinary fine for unpermitted activity. And once that is agreed and paid, then to approve the permit.
Do I have a second?
Second.
Any discussion? Dr. Gandhi, roll call since this may be discipline.
Mr. Braswell. Mr. Thorwald.
Aye.
Ms. Browning. Ms. Davis.
Aye.
Ms. Walmsley.
Aye.
Ms. Spark.
Aye.
Mr. Hogan.
Aye.
Mr. Al-Nassif.
Aye.
Mr. Anderson.
Aye.
Ayes have it with 2 absence, Madam Chair.
Thank you for being present.
Thank you.
We'll move to item 18B, Desiree Boone.
Madam Chair, if the board would like to go back to 20B and 9A, I think we're ready.
They're present.
Yes.
Okay, we'll go to 20B, which is Michael Constant, I believe, and I am recused from that.
Thank you, Madam Chair. This is tab number 20B. This is board case number 25-0316. Subject is Michael Constant, pharmacist. Board staff, Ms. Brown is present. And who do we have on the line?
This is attorney Breton Barber for Michael Constant. Michael, you want to mute yourself?
Yes, I'm here as well.
Thank you. Ms. Brown, would you like to provide a brief summary for the board, please?
Certainly. Jenica Brown, Executive Assistant to the Deputy Director. Michael Constant was issued an Arizona pharmacist license on August 15th, 2023. His license expires on October 31st, 2026. It is currently suspended. The board office received a complaint on June 9th, 2025 regarding Mr. Constant. The complainant alleged that she became involved in a sexual relationship with him while she was a patient of Safeway Pharmacy, and that he was the pharmacist involved in the provision of pharmacy services to her. The complaint included the following allegations. Mr. Constant wrote his phone number on the complainant's medication. He sexually pursued the complainant and engaged in sexual acts with the complainant after hours at the Sonora Quest at his place of employment. He sexually assaulted and strangled the complainant. He was stalking the complainant outside of her work after she told him to leave her alone. And the complainant indicated that she was scared for her life and stated that the sheer abuse of power Mr. Constant wielded over her when vulnerable is gross negligence. Staff received copies of screenshots and further evidence to support the allegations. The documents are contained within the board's files for review and consideration. Staff sent Safeway a subpoena for records to further investigate. Safeway responded indicating that an internal investigation was also taking place. Staff subsequently received a notice of termination from Safeway stating that Mr. Constant was terminated on or about June 13th, 2025 for engaging in a relationship with a pharmacy patient, providing the patient with medication via means of a fraudulent prescription and over-the-counter medication from the pharmacy inventory, and issuing fraudulent prescriptions for himself. Staff subsequently sent a second subpoena for records related to his termination. The records received from Safeway are included in the board's files for review and consideration. On July 3rd, 2025, staff sent Mr. Constant a notice of complaint and requested a response to the allegations, as well as the allegations outlined in Safeway's notice of termination. On the same day, staff received a notice of representation from his attorney, Bretton Barber. In his response to the complaint and further questions from staff, Mr. Constant acknowledged the following. Because of his access to her prescription information, he was aware of the complainant's mental health diagnoses and related challenges. He and the complainant engaged in a sexual encounter in a room adjacent to the pharmacy after the pharmacy was closed. After this encounter, he turned to the pharmacy and retrieved a 25 milligram tablet of diphenhydramine to give to the complainant to treat an allergic reaction to an injection she received earlier that day. On more than one occasion, Mr. Constant would sign out prescriptions that he had filled for the complainant and brought them to her at her residence. This included a flu and COVID vaccine. He removed these vaccines from the pharmacy and administered them to the complainant at her residence. He acknowledged using the prescribing privileges of his cousin, a physician in Louisiana, to write prescriptions for himself, another for an elderly pharmacy patient, and one prescription for the complainant. He also acknowledged that on one occasion he gave a pharmacy technician a single tablet of Zofran without a valid prescription. Mr. Constant indicated that there were instances in which he found a pharmacy customer to be cute and nice, and he would view their pharmacy patient profiles. He acknowledged to the complainant that he had previously dated 2 other pharmacy patients. And after Mr. Constant and the complainant ended their relationship, he admitted to conditions and experiences that may impair his ability to safely practice pharmacy. Following this matter, the board will consider a complaint against a technician regarding fraudulent prescriptions that Mr. Constant was allegedly involved in. It is important to note that Mr. Constant was asked during the investigation of this complaint that is being considered right now to provide the name of every person he has written a fraudulent prescription for. Mr. Constant did not mention his involvement in the conduct that led to the complaint against the technician. He only admitted to providing her a single tablet of Zofran without a prescription. You will hear in the next complaint that it was determined that he did write a fraudulent prescription for the technician involved and therefore was not forthcoming with staff. Mr. Constant entered into an interim consent agreement for interim suspension of license and professional assessment for fitness for duty on August 1st, 2025. The board considered and approved his interim consent agreement during the August 2025 board meeting. It was executed on August 25th, 2025. The agreement placed Mr. Constant's license on a suspended status until further order of the board, but no less than 60 days, and required him to undergo an evaluation. He completed the board-ordered evaluation with a board-approved provider on August 13th, 2025. The results of the evaluation are contained in the board's files for review and consideration. This matter is before the board for discussion, consideration, and possible action regarding the facts of this complaint, the underlying conduct, the results of Mr. Constant's evaluation, and the suspended status of his license.
Thank you, Ms. Brown. Mr. Barber, would you like to make a preliminary statement before we move into questions?
No, I want to just provide the opportunity for my client to answer any questions that you may have of him. Thank you.
Thank you, Mr. Barber. Board members will open the floor for questions and discussion.
I don't really have any questions. The narrative is pretty clear. The provider thinks that Mr. Constant doesn't have the psychological or cognitive ability to function safely.
If we are going to speak specifically about the evaluation, then we can go into executive session.
If I move to accept the recommendations of the evaluator,
then that's fine. Yes, thanks.
Before we perhaps go to that point, can we speak about the fraudulent prescriptions first before we move into the conduct with bad intent?
Right. So I see at least 2, maybe more. pathways here. The first is the ethics that I think the board evaluator addressed, but there's the fraudulent prescription that is not addressed in this evaluation as far as I can see.
Correct.
And I think we need to discuss each of those.
So, Mr. Constant, can you please tell us about your relationship with this provider in Louisiana and your relationship to issue prescriptions on his behalf?
Certainly. So yes, he is an older cousin of mine who has been in a practicing physician in Louisiana for quite some time. And so the relation with him is that in past experiences, if it was something that was certainly non-controlled and certainly nothing that's any sort of abuse, that he was okay with me utilizing his credentials to provide those kinds of services. And so I would attempt to not do that too often, obviously. And unfortunately, in hindsight, I'm aware that that was not appropriate at this time.
So he is aware that you were using his credentials to issue prescriptions in the state of Arizona.
Not these specific, not these specific prescriptions, but again, it's kind of was always like an unspoken agreement between him and I that I could do that under his name.
It's just my head spinning.
So in this scenario, Ms. Galvin, I think we have a duty to make notice to the Louisiana Medical Board that this provider in Louisiana is entering into this relationship with his cousin to issue prescriptions that they're not legally allowed to enter into. And it sounds like this Louisiana physician is aware that his cousin is doing this.
I'm sorry.
What is the mechanism for us to do that?
You would just direct staff to make that referral to Louisiana.
Does that need to be in a motion?
Yes, please.
So before we continue, I make this motion. So I move to direct our staff to reach out to Louisiana Medical Board to address the issue that took place in Arizona here.
Second.
All right, we have a motion on the floor to direct staff to contact the Louisiana Medical Board regarding this matter. We've got a first and a second. Any further discussion? All in favor, please say aye. Aye. Any opposed? All right, motion carries. Specifically, Mr. Constant, Ms. Brown had mentioned this next case with the technician that you did not address or come forward with and acknowledge those prescriptions that were issued. Do you have any further comments about that?
Yes. So at the time where I was initially asked, I genuinely could not recall those situations at the time. So it's not that I was trying to withhold that information. It was more so that at the time I couldn't recall it. I do apologize.
So you are admitting to that conduct today?
Yes, sir.
So I mentioned the two pathways that I saw, the ethics and the fraudulent prescriptions. And I think that the board's determination today could be concurrent in the sense that, well, I can't speak to I don't know if I could speak to the recommendation in the.
I would recommend that we do that in executive session because it's very specific to what he found.
Nonetheless, if the board is going to take an action relative to, let's say, a suspension, for example, I think that would resolve both of these pathways for me. So the question in my mind is, in terms of the fraudulent prescription, what is a typical, I mean, do we have like a standard in terms of, for example, we wanted to consider suspension. Would it be a suspension of a year? Is it really just totally up to the board?
I believe that we have revoked license previously for this, and depend on how big it is, right? Like how many prescriptions and the situation. But we have revoked licenses as far as I remember for this, and some cases we did suspension. So, but to me, this is like outrageous activities here. So that's why I like to move to executive session to discuss more options there.
All right, we have a motion to move to executive session. Do we have a second?
Second.
For,
If that would be for legal advice and,
It is for legal advice and talk about some HIPAA information. If there's-
okay, would you like to discuss the confidential health information first and invite Mr. Barber and Mr. Constant into executive session?
Yes, that would be, yeah, that would be part
thank
of my motion, yes.
Second.
all in favor, please say aye.
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 All right, any opposed? Motion carries. We will move to executive session. All right, we're back from executive session. Board members, any additional discussion, questions? And Mr. Barber and Mr. Constant, are you still on the line?
Yes, sir.
Okay. And Mr. Barber, I don't see you.
Yes, I'm here.
Okay. Just curious question. You guys are local, correct?
Yes, sir.
Yes, that's correct.
Is there a reason why you're not in the boardroom with us today?
I had another obligation at 9:15 that I had to appear at.
Okay, thank you. There's no additional questions. Is somebody considering a motion?
No, I would just like, I'd like to ask Michael if he wants before, like, I have a motion, I'm thinking about a motion, but I would like to give him a opportunity to address the board before I move or we move. There's anything you'd like to share with us and with public here in the room before?
Sure.
Yeah.
I just want to say that I certainly am sorry for all things that have occurred at this point in time. I've certainly spent many, many hours and days reflecting on this situation, and I've made sure to remind myself of why I even entered this profession in the first place, and that is to protect patients and provide them the best possible care as a pharmacist. And so that is something that I've spent more than half of my life dedicated to, and I, if allowed, would be more than honored to continue to do that to the best of my ability. Is something that I have tools in place now to continue to do that as far as with regards to mental health and things like that. And so I hope that it is within the board's, consideration that I can return to some capacity and allow myself to continue to prove that I can be a really good pharmacist.
Thank you very much. Then I'm just like looking at the case here, like there is many concerns, and he admitted it already. It's not only limited to fraudulent prescriptions, to unprofessional conduct and HIPAA violations here. So, and I believe I would, to protect public and protect him as well, you know what I mean, like, and public specifically, I would like to move for hearing for revocation based on the unprofessional conduct and HIPAA violations and fraudulent prescriptions. And I'm sorry, and also allow him to surrender his license voluntarily.
Would Mr. Al-Nassif, would your motion include the findings of the evaluator?
Oh, I'm sorry, could you elaborate here?
Your basis to move to formal hearing for revocation, would the factual basis, in addition to the fraudulent prescriptions, the HIPAA violations, also include the findings of the evaluator?
Yes.
And in lieu of the hearing, you would accept a voluntary?
We accept the voluntarily surrendering.
For how long would you?
I mean, our standard for 2 years. I'm okay with 2 years. And of course, when he appears before the board, if he want to reapply again, he needs to show like action has been taken care of and prove to the board that he's safe to practice pharmacist.
Yeah, only other thought earlier was mentioned about fraudulent prescriptions. That wasn't mentioned in the evaluation. Did you guys want to address that as well through a civil penalty or?
I mean, the fraudulent prescription, that's why I look at it different, right? It's a separate issue than the other unprofessional conduct he was involved with. So do we need to adjust the motion or?
I think your motion is sufficient.
Sufficient, yeah.
Board members, is there a second?
Second.
All right, any further discussion?
I kind of like the idea of a stayed revocation, offering a consent agreement with a stayed revocation that included terms of probation in line with what their evaluator recommended. That way, if he violates any of those terms, his license would be immediately revoked if he agreed to that consent agreement.
I like that too, Ms. Davis.
Is there a period of suspension with that?
Yeah, in line with what the evaluator recommended.
I like that.
Like, we should mean like suspension? What does it mean?
So the evaluator made some recommendations as to suspension versus probation time, that I would, agree with. And then with the stayed revocation, if he violates any of those, then his license would be revoked.
We just revoked somebody's license like this month because of the same activity of fraudulent prescription. I mean, there is two issues here. We have fraudulent prescription, which is absolutely big violations. We trust our pharmacists to be in the pharmacy and follow the rules. We're not talking about here only one problem, like you've seen, like many violations in his practice. So since we have done it for just like not long time ago, and I don't know how many prescriptions he's done. He admitted to 4, who knows, maybe 10, 20, who knows, right?
I think the one differentiator between the most recent one is that those were controlled substances. In that case, and in this case, there's not been evidence presented to this board that they're controlled substances. These are RX-only products, for what that's worth.
So if we, and we're in discussion phase here. So if we proposed a voluntary surrender, I would like to be a little more specific on the recommendations, only in the sense of duration. So 6-month suspension, 1-year probation, with quarterly reports from the employer in terms of the oversight that is suggested in terms of a preceptor type of situation where the pharmacist practice is being overseen by another pharmacist.
So we do have a motion and a second.
We do.
On the floor that moves it to formal hearing for the fraudulent prescriptions, the HIPAA violations, the unprofessional conduct, and alternatively accept a consent agreement for voluntary surrender. Both the consent agreement and a referral to formal hearing would include the findings of the evaluator. So I would suggest that we take a vote on that motion and see where we land, and then
So to be clear, the original motion included the option of voluntary surrender
it
through
did.
consent agreement?
It did.
Oh, very good.
All right.
It was for revocation, correct?
Yeah, yes, a referral to formal hearing for revocation, or alternatively, a consent agreement for voluntary surrender. And we will need a roll call, please.
Any further discussion before we vote? All right, Dr. Gandhi, roll call, please.
Thank you, Mr. Chair. Mr. Braswell. Mr. Thorwald.
Aye.
Ms. Browning. Ms. Davis.
Nay.
Ms. Wamsley's recused. Ms. Park.
Nay.
Mr. Hogan.
Nay.
Mr. Al-Nassif.
Aye.
Mr. Anderson.
Nay.
Motion fails.
All right, Dr. Davis. I think there were multiple colleagues on the board that were in favor of the route that you were going. So if you could try to reframe that.
I'll try to do my best. I propose that we offer a consent agreement for a stayed revocation that includes 6 months of continued suspension of his license with an additional year of probation. The ability to practice must be supervised, and we get quarterly reports from his employer as to the supervision and his conduct.
Would you also consider a friendly amendment of $1,000 civil penalty for each fraudulent prescription that is known or reported thus far as, so $4,000 civil penalty fine to be included in that?
Yes.
Second.
I'm sorry, who seconded it? Does Ms. Davis and Mr. Hogan, does that include that the period of probation is to include following the recommendations of the evaluator?
Yes.
Most definitely.
So let me repeat the motion if I may.
Before you repeat, I just want to clarify. Supervision, is that in-person supervision or through keystrokes, or what kind of supervision would you like?
In person.
Okay,
In-person
because
supervision.
We've had different versions of supervision throughout our lives here, so.
So just I have a question. In case he couldn't find job during his suspension, so there's no supervision. So, I mean, what? So what you gonna do? But you said like gonna be under supervision of pharmacists
So he's gonna need a 6-month period
of supervision, but there's no supervision because there's no job.
If and when he's employed.
Yeah, once the suspension is lifted, and the
Okay,
probation,
6-month suspension, so no employment, and then he will find job and during probation, and if he couldn't find job, so what then?
Then we don't have a report. There's nothing to report.
and typically probation would not start until he is employed in the pharmacy profession.
Okay, so that standard for, okay. It can be added to the,
And would he have to appear before the board to ask to move to probation? Or is it just 6 months period and then?
To lift the suspension and probation?
Yes.
Yes.
Yeah.
And that,
You'll have the opportunity to hear this again in 6 months.
And you would have, a report while he's on probation from the therapist, et cetera, who he will be required to continue seeing. And this, go ahead, I'm sorry. No, go ahead.
so to clarify, his probation will not begin until he is employed. And so he should not seek the lifting of his suspension until he's gained employment.
The suspension can be independently lifted prior to him finding employment. But again, the probationary period, because it is part of a larger order with respect to the practice supervision, et cetera, that would be something that would be in place. But the reports, et cetera, don't start until he finds pharmacy employment. Is there any CE involved?
I think the evaluator recommended some ethics training as well.
So if I may, the motion is that this would be a consent agreement for a stayed revocation that includes a 6-month suspension followed by a year probation. The year probation is to include an in-person practice supervision, and according to the other recommendations, he would not be allowed to practice independently, not work as a PIC or a preceptor. He has a $1,000 civil penalty for each fraudulent prescription for a total of $4,000, as well as following the recommendations of the evaluation. He has to request the lifting of the suspension after 6 months, and he needs to appear before the board at that time, and he would have to request the lifting of the probation at the end of the period. There were also recommendations for ethics training pursuant to the evaluator. Because this is a stayed revocation, If there is any violation of this consent agreement, this stay would be lifted and the license would automatically be revoked.
And I would just add that we requested quarterly reporting from the employer regarding the supervision.
Ms. Galvin, board members, if I may, there will be a matter considered tomorrow that has similar requirements in her probation where quarterly reports are required. There is a provision within her consent agreement that requires her to appear before the board if she does not find employment, which is why you will be hearing from her tomorrow. Is that something that you would like to add into this consent agreement?
Go ahead. You start.
So Dr. Constant would need to come back to us to lift the suspension. I mean, I think that would be an opportunity to talk to him. I don't know if we need anything more, but that's just a thought.
I'd just like to add, I mean, I don't know what 6 months of suspension will help the situation. And he's immunizer, right? So he give immunization to people. Like, I don't know if that's okay for him to go immunize or give injections to people, like, and we have this case before us. So anyway, so I'm sure we're gonna go for a roll call for like to vote for whatever motion, but if we can consider like 1 year suspension, because revocation will be like 2 years, right? But suspension maybe 1 year will help to give him like more time to be like evaluated and be compliant. I'm just like thinking out loud. Or if you can like add to your whoever can make a motion will not be me, if like not allow him to be immunizer.
If he has to be supervised, I would assume that's all the time that he's in the pharmacy.
All right, so we have a first and a second. I don't think we need to recap the motion again, do we, Ms. Galvin? We're good?
I hope not.
You did. All right. Any further discussion before we go for roll call? All right, Dr. Gandhi, we're ready for roll call.
Okay, Mr. Chair. Mr. Thorwald,
Aye.
Ms. Davis,
Aye.
Ms. Park,
Aye.
Mr. Hogan,
Aye.
Mr. Al-Nassif,
Nay.
Mr. Anderson.
Aye.
Ayes have it, 1 nay, 1 recused and 2 absent, Mr. Chair.
Thank you, Dr. Gandhi. Thank you, Mr. Constant. Thank you, Mr. Barber, for being here. Board staff will be in touch with you.
Thank you for your time.
Thank you.
All right. I think we're going to go back to 9A, which is, if I can get this going. 25-0434, Jasmine Alejandro Sotelo Watson. Is Miss Watson present? Good morning, Miss Watson. If you can unmute yourself and introduce yourself.
Good morning. My name is Jasmine Sotelo Watson. I'm a pharmacy technician.
Thank you. Ms. Brown, if you could give us a summary, please.
Certainly. Jenica Brown, Executive Assistant to the Deputy Director. Jasmine Sotelo Watson was issued an Arizona Pharmacy Technician license on April 27th, 2022. Her license expires on October 31st, 2025. It is currently open. On August 6, 2025, board staff received a notice of termination regarding Ms. Sotelo Watson, indicating that she was terminated from employment at Safeway Pharmacy on or about July 28, 2025 for creating fraudulent prescriptions to obtain medication. Ms. Sotelo Watson responded to the complaint and indicated that the statement provided by her previous employer was misleading because it presented the situation as if she alone initiated and carried out these actions. These prescriptions were never her idea, nor something she would have considered independently. The supervising pharmacist instructed her to prepare them and assured her that the process was acceptable. He later signed them under his relative's prescribing credentials. She further stated that at the time she was inexperienced and too trusting of his authority as a licensed professional. She did not understand the full seriousness of what she was being asked to do, and she regrets that she allowed herself to be placed in such a situation. Ms. Sotelo-Watson further clarified the name of the pharmacist referenced in her response as Michael Constant. Ms. Sotelo-Watson also clarified that the medication involved were for birth control, which was obtained 5 times over 5 months, and tretinoin obtained 1 time. She also stated that she is currently employed and working as a pharmacy technician for CVS Pharmacy. According to the information provided by Safeway, the prescription for tretinoin was filled once and the birth control was filled 6 times. According to Safeway, using Jasmine's vaccine consent form for a handwriting comparison, it appeared that the prescription for the tretinoin was written by Jasmine, while the prescription for the birth control matched others written by Michael. This matter is before the board for discussion, consideration, and possible action regarding the facts of this complaint.
Ms. Watson, would you like to address the board before we ask any questions?
Yes, I've prepared a statement. So thank you for allowing me the opportunity to speak today. I want to begin by taking full accountability for my actions and for the role I played in the situation. It was never my idea, and I recognize that I should have been that I should have asked more questions and taken more responsibility to ensure that everything being done was appropriate and within the law. I understand now the seriousness of the situation, and I am deeply regretful for not being more cautious. To briefly summarize what occurred, I was instructed by my supervising pharmacist to process a prescription that, at the time, I believed had been properly communicated between the doctor and the pharmacist. I followed his directions, trusting that he was operating within professional and legal standards. At the time, I was following the direction and guidance of someone who was in a position of power and authority. I truly believed I could trust his judgment, as he had more experience and was supposed to know the laws and professional boundaries far better than I did. I had no idea about the kind of activities he was involved in outside of this incident, or that his license would later be revoked for multiple serious reasons. I now find myself asking how someone deemed unfit to practice was ever placed in such a position to guide others like myself. I want to make it clear that I would never have acted alone or with bad intentions. My actions were based on the belief that what I was doing was appropriate and that communication between the doctor and pharmacist was taking place as it should have been. I also did not know that the information provided would be reused for birth control purposes. I was under the impression that pharmacists were authorized to prescribe birth control, and I trusted that the direction I received was legitimate. In hindsight, I realized I should have known better. I should have questioned what was being asked of me instead of blindly following guidance. I do have years of experience in retail pharmacy, and I have never encountered anything like this before. I truly did not understand the extent of the situation I was in, and I feel heartbroken that it has jeopardized my reputation, my integrity, and possibly my future in this profession that I love. My employer is aware of what happened, and I am not currently taking prescriptions over the phone until I receive proper training and full clarification on the protocols. I am doing everything I can to rebuild trust, learn from this mistake, and grow into a better, more vigilant professional. Pharmacy has been my passion for years. I care deeply about helping people and being part of a profession that improves lives. I would never knowingly put my patients, my license, or my colleagues at risk. This experience has been painful, but eye-opening, and I am committed to learning from it and ensuring nothing like this ever happens under my care. I hope the board can see that my intentions have always been good, and that my lapse in judgment came from misplaced trust, not from neglect or dishonesty. I have reflected deeply on this experience and will use it to become more responsible, informed, and ethically grounded as I continue working toward becoming a pharmacist. Thank you.
Thank you, Ms. Watson. Board members, questions, discussion?
I have a question. Ms. Watson, in the report that we just heard, there was a prescription for tretinoin. Are you familiar with that prescription?
Yes, sir, I have been.
Who was that for?
For me.
Okay, and was that phoned in? Was that written on a prescription pad in the pharmacy? Can you tell us about that process?
Yes, it was written in on a prescription pad in the pharmacy.
And who wrote that?
I did.
Okay. So at the time that you did that, what were you thinking? I mean, you're a licensed pharmacy technician, and that did not come from a physician. You just took it on your own initiative to write that prescription for yourself?
No, so I was taking down voicemails, which was something that I always did. It wasn't anything out of the ordinary for me. And my supervising pharmacist had instructed me to go ahead and prepare that prescription for myself. And so I followed those directions and I did so. I didn't ask any questions. I didn't ask whether he got the okay from the doctor, if that was even allowed. I just had no idea of what was going on behind the fact of him, telling me to just write it.
So tell me just a little bit more about that interface, if you can recall it. How did he ask you to write that prescription?
I can't fully remember, but I do know that he just told me, like I said, just go ahead and start the prescription for the tretinoin. And I mean, I know what goes on a prescription, so I filled out my name, the medication, and the doctor's information.
Ms. Watson, did you believe that the doctor had authorized that prescription for you based on the relationship that the doctor had with the pharmacist?
I did. I mean, I did not know of the relationship between them two, but I trusted him in doing it the right way, if there even was a right way to go about that. And I never thought that he would do something or put me in a position where, I'm jeopardizing everything.
So, I'm sorry. So you said you left your voicemail, like you did it?
No, I was taking down voicemails that were already left on the voicemail machine. So I already had, the pen pad with me and everything. And that's when he told me, like, go ahead and start the prescription for the tretinoin. And there was no voicemail. It was just, going based off.
So Ms. Sotelo Watson, help me reconcile. You had to have had dialogue with this pharmacist to say you wanted this medication, you ran out of this medication. How did that happen to initiate the contact of, okay, Ms. Sotelo Watson, feel free to write that prescription for yourself?
Yeah, so I had already been on tretinoin for, a year prior to that or, around that. And I would, always say like, oh, I'm thinking about getting back on tretinoin. And it was for my acne. And so that was just something that I really struggled with. And he told me that he could help me get a prescription for it. And again, I failed to ask questions further than, what happened.
But you legally obtained tretinoin in the past through a bona fide patient-physician pharmacy relationship.
Yes, sir.
So you know the process on how to obtain this medication appropriately, but you made a conscious choice to work with this pharmacist to bypass the provider in this case.
I mean, I was struggling with insurance. I did not have insurance and I was trying to go see a doctor. And that was kind of the reason why this even occurred. It was because I failed to go to an actual physician and get it, properly.
I mean, from my perspective, I mean, does she know about like a patient's provider relationship? I mean, I doubt technicians would know about that. You know what I mean? Like all of them, this must be a relationship. I believe my perspective, she got manipulated by a pharmacist. We addressed the previous case. I mean, she's a new technician. She's been a year. You've been a year, a pharmacy tech?
Since 2022. So
2022, okay.
It's been a while.
So, yeah, I mean, she could have done better, right? To see her primary care to get whatever she needs for her own safety and for law purpose as well. So to me, like, I address the issue there, but I really see how pharmacists can mislead their staff there. And to me, like, a letter of concern to her that will be satisfied. And to me, obviously, she's aware of the situation, and hopefully we'll never see her again here.
What about some continuing education on just the process of maybe the patient-physician relationship?
Yeah.
So I don't know if that's specific of CE exists though.
And really, that's why we ask pharmacists to take law exam and test. We don't ask technicians. They follow pharmacist directions, right? I mean,
They do get nationally certified, and there are questions about pharmacy laws that are on the PTCB exam and other nationally accredited exams. So I think there is an expectation that all licensees understand Arizona revised statutes and Arizona Administrative Code regard to pharmacy practice. And I think that CE is a good pathway for, and you had made a comment also, Ms. Satella Watson, that you were seeking to go into pharmacy school.
Yes, sir.
I mean, like I mean, she just said that she didn't know how he did it. Just she thought that he asked permission from provider out of the state, and okay, that's cool, that's fine. I believe like most of public say, yeah, that's fine. I'm not gonna see a doctor, and they're gonna give me birth control now. Great, right? So, I mean, the purpose of CE to send a message or to people to learn, right? But I believe she misled by that pharmacist. And I don't see the CE will help her here, just coming before us and talking to us and apologize. That's, I believe, and I hope she learned from this mistake. So a letter for concern from my perspective for her, it will be another message from the state board that you need to follow the law and the rules. And if you have a concern about unprofessional conduct from a pharmacist, you need to address it to your employer and to the state board. And I'm sure she will in the future.
In the whole scheme of things, though, an advisory letter / letter of concern and a CE for 3 hours on pharmacy law, which she clearly needs some education on pharmacy law. They're equivalent, right? They're both non-disciplinary, right?
This is the record thing, right?
The advisory letter is non-disciplinary. The CE can be disciplinary or not. It would be a little inconsistent to issue an advisory letter, which is non-disciplinary, but then order disciplinary CE.
I personally of the opinion that we should dismiss it. I think she was acting on the direction of the pharmacist. And while it was improper, I don't know that she knew that it was improper. And she was working under the direct supervision of the pharmacist, who we heard from his own words, granted I was recused from the case, but I did listen, that he did this for her. And he was acknowledged that he continued to provide prescriptions when he thought it was convenient for him to help other people. I don't know. I don't know that I think it's fair to hold her accountable for something that somebody instructed her to do.
I totally agree with you. Let's have the same thing.
I think she's a licensed technician. She's responsible for following the laws of pharmacy practice in the state of Arizona. And she wants to be a pharmacist. She's learned her lesson, and she knows that there has to be a physician-patient relationship. I mean, when she sees a provider's name on her prescription label from Louisiana, or who is this person? I mean, does that not trigger any sort of thought that this process was inappropriate? Because I'm sure she was part of the dispensing process where she's looking up this provider and sees that he's in Louisiana. I mean, come on. She has some sort of understanding that this was an inappropriate action, and she continued with the scheme. And I'm not asking for discipline, but I think that Mr. Hogan's comment about CE is totally appropriate. And I think an advisory letter is insufficient.
And if that's a motion, I would second it.
My motion would be for non-disciplinary CE at 3 hours in pharmacy law.
Second.
To be completed within 90 days.
So, yeah, just before we move on, so what did she evaluate exactly the law? I mean, is it the pharmacist who did the law violation or her?
She participated in the filling process, and the entire process. She asked a pharmacist to cover a prescription for her because she didn't want to go to her doctor.
If I may, I never specifically asked that of him. It was more so him trying to help me, and I understand that. He, like I said, told me that he could help me get a prescription for tretinoin. I never went to him and said, hey, I know you have a cousin who's a doctor. Can you get me this? It never went that way.
It sounds like it was entirely his idea and he instructed her to do it. And that's why I remain firm in my thought that we should dismiss it.
I just don't understand how it even comes up into conversation without saying, I need more tretinoin. Or how did it come to his knowledge to say, Ms. Satella Watson, go ahead and write this prescription, reduce this to writing, and go ahead and fill it? How did that conversation come to be without you having any sort of conversation with him about the need or desire to have tretinoin cream?
I mean, I for sure expressed to him that I wanted to get back on tretinoin. I never directly asked him to do that of me. And him being a pharmacist, knowing about medications, I had already been on tretinoin. It was nothing new for me. I trusted that, he got the okay from his doctor, and that's when he instructed me to do that. That's what was going on in my head.
So when you were in the process of filling that prescription, what were your thoughts in that process? Did you ever consider, or did your gut ever tell you that maybe this wasn't the proper way to handle this particular situation?
Yeah, I mean, I had never been put in a situation like that before, so of course I felt a little off about it, and that's where I failed to ask questions, and I do accept that. But at the time, I just did what was asked of me, and that's pretty much it.
So I think we have a motion on the floor, right? We have a motion and a second. I think there's going to be a split vote here. So let's do roll call.
Mr. Thorwald.
Aye.
Ms. Davis,
Nay.
Ms. Walmsley,
Nay.
Ms. Park,
Nay.
Mr. Hogan,
Aye.
Mr. Al-Nassif,
Nay.
Mr. Anderson.
Aye.
It's 4-3, motion fails.
Motion fails. Do I have an alternative motion?
I'll make a motion to dismiss.
Second.
I have a motion and a second. Any discussion? Dr. Gandhi, why don't you go ahead and do roll call just for fun?
Mr. Thorwald,
Nay.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Park,
Aye.
Mr. Hogan,
Nay.
Mr. Al-Nassif,
Aye.
Mr. Anderson.
Nay.
4-3, motion passes.
Thank you for being present.
Thank you so much.
All right, I think that takes us back to tab 18. 18B, Desiree Boone. Is Miss Boone present?
Hello.
Oh, jeez. Hi there.
I'm sorry.
That was very loud.
I'm sorry. I was trying to get it to work. Is that better?
That's much better. Can you turn on your camera?
Yeah. Is that there we go.
There you are. Thank you. If you could please introduce yourself for the record.
Yes, I'm Desiree Boone, pharmacy technician.
Thank you. Ms. Bolts, if you could give us a summary.
Certainly. Hannah Bolts, Licensing Division Manager. Desiree Boone was issued a pharmacy technician license on March 13th, 2013. Her license expired on October 31st of 2024. She submitted a technician license renewal application on February 12th of 2025. She disclosed that she was charged with 2 felony counts of aggravated driving or actual physical control while under the influence of intoxicating liquor or drugs in April of 2022. Ms. Boone did not disclose this information on her November 2022 renewal application. On October 3rd, 2022, Ms. Boone was pulled over for speeding and tailgating other motorists. Her 6-year-old daughter was seated in the front passenger seat of the car. Ms. Boone informed the law enforcement that she had been to a gender reveal party earlier where she indulged in bottomless mimosas. She advised police that she may have had cocaine in her system from a rave that she attended the night before and the morning of. A test of Ms. Boone's blood revealed the presence of metabolites for THC, cocaine, and ethanol. Ms. Boone was sentenced to serve 1 day in jail, was placed on supervised probation for 2 years, and pay all restitution fines and fees. Ms. Boone petitioned for early termination of probation, which was granted on May 10th, 2024. The board office was unaware of Ms. Boone's criminal charges until she submitted her late renewal application in February of 2025.
Thank you, Ms. Bolts. Ms. Boone, would you like to address the board?
Yeah, I would just like to say that I when this was going on, I was not currently working at a pharmacy when this took place. I do understand the seriousness of it. I've learned from my mistakes. It's just unfortunate lapse in judgment, and I'm trying to move forward.
Thank you, Ms. Boone. Board members, any questions or discussion?
Ms. Boone, on your application document, you had acknowledged that you were working at Star Care Pharmacy. Is that still your current employer?
No, sir. No, sir. I haven't worked there since I believe June, probably like the first week of June.
And what were you doing at Star Care Pharmacy in June?
I was just there as a clerk. So like just stocking shelves, answering the phone calls. I wasn't licensed anymore, so I wasn't writing, I wasn't processing prescriptions or building patient profiles or anything like that. I was just answering calls, stocking shelves, checking people out, things like that.
Thank you.
Questions or discussion?
So based on the cocaine and other related information, I think if there's no further discussion, I'm willing to make a motion.
Go ahead.
I offer a consent agreement for a substance use evaluation and fitness for duty component to be signed within 30 days, an evaluation completed within 90, not signed, deny application, and if executed, timely return to the board with the evaluator's report and determine next action.
Members of the board, you have the authority to order her to complete that evaluation. It does not have to be a consent agreement. So you could issue that order with the timeframe stated, the scope of the evaluation. Then if she doesn't complete the evaluation, your motion could also include a provision that the matter be referred to formal hearing for denial of the application and a violation of the board order.
Perfect. I will amend my motion to reflect what you just said.
And I'm in my second.
She also didn't disclose.
Which is the primary reason that she's here today. She would have disclosed, this wouldn't have come before us.
Well, she didn't disclose in her renewal in 2022 when she should have, but she disclosed during this renewal.
Okay, thank you.
I'm sorry. I thought the DUI happened after I renewed in 2022. Is that not correct?
So it looks like you were pulled over on April 3rd, 2022, and you submitted your renewal in November 8th, 2022.
Oh, okay. Okay, sorry. I had the timeline messed up. Sorry. Okay.
Ms. Boone, are you using any of these substances any longer?
No. I have the occasional drink, but no, that was just
And and this is the only DUI you've ever had?
yes, ma'am. This is the only time I've ever been in trouble. Like I've had my license for years.
Thank you. So the reason this is before our board members is not because of the DUI, it's because of the failure to notify that happened in 2022. She did notify us here. She did not do it in a prior application. I had a motion. Did I have a second?
Yes, I had second.
Do we need roll call for that? Yeah, we do, because it's an order, right?
Yeah.
You do, and it's a possible denial of application if she fails to comply.
Mr. Thorwald,
Aye.
Ms. Davis,
Aye.
Ms. Wansley,
Nay.
Ms. Park,
Nay.
Mr. Hogan,
Aye.
Mr. Al-Nassif,
Nay.
Mr. Anderson.
Aye.
Ayes have it 4-3, Madam Chair.
Thank you, Ms. Boone.
Okay, thank you. So someone would contact me with
Yeah, the
further
staff will be in
info-
contact with you probably either late this week or early next week, probably early next week.
Okay. All right,
Thank-
perfect. Thank you for your time.
18C, Elizabeth. Is Miss Ike present? Please approach and introduce yourself. Please introduce yourself for the record.
My name is Elizabeth Ike.
Welcome. I see we have a new face. If one of you could give us a summary, please.
Hi, Erica De Leon, Licensing Administrator. Elizabeth Ike submitted a pharmacist reinstatement application on September 4th, 2025. Ms. Ike's license expired on October 31st, 2019. She holds a pharmacist license in California that is active and in good standing. However, she has not practiced pharmacy within the last 12 months. Ms. Ike Ms. Ike retook and passed the Arizona MPJE on August 12, 2025, and has completed 31 CEs within the last 2 years.
Thank you, Ms. De Leon. Ms. Ike, would you like to address the board, or would you like us to proceed with questions for you?
I was actually renewing my Arizona license. I have 3 licenses: California, Nevada, and Arizona. I've always constantly renewed them, but somehow a year or so before I decided to retire, I decided not to pay for them. That's why it's expired. But all along, since I got that license, I've always renewed it. So my husband is a missionary, so he moved down to this place, to Arizona. So we came back to Arizona. When I came back to Arizona, I decided to rest for 1 year. I stopped working in September 2023. So I decided that I was going to rest. I wasn't going to work. So after 1 year, I came to renew the license. But what happened was I didn't know that the renewal date was November 1 because I've been away for quite some time. So I was like 5 or 6 days late. I came November 4. So I was told that it's now 5 years. I had to do the MPJE. So I took my time. I did the MPJE. So the last time I actually worked was September 2023. I decided to take 1 year vacation. And I want to renew the license because I don't want to sit at home all the time. I want to have time to go maybe work once a week or 2 days a week. I'm not getting the license for a full-time job. I don't think I want to do that now.
Ms. Bolts, any concern, or Ms. De Leon, any concerns with the application?
No concerns.
All right, I'll make a motion to approve the reinstatement application.
I second.
I have a motion and a second. All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Welcome to Arizona.
Thank you so much.
All right, let's go to 19A, Nizoni Rose Gamble. Is Miss Gamble present? Good morning. If you can go over here, please. If you could please introduce yourself.
Najoni Gamble.
Would one of the two of you like to give a summary, please?
Christina Castro, Licensing Administrator. Nizoni Campbell applied for a pharmacy technician license on May 1st, 2025. She currently holds a pharmacy technician trainee registration valid through December 31st, 2026. Ms. Gamble disclosed a prior arrest and conviction for extreme DUI. On November 1st, 2022, Ms. Gamble was pulled over for speeding. A field sobriety test were performed with a BAC of 0.233. Following her arrest, a search of her wallet revealed a small plastic bag containing a white powdery substance. The substance was submitted for laboratory testing and the results came back positive for cocaine. Ms. Gamble pled guilty to extreme DUI and has fulfilled all terms of her sentencing.
Thank you, Ms. Castro. Ms. Gamble, would you like to address the board, or do you want us to go ahead and proceed with questions for you?
I would like to say something.
Okay, please.
Well, I do understand that the primary point of discussion is disclosure of my prior extreme DUI conviction from November 1st, 2022. I want to be very clear that I take full and complete responsibility for that incident. There's no excuse for the poor judgment I exhibited that night, and I am deeply remorseful for the risk I posed to myself and my community. That mistake was a necessary and painful turning point in my life, leading to a complete and permanent change in my behavior and priorities. Since that time, almost 3 years ago, I have fully dedicated myself to a responsible, sober lifestyle. I have successfully completed all mandated legal and personal requirements. My past error is now the foundation of my absolute commitment to reliability and accountability. And I know that the role of a pharmacy technician is one of trust and precision. You are charged with protecting the public, and I want to assure you that the person standing before you today is absolutely fit for that responsibility. I am focused, reliable, and entirely dedicated to upholding the ethical standards required in a pharmacy environment. At my present employment, I have received recognition as Employee of the Month and is regarded as one of the highest working performing employees. I'm very serious and focused on maintaining my sobriety and my commitment to my work. It is my hope that you will consider granting me a pharmacy technician license and view your support as an investment in a highly motivated individual who has learned from a major failure and demonstrated the discipline required to rebuild with integrity. I am happy to comply with any evaluation or terms that you might direct me to demonstrate my fitness for the work as a pharmacy technician. I want to give you my unwavering assurance that this issue will never be a problem again. I am asking for the opportunity to prove my worth and my commitment to public safety every day I'm on the job. Thank you.
Thank you, Ms. Gamble.
Are you employed now?
Yes.
As what? As a pharmacy
Pharmacy
trainee?
Yeah, at Chewy, the pet meds.
Okay.
Yes.
And do you have a fingerprint card?
Yes.
Active, everything's fine.
Unlike the last case, there was no failure to disclose here.
And just for clarity, there was no failure to disclose because she had a technician trainee registration application that didn't ask at the time of application. So she didn't have a duty to disclose last time.
She still has a
Or this
duty to
time.
disclose. She just wasn't asked on the application. Statute still requires that trainee registrants disclose that information.
I'm concerned again with the cocaine. This isn't just alcohol.
Can I ask a clarifying question? and forgive me because I read the case, but I don't recall, was the treatment for substance abuse board ordered, or was that simply done? If I could just ask you directly, why did you enter into your treatment?
Both for like personal and also it was court ordered.
And you'd be
So,
willing?
yeah, I did an 18 course for what is that? Substance and alcohol abuse education, I believe.
Have you voluntarily connected with, PAPA or any sort of other recovery program for
No,
professionals?
but I have heard of it after reviewing what this thing will go forward to.
And would you be willing, it sounded on your statement that you would be willing to undergo an evaluation?
Yes.
Ms. Bolts, when was she first registered as a pharmacy technician trainee?
December of 2023.
So this DUI happened in 2022. So there's no question on the application. So she would have had to disclose within 10 days if she was licensed, but she wasn't.
I don't know about the 10 days bit. We do have that statute available on your summary.
But the charge took place before she became a technician trainee, right?
Correct. And there
And
was
the
no
application doesn't-
opportunity to disclose it on the application itself.
It's very similar to that nurse one
Right.
that we dealt with recently.
Ms. Gamble, where are you at with your sobriety journey? Can you tell us what you're doing? What is your sobriety date?
Would you like to adjourn into executive session?
If you think that's appropriate. Yes, we can move to executive.
For protected health information.
So moved. Do I have a second? All those in favor?
Aye.
Aye. All right, welcome back, everybody. I think, no, we don't have Dr. Gandhi. We can't start. Go ahead. Okay. Any additional questions for Ms. Gamble? Or discussion?
Discussion. So in the last case, Ms. Galvin helped me form a motion with an order for a substance use evaluation and fitness for duty. It sounds like she's willing to consent for that. Should I just legal question?
I would still order it.
Okay.
Just like before, I know you have a motion, but I believe the first DUI, there is no action required. My concern would be if there's only alcohol or there is other substance like in addition to alcohol. And just gonna bring this one to the whole board members here. Like we are facing a case just like if one DUI, first DUI, and is the application on pending now.
Just seeing the BAC of 0.233 does not make me look like she's a novice drinker.
I have thoughts on a motion from someone.
I like the idea of an order for a substance use evaluation with a fitness for duty component to be completed within 90 days.
I will second that.
She's already practicing, right? The technician trainee. Yeah.
Her license is good until the end of November, or December.
December next year.
This December or December?
No, next year.
Next year.
December 31st, 2026 is when the trainee license will expire.
All right, I had a motion and a second. Dr. Gandhi, roll call.
Thank you, Madam Chair. Mr. Thorwald,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Park,
Aye.
Mr. Hogan,
Aye.
Mr. Al Nassif,
Nay.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair, 1 nay, 2 absent.
And just for clarification, if she fails to comply, then her application would be denied.
Agreement for the group? Yes.
Yes.
Okay. Okay, thank you for being present. We'll go to 19A, Andrew Bobbitt. Welcome. If you could please introduce yourself for the record.
Good morning, everyone. My name is Andrew Bobbitt.
Welcome. Ms. Castro, do you want to give us a summary, please?
Sure. Christina Castro, licensing administrator. Andrew Bobbitt applied for a pharmacist license by full exam on July 9th, 2025. He currently holds a pharmacist intern license valid through November 30th, 2027. Mr. Bobbitt failed to disclose an arrest for a DUI that occurred in 2021. On November 13th, 2021, Mr. Bobbitt was pulled over for failing to come to a complete stop at a stop sign. Field sobriety tests showed signs of impairment and a breath test showed 0.079 BAC. Mr. Bobbitt was arrested for DUI. Mr. Bobbitt pled guilty to reckless driving and completed all terms of his sentencing.
Madam Chair, just for records, 19B.
Yes, I'm sorry. Mr. Bobbitt, would you like to address the board?
Absolutely. Yeah. So I should have had something written prepared. I'm sorry. I'm not a terribly interesting person. That night I was celebrating my engagement and I meticulously had counted out 5 hours without drinking before driving. So like I did drink that night, absolutely. And I waited and then I did not come to a full 3-second stop at the stop sign. And that's what initiated the me getting pulled over. But this is not atypical behavior for me. I don't drink often, obviously not a lot. And when I do, it's maybe once a month. So I would like to say that I am aware that this is not the inappropriate behavior, and I don't do things like this.
So this is coming before us because you failed to disclose it to us when this occurred.
Yeah, so I was mistaken. So I applied for my intern license, and all of this was included on my intern license application. So when I was applying online for my pharmacist application, it has the option that asks if you have an Arizona intern license. And so I said yes, and I assumed incorrectly that all of that information would kind of carry over into the same file. And so once I realized I was mistaken, I provided all the documents.
And we did confirm that he answered yes and provided that information on his intern license, correct?
Yes.
Is our application confusing to you?
Just that one part.
Thoughts? I mean, ultimately, he answered the question incorrectly on the application.
Correct.
I would be in favor of doing a $250 non-civil penalty, a non-disciplinary civil penalty is where my head is.
I agree.
Yep.
That's my motion and approve the application.
Just I have
Okay.
comments. So the case before it was for technician, she came 0.2, right, on her DUI. We want to evaluate, and now we have 0.7.
This was just over 0.1.
Okay.
I'll second your motion.
I'm just,
There's also no cocaine involved.
but it wasn't in her blood there. I'm just trying to be consistent here, like, you know, it's just I throw it to the board members.
Okay, I have a motion and a second on the record. All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Thank you for being here. We'll go to 19C, Larry Dow Jones II.
Hello, everyone. Can you hear me?
Yes, good afternoon, Mr. Jones. If you could
Good
please
afternoon.
introduce yourself for the record.
My name is Larry Jones. I'm a pharmacist.
I see we have Miss De Leon back. If you could give us a summary, please.
Larry Jones applied for a pharmacist license by reciprocity on July 28, 2025. Mr. Jones holds pharmacist licenses in Florida, Illinois, Iowa, and New Hampshire. Mr. Jones disclosed disciplinary actions on his Kansas pharmacist license and was ordered to pass the Kansas law exam. On Mr. Jones's Arizona application, he claimed to have complied with the board order. However, when board staff reached out to the Kansas Board of Pharmacy for clarification, the board stated that Mr. Jones did not take and pass the Kansas law exam. Rather, he requested his Kansas pharmacist license be canceled. Board staff is unsure if Mr. Jones is eligible for licensure via reciprocity.
Thank you, Ms. De Leon. Mr. Jones, would you like to address the board?
Sure. I'm not sure why that shows as it did, because I did in fact retake that exam. Kansas is not my original licensure. Iowa is. This incident happened at my first job out of pharmacy school. I was a good pharmacist, but I had a lot to learn about being a pharmacist in charge, which I learned over the last 30 plus years of practice. I have been a PIC for most of my career. I've been subject to multiple inspections by both the Board of Pharmacy and DEA. Never had any issues at all since. You know, in reflecting on that position in that store, I was far and away the youngest employee in the store and was the manager, and I did not make a lot of friends. I was basically put into that position to try to rectify a situation that the inventory was out of control. So we were doing bi-monthly inventories in the even months of the year and doing physical counts on everything, trying to get that inventory level under control. There was no discrepancies in June. In July, we had an inspection from the Kansas board that they were following up on an anonymous call that we were missing some controlled substances, and they were very specific on what those were. Those controlled substances that they were very specific on were in fact off. Nothing else was. After that visit, voluntarily, I put all of those into our Schedule 2 perpetual inventory system to keep track of those. So we were between inventories and had not caught that discrepancy in order to investigate and report. So, we ended up having a board appearance, at which time I was asked to retake the law exam, which I did. But shortly thereafter, I did relocate to Illinois, and I did not renew my license at that point. So I had been practicing it in Illinois for almost 30 years and have relocated to Texas. And I currently work for a company that owns 20 pharmacies, 4 of which are in Arizona. And I work as a remote data entry verification pharmacist. So, I'm basically just verifying prescriptions for accuracy on input. So that's
Thank
pretty
you,
much.
Mr. Jones.
Thank you.
I have one question for you.
Yes,
So
ma'am.
we have records that you have licenses in Florida, Illinois, Iowa, and New Hampshire. Was
Correct.
Kansas your original license, or did you have another original license?
No, I am originally from Iowa. I grew up just south of Des Moines, and Iowa is my original license.
And you've kept that license active the entire time?
Yes, ma'am. When I moved or got transferred to Kansas, I reciprocated my Iowa license to Kansas.
So does that answer the question we had about whether or not he meets the requirements for reciprocity? I think it does to me.
If you look at bullet point number 3, do you mind if I look at that? The board may license a pharmacist without a pharmacist licensure exam, a person who is licensed as a pharmacist by a pharmacist licensure exam in another jurisdiction if that person, 3, presents proof to the board's satisfaction that any other license granted to the applicant by any other jurisdiction has not been suspended, revoked, or otherwise restricted for any reason except non-renewal or for failure to obtain the required continuing education and credits in any jurisdiction where the applicant is currently licensed but not engaged in the practice of pharmacy. So we weren't sure because Kansas told us that he did not take the exam, that he requested his license be canceled instead of following through with that order. We weren't sure if number 3 pertains to him or not.
So what does his license show?
It shows canceled.
So does that mean that it's is it in good standing? I mean, what do we consider that?
I wouldn't consider that in good standing. And when we reached out to Kansas asking why, they said he requested that the license be canceled in lieu of taking that law exam.
And this would have been in 1994.
Correct.
Yeah, I mean, honestly, he's been pharmacist in Illinois and other states for years, has no issue, and that happened in 1994. And for bullet number 3, as you said, they did not revoke his license. They just say you want to take a law exam or.
The order didn't have any repercussions. It seemed. It didn't say if he fails to, take this exam within the 30 days, this is what's going to happen. It just said he had to do it.
Yeah, and I don't see any other states react on which state, Kansas. You know what I mean? So I feel very fine to approve his application.
I'll second that.
Ms. Galvin, any concerns?
No.
I have a motion and a second. All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Thank you for being present, Mr. Jones.
Thank you for having me. Have a good day.
Thank you. We'll go to 20A. Aquita Pharmacy LLC, and I'm sure I probably said that wrong.
Hi, close enough. We say Equita, but
Aquita? Okay, thank you
Yeah.
for that. If you could please introduce yourself for the record.
I'm Nathan Kenny, pharmacist in charge and owner of Equita Pharmacy.
Thank you, Mr. Kinney. Mr. Hyper, can you please provide us a review of this?
Hello again, board members. Steve Hyber, Compliance Officer. This is for a non-resident pharmacy permit reinstatement request. Equita Pharmacy now, LLC. I was with you, Akita. Located in Kirkland, Washington. I also want to point out this is in alignment with board case number 25-0145, just for the record. Equita Pharmacy LLC is a non-resident pharmacy located in Kirkland, Washington. The pharmacy received their resident state permit in March of 2024, and subsequently they obtained a non-resident permit from Arizona in April of 2024. Since that date, the pharmacy has filled and shipped approximately 9,716 compounded prescriptions to patients residing in Arizona. On March the 14th of 2025, the Arizona board received a communication from the state of Washington Department of Health concerning action taken against Equita Pharmacy involving an inspection performed by Washington State Board of Pharmacy. Because the inspection findings, the Washington Department of Health issued an immediate limited stop service, short for or LSS, order to Equita Pharmacy. The LSS cited Equita for 24 violations of Washington Administrative Code, Revised Code of Washington, and USP 797. The LSS stated that due to deficiencies, Equita was to cease compounding activity, including the dispensing, delivery, and distribution of compounded products, effective on March 12th of 2025. That same day, Executive Director Gandhi sent an email communicating the LSS order to Equita, with a response received from the PIC at Equita later that day. In his response, the PIC acknowledged receiving the LSS order, which was received the day prior on March 13th, stating Equita had stopped all service, including the compounding and dispensing of medications. The PIC stated the pharmacy would resume production only after the firm had satisfied concerns from the state of Washington. The PIC also stated the pharmacy would not resume non-resident operations, and that would include our state, until after our board was satisfied. Let's see, a couple of days later, we opened a complaint. That complaint I mentioned at the top of the discussion. An interim consent agreement for suspension of the pharmacy permit for Equita Pharmacy was created and signed on March the 17th. Since that time, follow-up inspections of Equita were performed by the Washington State Board of Pharmacy on April 7th and also May 6th. After reviewing the results of the inspections, the LSS restrictions remained in effect until a stipulated finding of fact and conclusions of law order was signed in July of 2025. The order, which is standing now, prohibits Equita from performing sterile compounding, but allows Equita to perform non-sterile compounding under USP 797 and 800, except for GLP-1 products, peptide-containing products. The pharmacy may seek modification of the GLP-1 restriction by providing master formulas and peer review supportive literature to the Washington State Board. Equita was also required to submit quarterly reports to the Washington State Board and be subject to unannounced inspections. As the date of my report here, the resident permit for Equita Pharmacy, that's just the Oregon permit, the Washington permit, is active with these restrictions. The pharmacy's non-resident Colorado permit is currently active with restrictions which are aligned with that Washington stipulated agreement. The Arizona permit before you today is currently suspended. And then lastly, based upon the agreed order with the Washington State Department of Health, Equita is requesting reinstatement of their non-resident permit today with Arizona to allow dispensing of non-sterile compounded prescriptions, excluding GLP-1, of course, to patients residing within our state. And then there's a whole bunch of supportive documents attached, numbered 1 through 15 for you to review.
Thank you, Mr. Hyper. Would you like to address the board?
I appreciate that summary. And yeah, just wanted to reiterate, we were the subject of a stop order centered around GLP-1 compounding and our practices pertaining to that. And after several visits with Washington, where we did our best to work with them to resolve this stop order, but unfortunately, it did take a few visits in reaching this agreement with them to forego sterile compounding, because after those visits, we kind of felt that there was nothing much we could do to be fit to continue to do GLP-1 compounding in their eyes, despite us, following our legal advice and the best that we could find. So we did reach this agreement with Washington. As Steve said, Colorado has a similar agreement. We just reached one with Kentucky, and one is pending in Vermont. We're just seeking reinstatement with Arizona, just based on these same terms, if possible. And we would love the opportunity to serve Arizona patients again. Certainly can say I've learned a lot of lessons here, and just intend to work with all the authorities to do our best to serve our patients. And thanks for your time.
Thank you, Mr. Kinney. Board members, any questions or thoughts?
I have a question about timeline. So this pharmacy opened in early 2024.
Correct.
What kind of training did you have for compounding prior to starting to dispense compounded prescriptions?
Yeah, so we used Critical Points TRC Healthcare Critical Points sterile compounding course, and I trained under an experienced sterile compounding pharmacist on site in those beginning months of the operation. So prior to that, it was minimal. It was my experience in school, but I felt
And the state of Washington didn't require you to hire any sort of consultant?
we did have a consultant. That was who I trained under.
After the stop order?
No, at the beginning, when he was there from the launch of the pharmacy for the first, I think 4 months or so.
But the state of Washington didn't require you to hire a consultant after this stop order to see sterile compounding?
No. We did hire pharmacists with additional sterile compounding experience, the most experienced ones we could possibly find, to be co-designated people for sterile compounding, but their experience was still found to be insufficient, unfortunately.
What sorts of non-sterile compounds do you intend to dispense into Arizona?
We were considering things such as skincare, hair loss products, and hormone therapy products. Nothing controlled.
So there's really the mechanism for us in Arizona, please correct me if I'm wrong, to incorporate these practice restrictions into work products that we use is within a probation agreement. Is that correct?
That would be correct. Upon approving the application and the entity's acceptance of a consent agreement.
Thank you.
I'm generally not in favor of reciprocal discipline, but I think in this case it's warranted to protect the consumers of Arizona.
All right, I'll make that my motion. I offer a consent agreement for our probation to include practice restrictions imposed by Washington. May request probation be lifted once practice restrictions lifted in Washington. If not signed within 30 days, refer to hearing.
I second.
I have a motion and a second. Any discussion? Dr. Gandhi?
Thank you, Madam Chair. Mr. Thorwald.
Aye.
Ms. Davis.
Aye.
Ms. Walmsley.
Aye.
Ms. Park.
Aye.
Mr. Hogan,
Aye.
Mr. Al Nassif,
Aye.
and Mr. Anderson.
Aye.
Ayes have it with 2 absence, Madam Chair.
Thank you, Mr. Kinney, for being present. I appreciate it.
Thanks for your time.
Let's go to 20C, Natalie King.
Hi, sorry.
Welcome, Ms. King. If you can please introduce yourself for the record.
Yes, I'm Natalie King.
Ms. Brown, if you could please give us a summary.
Certainly. Jenica Brown, Executive Assistant to the Deputy Director. Natalie King was issued an Arizona pharmacist license on July 5th, 2001. Her license expires on October 31st, 2026. It is currently suspended. On April 17th, 2025, Ms. King contacted board staff and disclosed that she diverted medication from her employer. She stated that she had experienced a series of personal hardships. On April 20th, 2025, CVS Pharmacy notified the board that Ms. King was terminated from her position for admitted employee pilferage. CVS simultaneously filed a DEA Form 106 that indicated a loss of several controlled substances, including carisoprodol and various strengths of oxycodone acetaminophen and dextroamphetamine. In her response to the complaint, Ms. King admitted to diverting the following medications: Adderall 15 milligram, 20 milligram, and 30 milligram, diverted approximately 10 to 15 times between March 2024 and March 2025. Oxycodone 5 milligram and 10 milligram, diverted on several isolated occasions. Carisoprodol diverted a few times, and rizatriptan 10 milligram diverted twice. She further asserted that she was never impaired while working. She stated that she was a float pharmacist for CVS and that the diversions could have occurred at 4 different CVS locations. Her complete response is included in the board's files for review and consideration. Staff received further documentation from CVS, including a handwritten statement from Ms. King admitting to the theft of 169 various types and strengths of ADHD medications, 165 various strengths of oxycodone, 120 350 milligram carisoprodol, 2 rizatriptan 10 milligram tablets, and 3 Senna Plus tablets from 5 different CVS locations. Further clarification from CVS indicated that it was suspected that she diverted medication from 7 locations, 5 of which she admitted to. On April 24th, 2025, Ms. King entered into an interim consent agreement for drug screening, substance use evaluation, and interim suspension of license. The board considered and approved the interim consent agreement during the June 2025 board meeting, and it was executed on June 20th, 2025. Ms. King complied with the agreement and underwent the required drug testing and evaluation. The results are contained in the board's files for review and consideration. This matter is before the board for discussion, consideration, and possible action regarding the facts of this complaint, the underlying conduct, the results of Ms. King's drug testing and evaluation, and the status of her license.
Ms. King, would you like to address the board?
Yes. I just want to first apologize and take full responsibility for my actions. I've been in AA since 2010. Just last year, I have a hard time disappointing people. And after my husband's suicide, I probably should have taken some time off, and a bunch of other things happened. And I was working way too many hours. And now I've realized I do need to take care of myself. I've been seeing a therapist since April, once a week or every other week at the least. I have a psychiatrist that prescribes antidepressants and stuff.
Ma'am, just a minute.
I'm sorry.
Mrs. King, please. Sorry. Do we want to go into executive session for confidential health information?
Oh, sorry.
Ms. King, I don't know that we need this detail of information, although we that
Okay, sorry.
It's okay. So we do have the examination and recommendations of the evaluator at this point.
Can we address the diversion here too? First is like, Ms. King, it seems like you acknowledged and own the fact that these controlled substances were diverted by you.
Yes,
And were they used for personal?
yes,
And you just mentioned you've been in a program of recovery since 2010. Are you still
yes.
actively in a program?
I am, and I'm actually more so now. I've taken on H&I commitments and stuff just because I know I need to be more involved. Yeah, so.
Considering the admitted diversion here and the known diversion or admitted diversion of controlled substances, and the history, is there prior board action that we should be made aware of?
Yes.
Ms. King, I believe that question was for staff. Once
Oh,
you
sorry.
if a violation has occurred in this case, then you are able to hear about any previous discipline. And I think because she has acknowledged the diversion, you have, I assume, found that a violation has occurred.
That's correct.
So staff can disclose any prior discipline.
There is previous discipline on record in 2010 and 2022 for possibly related conduct.
Was she on a prior contract?
Yes.
And were those for diversion related activities as well?
Not diversion, however, possibly related conduct for substance use.
Okay.
You can be more specific.
The two prior were alcohol related.
So this would be a third PAPA contract if it was offered to her?
That is correct.
In addition, I just have concerns on the timeline that the evaluator mentions. I don't know how manageable that is.
I mean, they're suggesting lifelong monitoring.
Correct.
And with a minimum of 10 years for possible reevaluation. And given the history, I can see why that is the recommendation. Hello, Mr. Grease.
Hello, board. My name is Ryan Grease. I'm the PAPA program director. May I? So there has been previous conversations about lifelong monitoring. I believe, and the board staff could probably correct me, I think there was a couple times where that was offered in the last 10 to 15 years. I don't think it's ever actually happened in fruition for people either deciding to go a different direction, or I think one person actually passed before they could enter into like the lifelong agreement. It is something that structurally we have been thinking about and is somewhat the way some of these are going, when, especially when you have repeat situations. So it is something that the capacity of the program could be able to do. We just haven't had to do that to this point.
Thank you, Mr. Grease. That's helpful. Ms. Brown, was there ever any non-compliance with her prior orders?
Both matters precede me. I would need to take a look into that and get back to you.
So my question is, what's the board's safety net to protect the health of Arizonans? How do we know if we were to go forward with a lifelong scenario? How do we know if the licensee becomes unable to practice? What are our tools?
Well, Papa would do the monitoring, so if she would have ongoing testing, ongoing monitoring requirements, counseling, etc.
Correct. It would likely look different than what a typical 5-year contract would be, especially if someone works from the 5 to the 10-year and beyond. So the requirements for how many urine drug screens and how many counselor, like weekly versus biweekly versus quarterly, that would be required, but they would never not be monitored. There would always be touch points, which then could be evaluated, that if there were concerns, it would be escalated for a requirement to report to the board that, hey, we think that there's some concerns here.
Personally, I don't have the appetite for a third contract. I think we're at a point where she's not safe to practice as a pharmacist in the state. She's not safe, and I'm not comfortable offering another contract.
I agree with you on this.
Ms. Walmsley, to answer your question, upon review, it does not appear that there was any noncompliance with the past discipline.
Thank you, Ms. Brown.
How long ago was she removed from that last monitoring contract before doing this again?
The last matter occurred in 2022. And I believe that was for 1 year. Let me double check here.
She was released from probation in October of 23.
Thank you, Jennifer.
I agree with you, Dr. Anderson. Like, we're getting to the point, I don't think she's safe to practice. And unless somebody can share.
Thoughts on a motion?
So our option here, Ms. Calvin, so we move for hearing or?
So, given the unprofessional conduct that I believe you have found, if you are not inclined to offer her some sort of consent agreement for monitoring, then you would move to revoke her license, and that would go to formal hearing, or alternatively, you could accept a consent agreement for voluntary surrender. The revocation would be based upon this underlying conduct, the recent diversion, the findings of the evaluator, and what has been disclosed in the investigation.
And in case her license get revoked, she still can reapply in whatever we decide, 2 years or 3 years.
Yes, it's a minimum of 2 years.
2 years, so she can reapply.
I think she needs 5 years of sobriety before I want to see her again. Correct.
Is that your motion?
That my motion, yes.
Do I have a second?
Second.
A motion and a second. Any discussion? Dr. Gandhi, roll.
Mr. Thorwald.
Aye.
Ms. Davis.
Aye.
Ms. Walmsley.
Aye.
Ms. Spark.
Aye.
Mr. Hogan.
Aye.
Mr. Al-Nassif.
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Thank you, Dr. Gandhi. Thank you, Ms. King. Dr. Gandhi, I believe we had some scheduling issues that we needed to try and handle before lunch. Is that correct?
That is correct, and a gentleman sitting right at the desk here, so.
Please direct me to where we need to move.
we would
23?
like to go 23A and then 23C.
Okay, let's take 23A, which is
Hughes.
Okay, thank you. Adam Franklin Nye. Welcome, Mr. Nye. If you could please introduce yourself for the record.
My name's Adam Nye, Adam Franklin Nye, pharmacist.
Thank you. Mr. Grace.
Hello, Grace, Papa Program Director.
Ms. Brown, if you could go ahead and give a summary.
Certainly, Jenica Brown, Executive Assistant to the Deputy Director. Adam Nye was issued an Arizona pharmacist license on July 30th, 2012. His license expires on October 31st, 2026. It is currently open and on probation. On or about October 18th, 2020, while working at CVS Pharmacy, Mr. Nye was observed inhaling from a can of compressed air and helping patients while under the influence of the inhalant. Mr. Nye later admitted to using inhalants at work and marijuana at home. Mr. Nye entered into a consent agreement for suspension, probation, and monitoring, which was executed on December 22nd, 2020. The agreement placed Mr. Nye's license on a suspended status for 6 months and required him to enter into a rehabilitation and monitoring contract for the entire term of his suspension and probation. Mr. Nye entered into a 5-year contract with PAPA on January 6, 2021. On May 7th, 2021, an order amending the consent agreement for suspension, probation, and monitoring was issued, lifting the suspension imposed on his license and placing it on probation for a period of 4 years and 6 months. On August 18th, 2025, Mr. Nye contacted board staff and requested an appearance before the board during the October 2025 board meeting to request termination of his probation. On August 31st, 2025, staff received a letter from PAPA endorsing his request. Mr. Nye is in compliance with his consent agreement, and there are no concerns from staff.
Thank you, Ms. Brown. Mr. Nye, would you like to address the board?
Yeah, I made a statement, but I'm not going to be able to read it. There's too much. I just want to thank you guys for giving me the opportunity to practice, over the last 4.5 years. When I lost my son in 2020, I went down a very dark road. I lost myself. And with what happened at work, and then joining PAPA, I've made a lot of changes and strides in life. Definitely put a lot of things into perspective. Just working on my recovery constantly, mentally, as well as abuse. I've made a lot of strides, and it's something that's never going to change as far as the grieving process. But I've definitely learned better ways to handle it than abuse and addiction.
Thank you, Mr. Nye, and sorry to hear about the loss of your son.
Thank you.
Mr. Grease, would you like to say anything? I assume Papa's in support of this.
We are fully supportive. He's made significant gains in the last 4.5, 5 years, and he's fully compliant with all of his obligations. And his counselor, who's in Tucson, who's not here today, is also fully supportive of him being released from probation.
Thank you.
I can move to accept the request for termination of probation.
Second.
I have a motion and a second. All those in favor? Aye. Any opposed? Hearing none. Motion carries. Thank you, Mr. Nye. Glad to see that you're doing well, and good luck in your continued recovery.
Thank you.
All right. 23C. M. Don Brewer. Good afternoon, Mr. Brewer. If you could please introduce yourself.
I'm M. Don Brewer.
Ryan Grease, PAPA Program Director.
Thank you. Ms. Brown, if you could give us a summary.
Jenica Brown, Executive Assistant to the Deputy Director. M. Don Brewer was issued an Arizona pharmacist license on July 24th, 2007. His license expires on October 31st, 2026. It is currently open and on probation. On or about May 15th, 2020, board staff was notified that Mr. Brewer was terminated from employment at Bash's for theft of controlled substances and forging prescriptions for controlled substances for personal use. The DEA Form 106 filed by Bash's stated that over 11,300 pills were lost due to suspected employee theft. The medications stolen included, but was not limited to, varying strengths of alprazolam, hydrocodone with acetaminophen, carisoprodol, lorazepam, oxycodone, tramadol, zolpidem, clonazepam, and diazepam. Bash's also found evidence of forged prescriptions entered into the pharmacy system on a regular basis. According to Bash's, Mr. Brewer confessed to the diversion and forging prescriptions for personal use and on behalf of a family member. Mr. Brewer entered into a consent agreement for probation and monitoring, which was executed on January 22nd, 2021. The consent agreement placed Mr. Brewer's license on probation for a period of 4 years and 6 months and required him to enter into a monitoring contract for the entire term of his probation. On April 24th, 2025, Mr. Brewer contacted staff to request an appearance before the board to request termination of his probation. In his communication, he further disclosed an arrest on or about April 22nd, 2025, which was the result of a warrant that was issued in connection to the incident in 2020 that led to his consent agreement with the board. On May 8th, 2025, Mr. Brewer contacted staff and requested a postponement of his special request in order to address his pending criminal matter. The underlying conduct related to Mr. Brewer's criminal matter was addressed and adjudicated by this board through the consent agreement that was executed on January 22nd, 2021. On August 28th, 2025, Mr. Brewer contacted staff and requested to appear before the board during the October board meeting to request termination of his probation. A letter of support from PAPA was received on September 21st, 2025, endorsing Mr. Brewer's request to terminate his probation. Mr. Brewer is in compliance with the terms of his consent agreement and staff has no concerns.
Thank you, Ms. Brown. Mr. Brewer, would you like to address the board?
Yes, I have a brief statement. My ordeal began when I was given a prescription for lorazepam for a panic attack that I was experiencing. A few months later, when I attempted to taper off the medication, the panic attacks returned. I was convinced that I could not live without this drug, and thus I began my slow descent into the darkness of addiction. A few years later, opioids were added to the regimen of abuse after a knee injury, and due to tolerance, abuse grew heavier and more severe as time passed. In May of 2020, my employer confronted me with concerns about possible substance abuse. The addict in me wanted to deny any wrongdoing, but I had simply had enough, and I confessed to everything. My recovery from substance use disorder has been and continues to be a remarkable journey. By the grace of God, I survived the living hell of withdrawals and detox. I have witnessed God's healing hand upon me as my health and clarity of mind were restored. I have been able to discover the reasons behind my substance abuse, and I have acquired the necessary tools for managing these causes in a healthier, non-pharmacological way. This journey has been filled with many challenges and obstacles, but it has also provided numerous opportunities for learning, personal growth, and service. I want to express my deepest gratitude to the PAPA program for teaching, guiding, and supporting me over the past 5 years. And finally, I would like to thank the board for your consideration today. Thank you.
Thank you, Mr. Brewer, for sharing. Mr. Grease, I assume Papa's in support?
Correct. We are in support. I will have a call that typically when we have these contracts that the person has been working in a pharmacy at some point in that 5 years. We have been working with Mr. Brewer and that has not happened, partly from where he has lived. So the removing of probation to having a fully active license without monitoring, I just wish we had 2 or 3 years of experience. So I wanted to say that out loud prior to, just so the board is aware that he has not been working for a couple years within pharmacy, all 5?
Within pharmacy, all 5.
All 5 years.
So, Mr. Brewer, have you not been working because you felt like you needed the time for your recovery, or you've not been able to find work, or what's the situation?
Initially, in 2020, there just was not any jobs in this area. Or there were jobs, but the supply exceeded the demand pretty significantly. The end of October 2021, both of my parents came down with COVID. They live up north in Navajo County. And so I moved up there to take care of them. My father was, he lost the ability and strength in his legs. He could not stand on his own power, so he required pretty much around-the-clock care. He unfortunately passed away from a cardiac event in December of 2021. After consulting with my siblings, I decided to stay and move permanently to Snowflake in Navajo County, where my mother resides, to take care of her. And I believe that was February of 2021 or 2022. Even though the opportunities in pharmacy have increased significantly in the last past years in Navajo County, those opportunities have been drastically limited. The other barrier to finding employment up there is the testing. There's only 2 test sites in Show Low, and it's a 40-minute drive one way. So finding an opportunity where an employer would allow 2 hours a day just for the drug screen was difficult.
What have you been doing to stay current with pharmacy practice? Obviously, a lot has changed in 5 years.
Yeah, I've kept up on my CE and I do get, emails from different publications about pharmacy and new drugs and so forth. Obviously, it's hard to match the day-to-day knowledge that's gained in a pharmacy.
So Ms. Brown, I'm reading in this summary here that there is potentially a criminal matter pending.
It's directly related to the conduct that we're discussing today, and the board technically adjudicated that conduct with the consent agreement.
They just haven't finalized the criminal matter.
I can give you an update if you'd like.
I think it'd be helpful.
The plea agreement has been accepted and entered. It's with the Attorney General's office. They're prosecuting the case. My sentencing hearing is next Tuesday, the 21st. And basically it's at the discretion of the judge to accept the plea agreement. And then if she accepts it, then she would also determine the length of probation that's stipulated in it.
What is your sobriety date?
Sobriety date is May 22nd, 2020.
So, Mr. Grease, I'm hearing that Papa's supportive of this, but has some hesitations. Is that fair?
I wouldn't necessarily say with his recovery, he's navigated, he's fully compliant. I have no reservations with that. If you want to use the word hesitations or reservations, in a perfect world, I think we'd like to have monitoring while someone is first dipping their toes back into
Right.
a potentially stressful environment. And I cannot attest to how he would respond in those situations. His recovery from what we have seen is solid, but that is a stressor that is typically outside of the day-to-day of someone who's not gainfully employed in the
Which
pharmacy.
is why we typically allow the probation so we can see how that plays with the recovery.
Sorry, I maybe misunderstood. So you have not worked as a pharmacist for 2 years or 5 years?
5 years.
5 years, okay.
Can we place any sort of practice restrictions?
That's within a probation, right?
Could we modify the terms of his consent to add practice consent conditions?
Yes, the probation would continue, but you would add any different terms, and it would have to be by consent.
I mean, he's requesting for termination of probation. That's his request, so.
I mean, he's in compliance with the agreement. There's nothing that said he had to work. I understand where Mr. Grease is coming from, and I appreciate you calling that out because I do think that it's important. I want to say yes, but I also know that pharmacy can be a stressful environment. I don't know.
I'd like to make a motion for legal advice.
Do I have a second? All those in favor?
Aye.
Aye. Okay, welcome back, everybody. Any additional questions for Mr. Brewer or discussion?
I think Mr. Brewer has complied with the board's order. And I'll just say that.
Do you have a motion based on that comment? If you don't, that's okay, but I'm just. Okay.
I move we accept the request to remove probation. And if there's anything else I need to add, I would be happy to do so.
Like to make you feel better about it. So yeah, I mean, he has complied with the board order. I would like to see how you will like handle stress inside the pharmacy, because as you know, you work as a pharmacist for years. It can be very stressful, but you have finished your probation and you complied. So if that's your motion, I will second your motion to terminate his probation.
I have a motion and a second. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion carries. Thank you, Mr. Brewer. I'm glad to see that you're doing well. All right, let's take a recess for lunch. Dr. Gundy, you want to come back at 1:15 or do we want to do 1:30? 1:15? Okay, 1:15 audience.
Thank you.
Saying our board council. Do we want to go ahead and get started, Cam? Can we go ahead and take roll call to establish quorum?
All right. Mr. Braswell. Mr. Thorwald. Ms. Browning. Ms. Davis.
Present.
Ms. Walmsley.
Present.
Ms. Spark.
Present.
Mr. Hogan.
Here.
Mr. Al Nassif.
Here.
Mr. Anderson.
Here.
6 present, 3 absent, Madam Chair.
Thank you, Dr. Gandhi. We'll go ahead and finish up tab 20, 20D. This is for Elvira Brenda Tosi. Ms. Tosi present?
She is not online, Madam Chair.
I feel like we are gonna probably need to talk to her, is based on my recollection of this case. Unless something has changed, Ms. Brown.
She was sent a notice to appear.
I guess let's go ahead and proceed with conferences and we can come back to her if staff can reach out to her and let her know that we're trying to reach her. We'll go to 21A and I'm recused.
Thank you, Ms. Walmsley. This is tab 21A, complaint number 25-0302. Board staff is Mr. Castaneda. A respondent is Walgreen number 3463. Type of complaint, a pharmacy operated without a designated pharmacist in charge. Ms. Trujillo, good afternoon. Would you like to introduce yourself?
Good afternoon. It's Susan Trujillo from Corals and Brady, and with me, I have Lee Navarra as the district manager.
Thank you.
And Mike Simcoe should be on the line there from Walgreens.
Thank you. Mr. Castaneda, would you like to make an opening statement or a summary for us?
Yes, thank you, board members. Ben Castaneda, compliance officer, Arizona State Board of Pharmacy. This is a continuation of the conference for complaint 250302 of a pharmacy operating without a pharmacist in charge for 2 months. At the last meeting, you had requested that I get more information from the permit holder regarding the discrepancies between when the previous PIC took over, when the previous PIC left and the new PIC took over, because there were some discrepancies in our database. I did reach out to Mr. Navarez, and he indicated that the discrepancy was due to a typo and that he did not intend to mislead anybody.
Thank you, Mr. Castaneda. Ms. Trujillo, would you like to make a opening statement?
Mr. Navarez will be making a statement.
All right, thank you.
Thank you. So when Bennett Jorgensen was a pick, he gave us.
Mr. Navarez, could you activate your microphone, please?
Thank you. I'm sorry. Welcome back from lunch. When Bennett Jorgensen, the pick in charge, gave his 2 weeks notice, Oscar Diaz applied for the pick position. He interviewed on March 24th and accepted the offer on April 9th. We scheduled the pick change inventory on May 13th, and he started in the store on May 15th. On May 13th, I incorrectly entered his starting date as March 15th rather than May 15th. Oscar caught the error upon receiving the violation and updated the profile on June 2nd. To try to correct the error, he updated my entry to add an end date of March 15th and created a new entry to show the correct date on May 15th. I'm sorry for any confusion that has caused and never meant to make it look like I was trying to backdate the change and hide the gap in coverage.
Thank you. Board members, any questions?
So I'm sorry. So there's no gap for PIC. It just mistakenly entered the wrong date. Is that
I entered the wrong date.
Yeah.
But there was a gap.
There was a gap.
Yes.
Yeah.
I made the mistake of not
Okay.
putting the pick in there.
Okay.
So what is your process to identify a pick before you have one hired when one leaves unexpectedly, or what is that process?
Please.
The process is that we do identify another pick that's temporarily in charge from one of our pick managers or staff pharmacists, and we need to have a pick in charge before that pick leaves the company. So that's our process.
So how come the process wasn't followed?
I did not follow it correctly. My intention was to have a pick there already with Oscar Diaz, but that didn't come to fruition. That didn't happen. And it was my fault for not getting a pick in there temporary.
Thank you.
How many days did the pharmacy operate without a pick?
It was approximately, it was about 2 months. I can give you the exact dates. Mr. Jordison left on March 14th and Mr. Diaz started on May 15th. So 2 months, 2 days.
So the standard is $100 for failure to update a change in PIC. Is that like per day, or is it just a one-time $100 civil penalty?
I believe only one fee, one time, one is a flat number.
That's just failure to notify of a change of PIC, not necessarily operating without a PIC though.
Correct.
So it's more like record keeping, didn't update the record.
Dr. Ganti, so I'm not talking about this case specifically, but let's say a small business pharmacy lost their PIC, so they cannot operate. There is no like law or rules will support them without PIC for like short time period, or because sometimes like hard to find PIC. I mean, so what is the legal or the right way for permit holder to proceed?
It's always been a challenge, especially in remote locations.
Yeah.
Obviously there's temporary PIC appointments by either the staff or temp agency or some mechanism.
Yeah.
Until they can find a full-time pharmacist.
So there's nothing really legal way to run without PIC. But this is what challenge I see. It's maybe something we should talk in the future. We cannot change the rules now, right? But it's really challenging from my experience. I mean, to find PIC, even temporary, it is a big responsibility for people. So I'm not discussing this case as I recognize there is a gap, but we might see many cases, regarding the same exact issue is running without PIC because not they don't want to find PIC because there is no way to find PIC sometimes. Yeah.
So do we have any history of when we have a permit operating with a gap of 2 months? Anything for us to?
I don't think we have history regarding it. I think our position's been, let us know your action plan, what you're doing to appoint a PIC. And as long as they've been working with us, because I understand there's challenges. Somebody might just up and leave right now, right? And out of the pharmacy, and then what do you do? So I think in the best interest for everybody is let us know your action plan. If it takes you 2 months, let us know it's going to take you 2 months and how are you going to fill in that gap? One of the things about Arizona is when you look at community pharmacies, it's not one PIC that overlooks one pharmacy. One PIC can overlook multiple pharmacies too, temporarily. So that is a little bit of a flexibility given in the state to accommodate those hard to reach areas.
And had Mr. Castaneda not do that, routine inspection and identify the lack of PIC, there may not have been action for another month. So I do think that, it sounds like you've taken corrective action and you have a plan moving forward, but it really doesn't absolve the conduct of having that gap and not working with the board to identify a PIC until one was fully secured in May.
And Mr. Anderson, if I may, the replacement pick was identified. It's just that he couldn't transition over to that store. So I think the error here was simply not filling that gap between when Oscar Diaz could start. So there was an individual identified. It's just that there was a gap before he could take that role. And so the era was not filling a gap.
Dr. Anderson, like from my perspective, I mean, this chain, like it's Walgreens, it's a big chain. They maybe have changed BICs many times. I don't see as kind of ignorance or just overlooked. Like when you have many changes, pharmacists and PIC, you're gonna miss something, right? And really, it's not happened from my perspective. It just because this permit holder doesn't care, or they don't want to do it, or they're above the law. It just happened. They overlooked, like sometimes has a busy days and they identify the PIC. PIC just take time to join, things like happened. Me personally, like I'm glad they found PIC and then they're aware of the issue, and hopefully they will not come again before us for the same issue. I feel like at this time, because we don't have like previous history about this, I mean, I'm good with dismiss the case, or I'm fine with dismissing the case in this regard. I mean, just given the fact that they recognize it and they have done correction action plan.
Yeah, I agree. I think, they do have a procedure. It just wasn't followed. It was a human error in that regard, and I would support dismissing.
Yeah.
So not even the standard 100 that we give for failure to notify of a PIC? I mean,
They did not fail. Did they fail to notify?
correct. They failed to notify until after our inspector is there doing a routine inspection.
No, so I overlooked this one. See, I same thing.
Yeah.
I made a mistake. See, everyone makes mistake. So so they failed to report, right? It's not after, because I got lost with those dates. So there is a gap 2 months
So when I went in to do the routine inspection, I believe that was in May.
on May.
Yes, the staff there told me that they did not have a PIC in place. And that's when I asked more questions and dug into it more.
Right. And it was around that same time that they did submit the paperwork to notify the board of the change in PIC. I mean, the portal shows that update like that. They did notify when Mr. Diaz started, when the new PIC started. So they did notify the board. It's just simply that there was that gap in time.
So there is.
It's the timely notification of a PIC change.
Yeah. So, okay, so since there's failed to report in timely manner, so $250 fee for failed to report changes. Right, because it's 100? Okay, it's 100, yeah.
So, Mr. Nassif, is that your motion, or do
That's
you have
in
any other,
$100. for failed to report.
any other comments, discussion?
I'll second.
All right, so we have a first and a second. Any further discussion?
And this is to the permit holder.
That's the permit holder, yeah.
All right. All in favor, please say aye.
Aye.
Any opposed? Nay. All right, motion carries. Welcome back, Ms. Walmsley.
Thank you.
Thank you.
Madam Chair, I believe Ms. Sosi is online.
Oh, terrific. We'll go back to item 20D. Elvira Sosi, if you could please introduce yourself for the record.
Oh, okay. Can you hear me now?
Yes, I can. If you
Hello?
could please introduce
Okay.
yourself.
My name is Elvira Sosi.
Welcome. Ms. Brown, if you could give us a summary, please.
Certainly. Jenica Brown, Executive Assistant to the Deputy Director. Elvira Sosi was issued an Arizona Pharmacy Technician Trainee registration on May 14th, 2024. Her registration expires on May 31st, 2027. It is currently suspended. On or about February 3rd, 2025, the board received a notification from a physician who expressed concerns that Ms. Sosi may have been intoxicated at work. Staff subsequently opened a complaint against Ms. Sosi's registration to investigate the allegations. Ms. Sosi responded to the complaint and asserted that she was not impaired while working. Her response is included in the board's files and contains information that raised concerns about her ability to safely practice. On February 26, 2025, an interim order was issued to Ms. Sosi, which required her to undergo an evaluation with a provider pre-approved by the board within 60 days. After a series of emails between Ms. Sosi and staff, an alternate provider was ultimately approved for Ms. Sosi to undergo the required evaluation with, as staff believed at the time that the confirmation that was received regarding the evaluator's ability to comply with the requirements of the order. On March 20th, 2025, staff received a notification from the provider indicating that Ms. Sosi rescheduled her appointment several times and that she arrived at her intake appointment with a positive breath test for alcohol. She was given a ride to urgent care with a recommendation for further treatment. Staff contacted Ms. Sosi with options for her to enter into an interim consent agreement for interim suspension of license or enter into a consent agreement for voluntary surrender. Ms. Sosi responded to staff and indicated that she was going through personal difficulties. After a series of emails back and forth, Ms. Sosi submitted her signed interim consent agreement for voluntary suspension of license. The board considered and approved Ms. Sosi's interim consent agreement during the April 2025 board meeting. It was executed on April 23rd, 2025, and required Ms. Sosi to undergo an evaluation with a pre-approved provider within 30 days. On May 27th, 2025, staff contacted Ms. Sosi to follow up on the evaluation, as she did not contact staff with the name of her evaluator and the date and time of her evaluation as required by the interim consent agreement. Ms. Sosi responded and indicated that she was on her second week of outpatient services with the provider that she was initially supposed to undergo the evaluation with. Staff asked Ms. Sosi if she underwent the evaluation and to provide the name of the evaluator. Ms. Sosi responded yes and okay. Staff communicated with the provider that Ms. Sosi was initially pre-approved to undergo the evaluation with. However, staff was not able to confirm that she underwent the specific evaluation that was ordered in her interim consent agreement, nor was staff able to confirm whether Ms. Sosi provided them a copy of her interim consent agreement. Documentation received by the provider did not demonstrate that she underwent the required evaluation and did not opine on her fitness for duty as a pharmacy technician trainee. On July 10th, 2025, staff contacted Ms. Sosi and explained that the documentation from the provider did not contain the information that was requested by staff and required by the interim consent agreement. Staff advised Ms. Sosi that before the board could consider her matter, she would need to undergo an evaluation to determine her fitness for duty as a pharmacy technician trainee. Staff provided Ms. Sosi the list of pre-approved providers and requested that she supply the name of the evaluator she wished to undergo an evaluation with by July 25th, 2025. In several email exchanges, Ms. Sosi ultimately requested an extension until August 15th, 2025. Staff granted her request. On August 8th, 2025, Ms. Sosi contacted staff and requested a phone call to discuss her case and the list of pre-approved providers. Staff spoke with Ms. Sosi on the phone on August 14th, 2025. During the call, Ms. Sosi expressed a desire to comply with the interim consent agreement, but indicated that she was having trouble finding an evaluator that she could afford. Following the call with Ms. Sosi, staff attempted to obtain a list of evaluators who may be able to complete an evaluation at a reduced cost. However, an alternate provider who approaches costs differently from the existing list of pre-approved evaluators was not identified. Staff followed up with Ms. Sosi in an email on September 8th, 2025, and requested a response on how she wishes to proceed in this matter. Ms. Sosi was given the following options to move forward. Select a provider from the pre-approved provider list and undergo the required evaluation. Select an alternate provider of her choice for consideration who is qualified for and experienced in conducting the evaluation that is required by her interim consent agreement, or enter into a consent agreement for voluntary surrender of registration in lieu of further administrative proceedings with the board. Staff did not receive a response from Ms. Sosi by the deadline provided. A follow-up email was sent with a deadline to respond on September 18th, 2025. Ms. Sosi responded and requested another extension for personal and medical reasons. This matter is before the board for discussion, consideration, and possible action regarding Ms. Sosi's noncompliance with her interim consent agreement and her request for an extension to complete the required evaluation.
Thank you, Ms. Brown. Ms. Tosi, would you like to address the board?
Sure. I am currently not employed, and I did contact the list of providers that was provided to me by the state board. And however, they don't take access. I only have access health insurance. And they charge by the hour, and they're not cheap, and I can't afford it. I can barely even afford rent with my kids. So I can't, and I did attend Aurora Behavioral Health, and I completed that program back in August. But I don't know, I'm just out of options. I don't have the money for those pre-approved providers that I was given.
Ms. Tosi, would you be willing to consent to voluntarily surrendering your registration?
I've been thinking about it, and it's my field of study. You know, I've always been interested in pharmacy, and just so you know, I was not drinking on the job. Never have, and I never did. And that's, I did. I was at work on, let me see, February 3rd. I went to work and I wasn't feeling good, so I left work early. And there's a QT right there, with the bus stop right there. That's when I obtained my drinks. I did not drink on the premises. I did not drink, on the job, nothing like that. And around that time, my mom had fallen ill, severely ill. And then, so I had to put off all of this stuff because she passed away in March in hospice. And as far as my recent deadline, back in September, I fractured my ankle in August. My right ankle. I had to have surgery on September 17th. And I've been in a lot of pain and just frequent doctor's appointments. So that's where I stand. And right now, I currently have my kid's father is in critical care. He's in the ICU at one of the Better Boswell locations. And he was flown out last week. So we've been going back and forth every day to see him, and there's no sign of improvement.
Thank you, Ms. Tosi.
Mm-hmm.
Unfortunately, I don't know what more time is going to do for her, is kind of where my head is. We've offered her the best resolution that we can, and we have people see a board approved evaluator for a reason. I don't know what more time is going to do. I understand and I'm sympathetic to the situations that she's had, but this has been going on for a number of months. We've already given her one or two extensions. Thoughts, anyone?
I agree with you. I was thinking the same way. Like, just giving her more time, I don't think that will help the situation. But I wonder what options do we have here in this case?
Ms. Galvin?
You can refer the matter to formal hearing for revocation, failure to comply with the board order, or alternatively, accept a consent agreement for voluntary surrender.
If she were to complete it in the interim, then we could consider that at the hearing, right? Okay.
I'll make that my motion.
I'll second.
I have a motion and a second. Any discussion? Do we need roll call for that?
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Park,
Aye.
Mr. Hogan,
Aye.
Mr. Al-Nassif,
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair, 6 and 3 absence.
Thank you, Dr. Gondry. Thank you, Ms. Tosi, for being present.
Here, can you, I can't really hear, what was
Staff will
that?
be in communication with you probably early next week on where the matter stands.
Okay,
Thank you.
all right, thank you.
21B, back to conferences. This is for Covetrus North America. Covetrus. Covetrus?
It's Covetrus.
Covetrus, thank you.
Thank you, Tamika.
If you could please introduce yourself for the record.
Yes, good afternoon. My name is Tamika Simmons. I am Chief Compliance Officer and Regulatory Counsel for Covetrus.
And you also have Susan Trujillo from Corals and Brady.
Ms. Galvin, any questions around the comment that she's counsel?
I do not have any questions.
Okay. Chirag, if you want to give us a summary, please.
Sure. Compliance Officer Chirag Patel with the Arizona State Board of Pharmacy. This is a complaint whereby a wholesaler introduced misbranded drugs by shipping them directly to the consumer end users without adequate labeled directions. So the board office opened a complaint number 24-0359 against Covetrus North America LLC, who pled guilty in the United States Court of the Western District of Virginia to introducing misbranded drugs into interstate commerce between March 2019 and December 2021 from its wholesale locations directly to consumer end users in violation of 21 USC Section 331 and 352 due to lack of adequate directions for use. Furthermore, ARS 32-1983 allows Covetrus North America LLC, a full-service wholesaler, to furnish prescription-only drugs to a pharmacy or medical practitioner, but not to the consumer end user. According to the response provided by Covetrus, they have already resolved a criminal investigation conducted by the United States District Court of the Western District of Virginia for introduction of misbranded prescription veterinary medication. They agreed to pay the federal government in excess of $22 million and pay $1 million to the Virginia Department of Health Professions for its assistance to the United States during the investigation. Covetrus further acknowledged that Covetrus shipped prescription-only veterinary medications from their wholesale distribution centers to locations that were not authorized to receive them. All veterinary prescription drugs must be dispensed either by a pharmacy pursuant to a valid prescription issued by a veterinarian or dispensed directly by a veterinarian. Covetrus provided a list of prescription-only drugs shipped into Arizona by their wholesalers, which were directly shipped to consumer end users. The list indicated that there was about 700 products, mainly shipped from two wholesalers, one in Visalia, California, and the other one in Fort Worth, Texas. These products were mainly shipped to unauthorized locations in Marana and Santan Valley, Arizona. The products shipped to these locations did not have adequate directions of use by the consumer end user. Thank you.
Thank you, Mr. Patel. Ms. Trujillo or Ms. Simmons, would you like to make any comments?
Yes, Ms. Simmons will be making a statement.
Thank you. And as Mr. Patel said, throughout the investigation with the Western District of Virginia, Covetrus did fully cooperate with the U.S. Attorney's Office. And in resolving the investigation, we agreed to pay the government $22 million, with $1 million going to the Virginia Department of Health Professions. We were also eligible for a 1 to 3 year probationary period. We were sentenced to a 1 year probationary period, which we successfully completed with no additional action by the government on May 8th, 2025. And with the board's indulgence, I would like to go over some additional remediation efforts that Covetrus has taken since this time. We have implemented a large animal pharmacy. So from 2019 to 2021, the time period for which the plea applies, we began development of our large animal pharmacy program. And as of today, the large animal pharmacy is active in all states with the exception of Hawaii, and that is purely due to lack of demand in that state. And this program allows Covetrus to comply with all state and federal laws regarding the labeling requirements. In addition, using the analysis from the DOJ's prosecution of Covetrus, we reviewed and corrected, with the help of external consultants, our software rules that were previously allowing for the erroneous shipments. Furthermore, while our previous process had been largely a manual one, in 2024, we implemented a new state-of-the-art customer enterprise master data management system that's called STIBO. And as a result of using STIBO, we were able to enhance our regulatory compliance by offering an improved integration with MedPro, which is a real-time DVM license verification platform, and also integrates with DEA licensor verification sites. And this process supports the accuracy of all of our licensing information and consequently our shipping information, and make sure that we are up to date on any changes in the DVM licensure. It also allows us to have automated rules for distribution and shipping following all state and federal regulatory guidelines. Finally, we have revamped our compliance committee to include a dedicated section in each of our compliance committee meetings that fully reviews compliance with all applicable national, state, and federal laws and industry codes. And to further aid in the compliance, we also have a dedicated section that looks at our compliance with the Food, Drug, and Cosmetics Act, as well as our state law shipping requirements. And I should also note that while I had previously been regulatory counsel, as a result of this overhaul of our compliance team, I had stepped into the role of Chief Compliance Officer in 2024. And I'm happy to answer any additional questions.
Thank you, Ms. Simmons.
And just as two quick notes, if I may, just for clarity, the sales were made to licensed veterinarians. It's simply that the shipments went to, stables and I think in the Ironwood Pig Sanctuary at the request of the veterinarians. So just in case that wasn't clear from the materials, the sales were made to vets. It's just that the shipments went to locations where the vets wanted them to go. Though Covetrus understands, and the settlement with the DOJ was about the fact that those shipments shouldn't go to unlicensed locations. Also, as Inspector Patel pointed out, the respondents, the caption in the case names basically every current license that Covetrus holds with the state of Arizona. There are only a few that were involved in the shipments that were identified during the investigation.
I have a question about the shipment. So it was the invoice was charged to a licensed veterinarian, and then the veterinarian sold the prescriptions to another entity?
No, they ask, oftentimes like these are large volumes of product that the veterinarians are purchasing, that they'll go, to the stable or to the pig sanctuary to administer. But, they, in some situations would have asked, the wholesaler to ship it directly to the stables or directly to, that animal care center, just so the veterinarian isn't, getting it delivered to his or her office and then driving it to that location. So I just wanted to clarify that the sales they weren't selling directly to those end users. The sales were to the vets, but the vets had asked for those shipments to go to the location where the vet was going to administer those medications.
What was the agreed upon quantity of prescriptions or prescription-only products sent from the Visalia and Fort Worth locations into Arizona? Did you say 71?
So about 700 products,
100 products.
approximately. And these were products received directly to consumer end users without any kind of labeling on it. But it's ordered by the vet, it's paid for by the vet, I'm assuming, but shipped directly to the end user without any labeling or directions of use.
So not for administration by the vet, for home use?
No, it's not. So in the example that Susan was referencing, so the Tortolita Veterinary Services, if I am a DVM, I have an office location in Phoenix, but I also service the pig sanctuary in Tucson. Instead of having those drugs sent to my office, they were shipped to that particular sanctuary in Tucson. So paid for by the vet, the bill to account is the veterinarian. And in the spreadsheet that we did provide to the board, you'll see that the veterinarians' names are referenced in each of these purchases.
Maybe to answer your question, I don't know whether the end user was the one administering it or a veterinarian came over to administer it to the animal.
Do we have any history of per unit item for misbranded items being shipped into the state?
It just seems like a $22 million fine is pretty significant. Obviously, this is unpermitted activity, but the scale of it must have been quite large.
So that was outside of Arizona. I mean, that was, Arizona and other states that were involved.
Arizona was just 700 shipment to Arizona.
Yes, that's the Arizona portion.
And we just say it is misbranded because it has no direction. Like,
Exactly, has no labeled
yeah, that-
directions of use.
But we don't know if the vet who administer this treatments or the consumer themselves.
Exactly.
There's no evidence for that.
There's no evidence of that. And we don't know if the veterinarian gave directions to the patient or end users or animal keepers or not. I don't know that.
And this activity was, 2019 to 2022. So, like the timeframe is
So-
a while ago.
I'm sorry, I'm just trying to think out loud here. So the vet office address is in the invoice, but the shipment address to consumer address.
Correct. Which is, something
It's
that
like bulky items, they cannot have it in the office, right?
right. Right. I mean, that is an example.
Yeah.
This is going way back in the archive of my brain, but I remember there was a case that we had where there was an internet pharmacy selling ciprofloxacin to people that were marketing it for fish, something like that. That's the only
Oh,
that I can think of.
Yeah, I think,
Similar.
yeah, it was a wholesaler it was Zitromax, I believe. Yeah.
Sorry, azithromycin, not
Yeah.
ciprofloxacin, but
But there was-
it was during COVID.
And Mayor, if I could also point out that among the line items for the 700, it also does include over-the-counter products as well.
Do you remember what we did with that case? I don't remember. I remember. I agree with you. This is a huge settlement agreement, and I don't think we can do nothing.
What about if we mirror what Virginia did, which is a 1-year probation? They also got a $1 million fine, but
How many items shipped to Virginia?
We have no way of knowing how many items shipped to each of the states that were involved in this settlement. The government never disclosed to us which of the shipments that we sent to them, and there were many of them, were erroneous.
Don't you have the data on who you shipped to?
We
Don't
do
you-
have that data, absolutely, but it covered 21 separate states. Arizona was not inclusive of that 21 states originally.
If I may, they provided us with a list of every drug that they shipped into Arizona, and that's where I came up with the 700 shipment number from. Each
Were you-
drug and where it went and who it was sent by. And that was supplied by Covitris. And most being prescription-only items. Few were non-prescription, but most of them were prescription-only items.
So all of them prescription only items? Yeah.
Most of them.
Most of them, okay. So
I don't know how familiar you are with veterinary medications and if you're able to tell on that list of 700 if they're the types of veterinary medications that are administered by a vet versus like chronic daily treatments that would be inappropriate to not be labeled for adequate directions for use.
So most of them look like common human use prescription medications. So they do require directions.
And to clarify, there's probably a good 80% of drugs that are available for human use that are also for use in animals as well. Covetrus only sells drugs for animal use, not for human use.
Yeah, my question was mostly about whether they were chronic therapies versus something that would be administered by a veterinarian.
So here's some examples. A lot of antibiotics like clindamycin, rifampin, doxycycline, gabapentin, prednisone, more doxycycline, sucralfate. Those are the kind of medications. So a lot of antibiotics and steroids too.
I wonder why Virginia settled with $1 million, Virginia, but
So the Virginia settlement was for their assistance in the investigation. It was not as a result of the shipment into their state.
that's
Because has Covetrus been disciplined for this activity in any other state?
It has not.
so in the case like somebody shipped to Arizona without the license, our fine is $100 per item. Is that right? So I don't know if that can be if we can apply the same fine to this case, like with the equipment. So
that's a little different.
yeah, I know
These
difference, but we
people
don't have
had
the, yeah.
a permit.
Yeah.
But they just shipped it to the wrong location, as opposed to what you're explaining is they were shipping without a permit entirely.
Yeah.
So that's very
It's
different.
less severe than I mean we cannot say it this way, but
I'm kind of leaning towards let's do like an administrative fine for the labeling
Yeah.
violation for the locations that
I
where it
totally agree.
occurred. What's our maximum? 5,000?
Yeah. I believe this.
I don't know that we need to go to the per item level, but I definitely think we need to put something on the books. Is where my head is.
That seems reasonable to me, and they've obviously invested a lot of time and energy into, ensuring that it's not going to happen again. I mean, it just seems like they're doing all the right things, and based on what I've heard today and what I've read.
I totally agree.
So I would be in agreement with that.
And I support that.
Is this disciplinary or non-disciplinary civil penalty?
We already have discipline.
I was thinking disciplinary and doing it. I mean, this isn't an administrative violation. This is a labeling violation, in my opinion. But I was thinking disciplinary. I don't think this falls in our non-disciplinary categories, unless I'm incorrect here.
And it's for total $5,000 to be paid in what period of time?
But we need to address both permits, the Texas permit and the Visalia, California permit.
Is 5,000 for each
Yeah, I think,
permit?
I think 5,000 for each permit is where my head is. And dismiss the others. Thoughts, guys?
I mean, I'm in favor of this, you know, like, I was thinking $100 per item, so $70,000. This, I believe you are really more appropriate with what you're thinking. Like 5,000 for each
For the two.
location, for 2 locations, and that would be disciplinary, fine. How Mrs. Garvin, how can I make a motion for this? $5,000?
My understanding is that this would be a disciplinary order for civil penalties for failing to comply with the labeling requirements, $5,000 each for the 2 permits.
Yeah.
And dis-
To
and
be
dismiss
paid
the other
within,
two.
yeah,
The
and
other-
dismiss the rest, yeah.
So moved. Do I have a second?
So that's mine.
Any further discussion? Dr. Gandhi, roll call.
Thank you, Madam Chair. Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Park,
Aye.
Mr. Hogan,
Aye.
Rel Nassif,
Aye.
Mr. Anderson.
Aye.
6 ayes, 3 absent. Madam
Thank you, Dr. Gandhi. Thank you, Ms. Trujillo. Thank you, Ms. Simmons.
Thank you.
Thank you for your time.
We'll go to 23B, discussion, consideration of possible action regarding Jonathan Michael Espinosa's request to terminate probation. Is Mr. Espinosa present?
Yes, I'm present.
If you could please introduce yourself for the record.
Yes, Jonathan Espinoza.
Welcome. Ms. Brown, if you can give us a summary, please.
Certainly. Jenica Brown, Executive Assistant to the Deputy Director. Jonathan Espinoza was issued an Arizona Pharmacy Technician license on January 22nd, 2013. His license expires on October 31st, 2026. It is currently open and on probation. On or about January 11th, 2024, the board received a notice from the Arizona Department of Public Safety indicating that on or about August 27th, 2023, Mr. Espinoza had been arrested and/or fingerprinted for a misdemeanor DUI. Mr. Espinoza failed to disclose his criminal charges to the board within 10 working days. According to the police records, Mr. Espinoza was the subject of a traffic stop on August 27th, 2023. During the stop, officers detected the odor of intoxicants coming from his vehicle. Mr. Espinoza admitted to having a few beers and was subsequently arrested for driving while impaired. A blood draw yielded positive results for alcohol and positive for a metabolite of THC. On or about January 4th, 2024, Mr. Espinoza was convicted of DUI. On April 24th, 2024, the board issued an interim order for substance use evaluation with fitness for duty component. Mr. Espinoza completed the evaluation as ordered and subsequently entered into a consent agreement for probation of license with monitoring, which was executed on August 23rd, 2024. The agreement placed Mr. Espinoza's license on probation for a minimum period of 1 year and required him to enter into a rehabilitation and monitoring contract for the entire term of his probation. Mr. Espinoza entered into a contract with Community Bridges on August 28, 2024. On September 5th, 2025, Mr. Espinoza contacted board staff and requested an appearance before the board to request termination of his probation. On September 8th, 2025, staff received a letter from Community Bridges endorsing his request. Mr. Espinoza is in compliance with his consent agreement, and there are no concerns from staff.
Thank you, Ms. Brown. Mr. Espinosa, would you like to address the board?
I guess just the only thing is that I thank you guys for allowing me to practice while being on probation and allowing me or considering this for me. Thank you.
Board members, any questions for him? Discussion?
It seems that he's been in
He's
compliance
compliant.
and
Aye.
so I would move to accept his request to terminate his probation.
I second.
A motion and a second. Any discussion? All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Thank you, Mr. Espinosa. I'm glad to hear that you're doing well.
Awesome. Thank you, guys. Have a good day.
All right, that takes us to Dr. Gandhi's report.
Just getting ready, Madam Chair. Madam Chair, my report, 24 AI, discussion, consider possible action on complaints dismissed through executive director authority. 11 complaints were dismissed through the executive director, and you can see the itemized list of the reasonings why they were dismissed. Customer service seems to be leading the pack in that category, where a staff member, pharmacist, or technician may have treated a customer poorly. That's customer service. We get a lot of those based on the interaction, and who knows how that transpired, but we end up getting a lot of those complaints where they should really be going to corporate to manage those kind of complaints. We also get a lot of professional judgment complaints, whereas a pharmacist make a decision to not fill a prescription, particularly controlled substance, based on what their finding is in a CSPMP database or the history of use and so forth. So you see those numbers there. Non-disciplinary orders for civil penalty, we issued 6 from the last board meeting. I think a lot of those are focused on more administrative type activity versus something that would endanger the public, because that escalates to a different level. The next agenda item was what kept us busy for a little bit with the nationwide movement on immunization and position that the federal government was taking. So we were kind of tapped on the shoulder by the governor's office and Department of Health Services to work with them to create a protocol. And then, of course, an emergency rule writing session took place. So first of all, I'd like to thank Chirag and Ram for their tireless efforts. And this, I think Ram went on a crazy spree of not sleeping, showering, or anything of that nature, and focused on his project. So I think a lot of effort has been put on this project, and came together where DHS really appreciated our effort. But with the emergency rule writing taking place and it being approved and signed into a temporary law, we have to start moving forward on making it official. And in your packet, you'll see a package with a slight modification. I think with the speed of light movement that we were doing, we identified an oversight of on a prescription order, a pharmacist can go down to 3 years of age. And we're defining standing order to be a prescription order now. So the original emergency rules package indicated 6, but you'll see an adjustment in this normal rule package down to 3. DHS also recommended that we expand the standing order beyond just their authority, but the county and Indian tribal lands and stuff like that. So you'll see that adjustment. So I'll open it up for discussion. Obviously, we do need to move forward with that. So the next steps would be hopefully your approval to move forward to public comment on this process. We do have governor's office's approval already to move forward. Once we get public comment and receive all those, and we'll evaluate that and then get the governor's final approval to move it to GERC. So I'll open it up for discussion.
Any discussion, or do we have a motion? Makes sense to me from.
Absolutely.
I received information from the California State Board of Pharmacy, and they're also at 3 years. So that kind of corroborates that a little bit.
So just for clarification, so they can administer vaccine or COVID vaccine 3 years and older, right?
Using the
For now.
standing order.
Using the standing order.
Using a standing.
That's for pharmacists, including pharmacists.
Yes.
If we change the rules, because
If
right
we
now the
change-
temporary rules say 6.
Yeah. And
Not right now.
And just to give you an idea of the time period, so this normal rule writing process is going to take a little time.
Okay.
I would probably say an estimate of 5 or 6 months.
So we need motion to moving forward.
Send it forward for public comment.
Public comment.
The motion would be to approve the language that's in your board book and move it to public comment.
And that's my motion. Yeah.
Do I have a second?
Second.
Any discussion? All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Rom, thank you for your work on this. We appreciate you. The citizens of Arizona appreciate you. Thank you. And Chirag.
And
You're-
Mr.
Who was the one that you said wasn't sleeping? So
One of those.
Rom wasn't.
Yeah.
So
Yeah. Ms. Galvin, was there anything else on that to make it official?
No, I think you're good.
Okay. So that was 24, A3 and A4. So I just talked about it all in one. We'll save the juiciest one for the end, Madam Chair, if that's all right, the A5 discussion.
whatever you'd like. We're still going to talk about it today. So
We will. The next one is related to Senate Bill 1372, and that topic is about public records request. So we had to modify our form to incorporate whether this is going to be used for a certain purpose or not. I think it's for commercial use. They have to identify whether it's going to be for commercial use. And that's the end of it. I think if they identify it's for commercial use, I don't know what the next steps are other than us collecting that data. Was there another part to that story?
No, and that's what's confusing.
Yeah, so it was a little confusing about an extra data point that we had to capture, and that was the end of the chapter. So just informational more than anything. Next agenda item was related to HB 2173, and that's related to mental health inquiry prohibition. So we did modify our applications to comply with this, with the new law that kicked in about mid-September-ish time period. So updated our online applications, paper applications, renewal applications. So I think we are in compliance with that question now. Any thoughts, questions?
I'll just say that I read some of Hannah's emails, and she was very effective at getting responses in timely fashion. So I appreciate that.
Sometimes it just requires a little light under a fire under some people, right? So no, we're grateful that Hannah has a unique way of communicating some of those messages. Next agenda item. So I've had the pleasure of attending the district meeting in St. Louis this past October 5th through the 7th. With me, of course, Ms. Wamsley was there. Jennifer was there, and we had Truman as well as Chirag present. Meeting went really well, successful. Good topics. I don't know if you want to share the meat and potatoes of what we talked about, but
I'm happy to.
please,
Or we could call one of the inspectors up
we could.
because that would be fun. No, I think overall the topics were really relevant and good. I did speak around kind of innovation in pharmacy practice and my day job capacity around some of the trends and innovation. Was on a panel with a couple of other board members. There was some talk about healthcare literacy. How different states are approaching labeling, some of those kinds of things. There was a lot of discussions around enrollment trends, nothing that is, I feel like, different for Arizona than we're seeing in other states, but nevertheless, there were some good data points provided around that. I missed the afternoon sessions around payment reform, so I don't have anything on that. And then Mr. Trujillo did a case law update on just some hot topic cases across the country. And then there were some hot topics discussions, but overall, I thought it was a good meeting. District breakout was pretty good. We did have a close call on some quorum issues, so we're going to look at the district bylaws to see if we need to make some changes. And then I guess the other piece of it is Dr. Gandhi is moving forward with his nomination as secretary or treasurer of NABP, and I am the executive committee nominee for District 8. And the election will be held in May.
I think some other topics worth noting is Drug Supply Chain Securities Act was talked about and how that's playing a major part in many states. I believe we're leveraging it here too. And I think one final subject worth mentioning is the MPJE versus the UMPJE, where I believe our laws are already in alignment if we were to pivot to that way of thinking. That is supposed to roll out sometime mid next year. So some exciting things are coming, where then licenses can fluidly move across state lines. Better than they do now, right? Without the bumps. The one thought process I think they did a phenomenal job with coming up with this UMPJE is they've kind of compared all the states and took commonality laws throughout the states, and that's going to be part of that, not just the federal law, but there's going to be state law incorporated, but it's only going to incorporate the common laws across all the states. So that takes a lot of effort. Truman, Chirag, any other thoughts from you guys?
No, but we do want to say thank you for the board for allowing board staff to attend some of these meetings and hear about some of the hot topics. Maybe the last highlight that was on my mind, heard a lot about standard of care, standard of practice, potentially thinking about regulatory framework that might allow pharmacists to practice at their full capacity based on training, education, experiences. So I thought that was an interesting subject as well. Thanks.
Good, all right. Next topic, the Auditor General, I'll kind of hold off on that as well. So I will come back to the last one on my list here before we get into the juicier ones are next year's board meeting dates. So you'll see the proposed dates in your board book for consideration, discussion. One of the topics that was brought up by the Auditor General, and we'll talk about that in more detail, was having a more frequent board meeting so that we can get to subject matter sooner than later. Right now we meet 6 times a year, and sometimes we have emergency sessions between those dates. Statutorily, we are obligated to meet 4 times a year, so we're already exceeding our statutory obligation, but they want us to meet every month, potentially. Maybe every day if it was really feasible. That's just my frustration coming out. I apologize, but meeting every month, obviously. I mean, we've already started working on the next book, which started maybe a month and a half ago, maybe 2 months ago. So it's a constant churn, right, to get prepared for the next. Having it monthly, operationally, doesn't seem feasible for our agency. And be counterproductive, putting us further behind on investigations, further behind on inspections, because we'll always be just preparing for the next board meeting. So I do have an operations background, and I don't think that would be operationally feasible. So we may adjust some timeframes behind the scenes to submit information. So that's an internal process that we'll manage, but for your consideration are the dates and deadlines in your board book.
Just a question, why is the October date highlighted?
That may be subject to move because October is when we have our district meeting.
Okay.
And we just posted the date, so you can actually take the highlight off because that would have been a little bit fluid. My ask is if you're good with the dates, we'll move forward with it, but put a little asterisk on they may subject to move based on other meetings.
Yeah, the I'm just gonna look at when the NABP, the district meeting is. I think it's that same week.
I thought it was a week before.
Hang on a second.
I think I have a picture of it somewhere.
I think I put it on my calendar already. Starts on the 18th. It's the 18th to the 20th is when it is. So we're okay.
Yeah.
It's just close.
Yes, with the asterisks that I've asked for.
So I move we accept the proposed board meeting dates for next year, subject to potential change.
I second.
Motion and a second. Any discussion? All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. All right.
And just a note, obviously, we won't change the dates until we present it to the board. And there'll be ample notice and ample time to have people make adjustments and stuff, so. So let's get back to 24A9, the Auditor General Report. There were recommendations made by them, 33 of them. This is a public report, so there shouldn't be an issue for us discussing it in open forum now. Some of these recommendations, Doug, if you want to step up too, because this is going to involve you. Some of the recommendations were broken up, so maybe, I guess, one recommendation, but then they got 1, 2, 3, 4 just to add more color, add more numbers to the equation, I guess. But some of it is, so let me back up. There's potentially 3 buckets. Things that we can fix, and then that breaks up into 2. Things that we've already fixed, and then things that may take time. And then there's things that in that bucket is not an unreasonable fix, such as doing inspections in 18-month turnaround. That's just not going to be possible with the manpower we have. And we've already expressed that to OSPB, the budget analyst, the governor's office, and so forth, as well as getting complaints adjudicated within 6 months. We do a pretty darn good job, somewhere about 70-75% adjudication within that time period, which is in alignment with 2 other states that have similar profiles that we do, which is Ohio and Virginia. So we're in alignment with best practices across the country. There's no way we'll get to 100% with the manpower we currently have. And you can see some of the complexities in the cases that it could take 3, 4, 5 months just to complete an investigation. Now we have to bring it together, digest it, so that we can present it to you in a reasonable, comprehensive way so that you guys understand it. And that all takes time. So some of the most egregious cases could take a year to investigate. And if legislators have it their way, those egregious cases would then be dismissed. If historically they've had some bills proposed that anything beyond a certain time period would automatically dismiss. They failed, but that is a concern that may happen again this legislative session. Second budget is things that require an IT upgrade for us to comply with a lot of those things. Today we track things manually. We retrospectively track things or look at things. But if we had an automated process where it triggers certain things about closing an application after a certain time period, right? That's an automatic trigger versus a manual process because things could be overlooked. Communication back and forth with an applicant, because every time we ask for something, there's a timeout period. It could be an hour, it could be a day, it could be 5 days. But every time we communicate and ask for information, there is that timeout period that we are afforded because the ball's not in our court anymore. So some of those things, if we can internalize it in the database, it could track and trace it and give us a more definitive time period on when an application is supposed to close. Or when we present it to you guys and say, hey guys, this is the day that you have to make a decision. Otherwise, this could happen. So some of these IT fixes will fix some of the recommendations. And as you guys know, we had partnered with a vendor. 18 months later, they still hadn't produced anything. So we severed our relationship with that vendor. We recollected about 70, I want to say about 75% of our spend with them. It was a push and pull argument. So we had a settlement agreement and recollected majority of our fees that we had paid them. So that was a victory, but now we're back on the market to look for another database vendor so that we can get compliant with some of those deficiencies that were identified. The third bucket requires legislative adjustments. One being pharmacists, for instance, checking the CSPMP. Right now, there's no possible way for us to track a pharmacist checking the CSPMP because there's no unique identifier attached to the pharmacist. There are for physicians and prescribers because they have a unique DEA registration. Pharmacists don't have that. So we have license numbers, but you also have to keep in mind license numbers vary from state to state. So how do we have a uniform process on what to report and so forth? NPI number was a hot topic when I first graduated many moons ago. That kind of dissipated over time, but it's still out there. But we don't mandate the requirement to have NPIs for pharmacists. So the discussion is going to have to be how do we move forward with tracking a pharmacist, checking the PMP. And I'll let Doug dive into some of these CSPMP opportunities. So Doug, I'll let you take it over.
Good afternoon, board members. Like Dr. Gandhi said, there's certain requirements to be reported to the PMP, and there is no requirement for an identifier for a pharmacist. Dr. Gandhi brought up that there are challenges with out of state and not knowing all those license numbers and so forth, but we know that about 98% of all controlled substances that are being dispensed to Arizona citizens are coming from Arizona pharmacies. So if we used a license number identifier to be reported to the PMP, we'd be able to do a heck of a lot more than we do today, which is nothing. So the question really is, do we want to require a pharmacist identifier to be reported to the PMP? If that answer is yes, we would want to look at how we want that language to read on which pharmacist identifier, which pharmacist should be, quote, the pharmacist of record. Because as we know, a lot of times there's more than one pharmacist involved with the dispensation of a prescription. Initial thoughts from me would be let the company decide who that pharmacist of record is and make sure that you report that identifier, because that would enable me to go into the data and see that there was truly a query by the pharmacist of the identifier report to the PMP. I don't know how else to do it because every business has different workflows. But if you report an identifier, the identifier should match a query in the PMP. So I'm going to stop there because I imagine there's some questions.
It's not a question. Thank you very much for working on this. I know it's hard work, a lot of thoughts there. Me, just I like to add this comment. I mean, to me, I would see more appropriate for who verify the products before leaves. That's who should be reported. That's me, my perspective. But different business has different workflow, so you cannot determine really. So I agree with you, and this is gonna be a long discussion here.
Yeah, I think the question we have today would be, we're not going to have another board meeting till December. If there's going to be bills run looking for any type of legislative type changes, I need direction.
Do we need to get feedback from industry?
I think that's up to you guys. Without a doubt, we know that everybody has a different workflow. So
I don't know the level of technical detail that this is going to require to be in compliance. No other state has been able to do this. So I am worried about what that is going to look like when the rubber meets the road for businesses, right? And I don't want to craft it in a way that we're setting people up for failure for compliance. So
makes sense.
Is it something you could do under a pilot scenario? Do you think that would be effective, or what are the pluses and minuses of doing it in that way?
I'm assuming that from a pilot, there'd be volunteers to submit this data, because without the data coming in.
Yeah, I think you
Okay.
ask everyone to submit it, but because it's a pilot, you have the structure to begin a dialogue with industry and try to resolve some of the biggest items right off the bat. In other words, people don't get penalized initially.
would we
because it's a pilot.
would we be able to do a task force or something like that and invite some industry stakeholders, maybe somebody from Bamboo and then some of the larger organizations, obviously the Pharmacy Association as well, to make sure we get kind of just broad perspectives.
And would we be shooting to make that happen?
I think we would
As soon
need to
as
probably do it pretty quickly, because
Yeah.
what's the deadline to file a bill unless we can file just a placeholder?
And then would you have some recommendations of who you'd want on that task force? It should be data submitters,
Yeah.
Like,
Like I'm thinking like people that are like responsible for the PDMP, like for my company, probably Stephanie's companies.
Also, I can be responsible for my company.
Yeah, I'm sure we can pull together some suggestions. And then obviously if there's members of the public that would like to participate, I mean, I would welcome what that would look like. But I think we probably need to do it pretty quickly. I don't know what the legislative deadlines are.
And if you're okay with that, I can bring some IT, like from our company,
How
and he's a
does,
pharmacist and IT at the same time. So
maybe mid-December or mid-November work. Just look at your schedules and we'll talk.
and it will be virtual, right?
I'm gonna
virtual.
I'm gonna be out of town till the end of this month. So
Yeah, so it'll be as soon as you come back.
Yeah.
Last day to submit bill requests is February 6th.
So these,
So
what date was it?
February 6th.
Okay. I think we got a little time.
Pre-filing begins November 15th
November.
is pre-filing. So I don't know what your deadline is. Is there an agency deadline, Cam?
There isn't. We would just have to find a sponsor to run that bill.
Yeah.
So maybe we can start that ball rolling and let them know that we have a task force meeting coming up and this is what it may look like.
Sure. You okay if I keep going with?
Yeah. So we're thinking November, like beginning of November, right, to meet?
Maybe we'll even,
Before?
knowing we have a little bit more time, once I get back,
Yeah, you organize it. Yeah.
sounds good.
Thank you.
But hand in hand with, when we talk about requirements to be reported to the CSPMP, right now, some requirements are listed in statute and some requirements are listed in rule. And quite frankly, if you add it all up together, it still doesn't equal all the requirements that as far as what we have in our user guide is we have a dispenser guide, and that's what data submitters use to make sure they submit everything that's required. So our statutes, rules, data submitter guide all don't match. I think there's an easy way to try to fix that, and within the statute, we could point back to the dispenser guide as the requirements to be reported to the PMP. If we do that, then what we would make sure happens is any changes to the data submitter guide would need the board's blessing. But that's the best way I know to give the most complete view of or list of what data submitters need to submit to us. And I bring that up because it's all tied to the fact that we potentially would be asking for some new piece of data, which is that pharmacist identifier. So if we're asking for a new piece of information, it might be the right time to try to combine it all in statute appropriately. And I think it would help industry better because we just point back to the dispenser guide. So that would be an ask of if we run bills, are we in support of that?
That makes sense to me.
And then one of the recommendations in the Auditor General report asked the Board of Pharmacy to work with the President of the Senate, Speaker of the House, and the Governor to establish and appoint members to a working group to develop a strategic approach for identifying non-compliant prescribers in the CSPMP. As you guys know, we've been identifying non-compliance. We've been sending a list of around non-compliance. The auditors would like to see us do more. I challenged, well, what is enough? And they kind of pushed it back and said, well, we can't tell you that. So I said, well, how do we get there? And that's where this recommendation came from. I think there's a way to currently ARS 362603 is what establishes the task force meeting that the president of the board chairs, and I spend a lot of time talking about the work of the PMP. What's in 362603 is pretty outdated. It talks about help administer the computerized database tracking system to identify educational outreaches and support services to advance medical practitioners' adoption of electronic prescribing of Schedule II controlled substances. Well, we've adopted EPCS. Our states required prescribers to use EPS for Schedule II opioids since 2019. So I'm thinking that task force could be repurposed in a manner that instead of what I just read to you, that task force focuses on compliance. We would have to work with the House, the Senate, and the governor's office and let them help appoint the right members for that task force. I would hope that the board chair would still be the chair for the task force meeting. But it seems like it kills two birds with one stone by, number one, getting our statute to read the way that our task force is today. And our task force is pretty compliance heavy. And then second of all, we could reestablish a group that is truly looking to work on compliance. So if we ask for that change,
that would also need to go in statute, right? Because
that would
the
have to be a statute.
task force is in there.
Yep. So
Okay.
it would be changing 362603.
That makes sense to me. Any concerns, guys?
Finally, from the Auditor General's perspective, even with the non-compliance list that we do send to the other licensing boards, the perspective is nothing really happens. And they asked, well, what can you do? And I said, we're at the Board of Pharmacy. I have no jurisdiction over a prescriber's license. So my hands are tied. All I can do is send the information. They suggested us running a bill for a controlled substance registration. Some states have that right now. That registration, I think maybe a little less than half the states have it, maybe around 17 to 20, something like that. And you know, if the Board of Pharmacy issued a controlled substance registration to every prescriber, and that could go to wholesalers, distributors, pharmacies, that would be up to whatever we wanted. Some states require anybody that's handling controlled substances to have that controlled substance registration. But if we were the issuers, the logic was then we could take action on those controlled substance registrations. And if you don't have a controlled substance registration in good standing, it may impact your ability of right for controlled substances. So that's a big ask. You know, not only are we putting some more regulations, but we're also we're going to need more manpower to do that. You know, to issue all those registrations. There's 45,000 prescribers with active DEA numbers in Arizona. I'm sharing with you what the Auditor General shared in their report.
I'm less excited about that one, Doug. I mean, I think it's going to be in a lot of work for our board, and I wish the other boards would follow through on what you're already providing them. I get where the recommendation is coming from, but it is going to add a lot of work and a lot of extra administrative work for all of us in this room. And then obviously cost to the public. So,
Well, not only that, but I can foresee some serious unintended consequences that could result from this in terms of patient care potentially being affected in a negative way. You know, based on just providers trying to figure out, you know, what is really going on here. I think that one might have to be on the bottom of the priority list.
I mean, ultimately, you're going to have to find a sponsor for it anyways. I mean, I get that we're trying to ratify the recommendations of the audit committee. I just personally, I don't know that I think that that's the best use of the board's time. I certainly hope that that would come with additional resources for the staff. I think that there's things that are much higher on the priority list for us from a patient safety standpoint, and the other agencies can and should be using the information that you're using. But I'm not opposed to it. I'm just putting my concerns out there.
Dr. Gandhi, do you have anything else you want to add? I know you and I have talked about this quite a bit.
Yeah, this has been a challenge. We've been sensitive to the other boards about what they can digest as well. But it seems like the burden's falling on our shoulders, and the auditors want us to control the situation. And I don't know how to do it unless we go in that direction. We can't. I mean, Doug and I've even bluntly talked and says, just send a whole damn report to these boards and let them worry about it. Why should it be our problem, right? But we also want to play in a sandbox with everybody. So we know that they're struggling meeting the deadlines that we have as well. We have 18 months and 6 months and so forth set forth by the legislators. Best practice standards. Other boards are held to the same guidelines, and they just can't meet it. So
our agency is then going to have to deal with all of our stuff plus all of this other stuff.
And that's where if that, let's say the bill comes together and everything goes according to plan, we would of course request a whole bunch of manpower, because there's no way feasibly we're gonna be able to do that. I think you have 20 cases that you forward to the other boards today, correct? And
correct.
And when you have 20 cases and we're vetting those 20 cases before we send it to make sure that there's no exemptions and other stuff that are there. So we filter this information, and it takes 2 people 3 days,
2 days.
2 days, 2 full days to vet those 20 cases before they go off to the other board. Now think about thousands and 9,000, something like that is what you're indicating.
I am, yes.
Well, and then I also think about just even the administrative process to come up to like go through all of the registration process.
Yeah.
And then that's going to be additional cases that are going to come before us. And like, it's a snowball effect. Like we're basically taking on a whole potential extra enforcement piece if we want to do this.
We would meet every day. In essence.
Have just a question. So the top 20 that you send to the other boards, do we formalize those as complaints, or are they just sent as a spreadsheet and there's no action taken? How do they act on that information?
Yeah, the boards that are addressing it, the reports, they address it as if it's a complaint from us. Each one's individual, prescriber's name, number, a DEA number. We include things like how many prescriptions they wrote for opioid and benzodiazepines, which is what a prescriber is required to check the PMP for, and they have 0 queries of the PMP. And this list is where they have at least 50 prescriptions. We started, they had at least 300 prescriptions and 0 queries of the PMP. But all that is in an individual sheet that goes to the licensing board.
Thank you, Doug.
So when we have these discussions with the auditor and we explain some of the challenges that you guys are bringing up right now, that's not even discussed with the legislators. The only thing discussed with the legislators is the Board of Pharmacy is not doing enough to protect the public of Arizona. Period. And that's the picture they paint.
So I think I know the answer, but just to be on record here, we don't want to pursue a controlled substance registration right now.
The other option is we pursue it because there's going to be a strong pushback against it by the medical board, right? And let it fail, right?
You never even get a spot. You get more sponsors against it.
At least we can say we made an effort. Here's our effort. It didn't come together.
So
what
the, for anybody, so couldn't we do this next year? I mean, why do we have to do it now? We've got other things we're doing now. I mean, give it some time because we have other things we have to do. And, doing busy work doesn't make a lot of sense to me. So maybe in a year, there's a different opportunity to move something like this forward. And I don't think, well, I could be wrong, but waiting, it's not like we're going to put in the document we're waiting a year. We're just don't get going on it because we're doing other things.
Are the other agencies actually exploring these as complaints, or do we need to formally submit them as complaints? Because I don't know. Like, I feel like this is.
That's kind of what I was thinking. And that was I'm like, is that a happy medium? So we are showing that we are submitting formal complaints per prescriber with each board. And I don't know if that's a good happy medium.
We hold a quarterly meeting with the other licensing boards, but attendance is not super high.
I thought I heard you say last time that the auditors wanted you to send everything over there. I mean, I don't know how that jives with opening complaints. I mean, it's just unrealistic.
I would do nothing but just, I guess, write emails about complaints. Yeah, there's 9,000 prescribers that had 0 queries of the PMP.
I mean, I get where they're coming from. It's a problem. It's a problem that needs to be addressed.
And
however, I don't know that I think that responsibility lies with our agency. And that's my concern. Like, there's nobody that's going to go out there and inspect pharmacies. There's nobody that is going to do these other things that our agency is responsible for doing. I mean, granted, I would hope that we would get extra staff, but I worry about the fact that, like, are we taking our eye off the most important pieces, and should this be really going to the other boards? I don't know.
And also there is like more complicated because some of those provider maybe work in the federal facility, right? Some of them state. So it's
Our inspectors are going to have to go out and investigate all that, right?
correct, yeah, which is this make it very complicated. I mean, like, and time consuming.
And that was my comment relative to potentially adverse patient care. What if we decide, or some future board decides, well, we're just going to cut these prescribers off and they can't prescribe controlled substances?
Well,
That
in-
can have some very detrimental effects on patients.
I think it would put you guys in a tough spot at times with these cases.
Well, I mean,
So what's the appropriate way to proceed now? What, that's the question. Do we?
I'll go back to what my ask was, and,
Yeah.
and the ask is, if we need to run legislation, do you want us to run the legislation or no?
Oh, yeah, this will help. I mean,
I think there's another aspect to all of this too.
need to find sponsor.
That other aspect is that most of the other entities out there, boards, just don't have the staff. They don't have the budget at all. If somebody complains, they get to it. But their complaint level is extremely low. I've had this discussion at GERC more than once. And for them to handle it, it would be unhandleable. They couldn't do it. But that's a budgetary thing. We've got a budgetary shortfall. To me, this is all of that needs to be outlined and shown to the governor's office on what's there, and to the legislature, because that's the only way it's going to get resolved. We can do anything we want, but all we'll end up doing is looking bad, and so will the other entities out there, unless they understand that entire picture.
Correct. And with our current rules, who's the authority to enforce it? Is it Attorney General office or medical board or State Board of Pharmacy? Like in our statutes now, who is responsible or who has the authority to enforce these rules?
I think
Attorney?
I think that's the challenge right now, is that, we don't have authority over anybody other.
Attorney Bill doesn't have, no, but somebody should be listed as an authority to any, is that right? Like any law or for?
What they're saying is that we need they want the bill to give us authority over prescribers to
Yep.
be able to address non-compliance with this, because their respective boards are not addressing the information that we're providing. Is that a fair summary?
Well,
That would be a fair.
but what I'm trying to say, if we cannot run a new legislator, can we report to Attorney General office our finding and let them deal with it? Okay, this is what we find. Those like 9,000 prescribers now compliant with the state rules, and they let them reach out to medical board and the other boards. I mean, instead of like reach out to them directly, now the Attorney General office reaching out to them. That's how I see it for now, till we change something.
I mean, maybe we think about, like, is there a way that we can incorporate some sort of, like, can you incorporate some sort of an ask within the bill? Like, that if it does pass, because I worry that, okay, so say it does pass, we ask for the budget, there's no guarantee that you're going to get the budget.
Yeah, it would be an ask of manpower along with that bill.
Like, would we put it in the language of the bill?
I would like to, yes. I would figure out a way to do it. There's always a carve-out provision at the end of the bill. There's a language about if appropriately staffed, or some notation that we can work with the sponsor to put in there. Because otherwise, yeah, we're asking to fail, because if we don't get the manpower, we're not gonna succeed.
One of the concerns you're trying to address also in the same report is the fact that we're not handling complaints fast enough. But then we're going to have to handle complaints faster
Or other-
and also address all the other license
Other
stuff.
license stuff.
If you think about all the licensed applications that come before us. We're gonna have prescribers that have background check issues. We're gonna have prescribers that have past discipline. All of those people are gonna have to come before us.
I think the scope would have to be whether they're checking or not. It's gonna have to be narrow, and then the board can handle everything else. Right, whether they're registered or not registered, and whether they're checking or not checking. And those are the parameters that we'd have jurisdiction over.
But is it possible to just report those 9,000 to Attorney General office? They have authority over all rules in our state.
You know, why I hesitate on that is, you know, we talked about the double checking we do, because there's exemptions to checking the PMP. So
federal.
I don't really want to do that for 9,000.
And overwhelming.
You know, so we've been sending the top 20, the most egregious, if you will.
So what do you want to do, guys?
Whatever make it easy for our staff.
I don't know that there is easy in this,
So,
you know,
whatever
but
possible.
I needed to at least address what the auditor's ask was, and
So
we need motion for what?
I'm not hearing a lot of pushback from you two about potentially running a bill. I mean, it's gonna take your guys' time, probably more than your staff's necessarily. And if you're okay with doing that, then maybe we should try it. But if you're not okay because you have other things to do, then I would support not doing a bill right now, and let's do it later.
Not gonna do it, especially in the different board. So do we need motion like to move something or?
you know, I think what we will need is a sponsor, and I don't want Cam or myself asking a sponsor for something that the board doesn't want.
There's another thought in all of this as well, since the governor's got to sign off on whatever bill passes. And they have to, well, going back to what I said earlier, unless there's coordination effectively with the governor's office and the legislature on the budget, in a shortfall like this, there's no way they can come up with additional money, because you're creating you're in essence, at least doubling your staff here. And if we run a bill, which I think it would, I've always thought that the authority over pharmaceuticals should have been originally created into one entity instead of broken out everywhere. That's my GERC perspective. That you have to have that team to be able to do that and effectively do everything across the board. But with this budget, you just can't do it. So unless the governor is on board with the budget change and the legislature is on board, it's just a waste of time, in my mind. The first thing has got to be, here's the budget changes that have got to be made to go with this. Goes to the governor and simultaneously goes to the legislature, to the president of the Senate and Speaker of the House, and let them figure it out. Here's our dilemma. What do you want? Let them make that decision instead of us.
And that's our defense to not running the bill. We couldn't find a strategic priority to put it under from a budget perspective, and so we felt it wouldn't go anywhere. So
Have we entertained any discussions with the governor's office about this?
No, not at this time. This has to go through JLAC before we probably have that discussion with the governor.
We're going to have hearings.
So JLAC wouldn't happen until probably after the bill filing deadline, right?
It probably will happen sometime in November-ish time period before sessions kicks in full gear in January. So sometime mid-November to December.
What do you guys think about, we have our JLAC meeting. Take what we, maybe whatever becomes of the JLAC meeting, reach out to the governor's office, and then bring us back in December and cross our fingers and toes if we want to run a bill that we could find a sponsor. Because I don't know.
I don't know. I don't want to make it too complicated. I mean, do we authorize you to start having discussions and then in the meantime, we'll find out what happens with JLAC and
I think that would probably be prudent, yeah.
I mean, it's gonna take time. I mean, but I do think it's important to have the context, right? Because the bill is gonna just be, this is what the new requirement is. It's not gonna have all the context of the audit report and the discussion that we're having today.
I mean, as I sit here thinking about it, we haven't even drafted anything yet. And to draft what our oversight would be, and then the consequences, and then the manpower trying to calculate what we need, that's gonna take time. So maybe we start talking about it, and maybe we don't run it till next year, but at least we need to start talking to the legislators about it. Get a pulse on what they feel.
Yeah, that probably makes the most sense to me, because if even if the bill was run, then we'd have to figure out a fee, and those fees would hopefully be able to cover the costs. And
Yeah, I mean, you almost need to do a fiscal analysis
Right.
too. I mean, and this is gonna have a fiscal note on it,
Oh, yeah.
the bill,
Yeah.
so.
Yep.
It's a whole new fee for the public, basically.
Is there an opportunity to hire an external consultant to do that work?
That's the money in the budget for that.
Yeah, that costs money.
So how about this? How about we authorize the staff to pursue discussions in parallel to the JLAC hearing regarding the auditor's recommendations. If decisions need to be made in the meantime, if there's any urgency, that you could delegate it to the chair and vice chair. How's that for a thought process? We're not agreeing to absolutely to anything today, but we can at least start to pursue.
Yeah.
Do we need motion for that?
I don't think it should be me as the chair to make it, but
I think you gave us direction, so thank you.
you need a motion, Dr. Gandhi.
It'd be best if we had something on record.
I'll second that motion. I think it's appropriate.
I'm not going to make it as the chair to give myself the authority.
So,
You've made it before.
I mean, I don't know how to repeat what you said, but this is my motion.
So I have a motion and a second. Any discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. I think we should probably take a bio break. Let's come back at 3:10. Everybody. All right, welcome back, everybody. Kim, let's go to the last item on your report.
All right, Madam Chair, this is regarding public comment regarding the rules package related to fees and compounding. We did get public comment. All of them are in your board packet. Mr. Neal, are you recusing from this subject matter?
Do you want me to? I feel like that this is like my expertise.
It is, but I think you're representing and working for a company that solely focuses on compounding and representing the entire industry on its practice standards. So it may be wise to recuse from this matter. And I think we have a public comment from APC as well, right? Which I don't know
Yes.
if you helped draft or had input in it or not, but
I will recuse.
Yes, so we have public comment.
we
in
have
our
public
packet.
comment. It is
We
in
had-
your packet.
We had one additional that came in via email yesterday that I think everybody was emailed.
Yeah, and typically we don't distribute any additional paperwork after the deadline, as you guys have so much to read. But this was basically just saying we strongly supporting their first letter that they submitted. And then in addition, I think we had a public records request requesting all the comments. And then they, of course, added on their thoughts as well. So in a nutshell, I hope you all had the opportunity to read those public comments. I took it upon myself to read it and incorporate language in the draft that was posted for public comment to make some adjustments that made sense to me. May not make sense to you guys, but you'll have to either support or say it doesn't make sense or make additional adjustments if you see fit. But those were my comments and my comments only that were in the blue and red and all that other adjustments I made in the original public comment or the posting of the rules package. So some of the comments, like for instance, Alliance for Pharmacy Compounding incorporated stability under 797 and the cost parameters of 30,000 per formulation. I did incorporate that in the preamble. If you've noted that, you could see that in the dark blue. And it makes sense, but it also goes back to the history of USP 797, 795, 800, where the board had adopted it at one point. There was already a lot of companies that have adjusted their infrastructure to be compliant with it, and there was some that haven't. Don't know the exact numbers on how many moved in that direction to be compliant, and I don't know how many didn't move in that direction at that time. But as you all know, USP 800 has been in discussion for probably a decade now, I would think. But so there was ample time for modifications, infrastructure of these things. A lot of states have already moved in that direction, some 100% in that direction. Some have carved a few things out. But all in all is, I think most everyone is adopting USP. Our position, I think last time we discussed this during a task force meeting and then at the board meeting was we would still do a substantive policy, carving out some things that ordinary community pharmacies do, like magic mouthwash and stuff like that. So they don't carve out space just for compounding, but they can actually allocate an area that could be multifunctional, but then easily transformable into when they're making magic mouthwash or blending two creams or whatever. And we can incorporate that kind of stuff in a substantive policy. But the first comment was from, and I have a spreadsheet that I've created for myself so that we can have a discussion on each subject matter and I can take notes on the board's position if you're in agreement with it. Alliance for Pharmacy Compounding had that provision that 797 could cost $30,000 per formulation. Rural small pharmacies may face substantial costs. I did incorporate that into the preamble, as you can see. American Diabetes Association supports the language, aligning with USP and prohibiting unsafe pharmacy compounding. They didn't have any suggestions, so there's nothing to add or delete. APC and Arizona Pharmacy Association clarify distinction between USP standards for 503A pharmacies versus CGMP for 503B outsourcing facilities. I did incorporate that and clarify the language in your packet there for you guys to consider. APC at Arizona Pharmacy Association, hazardous drugs, reference outdated NIOSH table, recommend adopting 2024 NIOSH two-table structure and risk-based approach. I think I captured that thought the best I could. I think it's in a rules package for consideration. Again, APC and Arizona Pharmacy Association, failure to reference interim FDA bulk drug list could cause therapy disruption during shortages. So that one doesn't look like I made any adjustments. I don't know if you've had any recommendations for that. But that was a comment made by Alliance for Pharmacy Compounding and Arizona Pharmacy Association. I can go down my list and then we can kind of regroup to give you guys some thought on this. Arizona Pharmacy Compounding, Eli Lilly and Novo Nordisk, API sourcing criteria too restrictive. Risk excluding appropriate APIs such as methylcobalamin, DHE, allergen extracts. I think we did factor in the allergen extracts. I think Mr. Boson had brought up that some of these things, like for instance, leather allergies or fabric allergies or allergies that are necessarily not a drug. How do you extract that? So I believe that's already built in. So I'm not sure how to elaborate on some of those things, but the allergen extracts was built into that. APC, Eli Lilly, Novo Nordisk, copies provision, ambiguity around essentially a copy and shortage language, risk of abuse by compounding entities to evade FDA rules.
Cam, can I ask a question?
Yep.
As a new board member and perhaps ignorant of this process, maybe you can enlighten me. So we have a notice of proposed rulemaking that the Board of Pharmacy staff prepared. Is that correct?
That is.
And now it's
yes and no. The original rules package was created and drafted with stakeholders and task force members and stuff like that.
Great.
Post public comment, I made modifications to the best of my ability.
So
for
what
you
we're
guys to
looking at right
consider.
now is the result of your adjustments based on the public comment feedback.
Not all of it, some of it.
Right.
Yes,
right.
and those are my thoughts and my thoughts only, but for you guys to consider.
And what is our duty to consider public comment? I mean, is it what's the standard?
I think you address it. You're saying, yeah, we understand you have submitted public comment, and it's either you can say, yes, that makes sense, and make an adjustment to the language, or thank you for your comment, but we feel that this is appropriate.
But regardless of what we do today, these changes would be substantive enough unless we adopt the original language that we would need to send it back out for public.
That is correct. That is correct, yes.
So there will be another public comment period where people could comment again, and we might decide to make other changes. The other thing I was thinking about is I don't know if there's a value in bringing the task force back together. I mean, and just getting one blush of public, like, let's have a bi-directional conversation. I don't know. We've had, I don't know how many rule committee meetings on this, like probably at least 6, 8 on these rules.
Yeah.
And then ultimately, what happens to the rules? Where do they go to get ultimate approval?
So we will put it out for public comment one more time, if that's the direction of the board. If there's more significant public comment that's not being addressed here today or anything like it, it's going to have to come before you guys again. for reconsideration of those comments. And if nothing changes, then we move it to permission from the governor's office to move it to GERC.
So I think where we're at right now is really, do we want to bring it back forward to the task force? Do we want to send it out for public comment again? Or do we want to make no changes and move it forward? I guess is kind of my thoughts on where we're at right now. Frank, did you have a comment?
Yes, I was just curious what the typical makeup is of the public commenters that are commenting on this.
So you have a couple of manufacturers, Novo Nordisk, Eli Lilly. You have Alliance for Pharmacy Compounding Association. You have the Arizona Pharmacy Association. CVS has commented on it. American Diabetes Association has made a comment. So those are the public comments, the entities that have filed public comments.
But for those people that haven't been on the rules task force, we had compounding experts on the task force. So we brought in some additional subject matter expertise, people that don't necessarily normally serve on the rules task force, so that we made sure that we had the appropriate expertise in the rulemaking process. I don't know that I'm opposed to any of these changes personally, but I'm also not like a huge subject matter expert in this either. So it seems common sense to me, but I'm also, like I said, I don't want to make a bad decision, is where my head is.
So in lieu of that statement and the previous three options you gave us, what seems to be the best approach? And I'll offer, maybe it's accept these modifications and then put it out to public comment again and see what we get. Because if we get, for example, no more public comment, then we might be on the right track.
Yeah.
Yeah, I mean, there's compromises on both sides here, I feel like.
Madam Chair, if it's okay with you, I'll just read down the other comments that I've itemized here, and then I'll let you know. So CVS Health had put in language to clarify labeling language requirement. Prescription labels cannot realistically include purity, quality elements, and I did adjust that in there. That made sense. Eli Lilly had a provision or made a comment, advertising provisions supported need restrict prohibition on false misleading advertising. That's more an FDA jurisdiction, I felt. I don't know how we can restrict someone from doing that, but so I noted FDA jurisdiction, if you guys are okay with that. Eli Lilly also, office use compounding elimination supported, ensures prescription remains patient specific, and that kind of aligns with the FDA because I believe they put out guidance on that. Eli Lilly again prohibited. They wanted us to prohibit the sale of 503B outsourcing facility to 503A compounding pharmacies, and they stated that Massachusetts did that. I did have a discussion with the Massachusetts Board of Pharmacy, and they initially did put that out there, but then rescinded that like soon after. But there's also a guidance by the FDA allowing that practice, 503B to 503A. So,
And just from my perspective, from a hospital perspective, that's commonplace, where we will purchase from 503Bs and we're a 503A.
correct. So that was explained to Eli Lilly that this is a guidance. Of course, they challenged it by saying guidance is not the law, but guidance is kind of similar to our substantive policy, right? This is the interpretation of what is allowed by the FDA. So that was explained to them. Eli Lilly also had a misunderstanding about med spas, saying that, because I believe we incorporate in there that a pharmacist and pharmacy technician can only compound within a pharmacy. And they're like, well, this is great because now med spas can't compound. I'm like, well, that's a different jurisdiction because prescribers have compounding authority as well. So we're controlling what we can control. And that's med spas is typically out of our jurisdiction. Other comments from Novo Nordisk include documentation of 7 years. We do have a 7-year provision of record keeping in other parts of our language. So I did add that because it made sense. Anticipatory compounding provision to permissive should require history and valid. I think the interpretation is there. And anticipatory compounding is also addressed with the FDA, and it's more an FDA jurisdiction, which we kind of align with or try to follow. Bulk drug substance provision, illogically ordered, should mirror Section 503A hierarchy, replace chemical grade with pharmaceutical grade, and I did make that adjustment in the language. Concerns with compounding semaglutide impurities, inconsistent strength, safety risk, request stronger restrictions. I think our language overall aligns with FDA, and if they want to modify and make it stricter, that would be more of an FDA jurisdiction.
How does the language compare to the other states?
There's variances across many of the states. A lot of states did incorporate the chapters of USP. There's some states, California made it stricter. I'm going to say Ohio may have made it slightly different. Massachusetts did restrict 503B to 503A and then rescinded it. So there's some variations across the country.
Where do we lie in all of that?
I think we have some flexibility where obviously going to allow, like through substantive policy, some adjustments to, you don't have to allocate this space specifically for compounding, but you can put out a plastic mat underneath so that you're covering up the carpet, and then, kind of have that area where you can compound if appropriately cleaned up and whatever. So we'll make some adjustments to that. Flavoring is something that we were going to carve out as far as not being compounded. So there's some adjustments that we're making as well.
I already know the answer to this, but I'm going to ask the question anyway. At least I think I know the answer. Vitamins that are compounded. We have no control over that.
If they're considered a drug, even if it's an over-the-counter drug, and you're combining two drugs into one, that becomes an awful, it's not an FDA-approved drug at that point. And it is considered compounding.
Okay.
Compounded drugs are not FDA-approved drugs.
Well, I was thinking more, there's several outfits that I know here in town that do compounding of vitamins. How I originally discovered this was we were looking at leasing a building and they were moving out of it. And it was so polluted, the vents, I mean, everything. It was a miracle. You could just walk in and even exist. That's what made me ask that question.
Yeah. Probably a lot of vitamin C in the air, and you'd be healthy when you walk out, so I don't know, but if you do compound, even if it's two over, like aspirin and Tylenol, you put those together and make it a compound, it becomes a compounded drug. Thoughts?
Is that all your comments?
Those are the comments, yes.
Thoughts, board members, discussion?
As a hospital pharmacist for over 20 years, I fully, and sterile compounding's been a central part of my practice for those 20 years. And I do fully support your adjustments, Dr. Gandhi. I think the rules are built on USP 797, and I think that's the nationally recognized standard for sterile compounding. And the latest revision is a result of years of rigorous review and consideration by experts across the country, pharmacists, physicians, microbiologists, regulators, and it really reflects the best available science today. It's designed to protect patients, and importantly, I'm pleased to see that we're evolving and moving towards the latest versions of USP, and appreciate the efforts in doing so.
think we need a motion on what we want to do with the rules. Do we want to send them for public comment again? Do we want to go back to committee? Do we want to make no changes?
We need to move forward and finalize it, right? So what the fastest way?
Public comment?
Public comment? Yeah. Dr. Gandhi, just I have one question. Like I've noticed that we list like NIOSH 2024. Can we stay away from the exact year and just put the most recent NIOSH list?
No, there's a Title 41 statute that states that you have to reference the date and specific. So when a law comes into play, whenever the law is enacted, is up to the date that you can enforce it. If something new comes out after that, you can't enforce that. You have to then revisit that law and update the enactment date, right?
So we need motion to take it public comment, accept the changes.
Accept the changes and send it for public comment again.
Okay, this is my motion.
I think we have to though, because they're substantive changes. So we have to give the public the chance to see it, which I'm supportive of. I mean, we're looking at bringing it back at the December meeting, right? Like,
It's the right thing to do.
and that's the fastest way. I mean, if we have a task force meeting,
don't
then,
push back
then we're
again,
gonna have to go back to the next meeting and then back out again. And we can still make changes based on public comment,
Yeah.
again, at the next meeting.
Yeah.
I maintain my motion.
Do I have a second?
Second.
The motion and a second, any discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Doug, you're up since you're sitting at the table. I think you want to be done today.
Thank you so much. I only had to report on, we had our task force meeting that we talked about a little bit ago. And during that task force meeting, the things that were covered included our annual report that I presented to you guys maybe about 2 meetings ago. Covered that with the task force. And for those that don't know, the task force includes members from other licensing boards, associations, the Pharmacy Association, and prescribing associations, DEA, Attorney General's office. So it's a diverse group. And again, if we're going, I'm kind of going backwards to what we talked about earlier, and that was if we're going to repurpose this task force, membership might need repurposed too, and we'll get the right input from the House, Senate, and the governor's office. But with the task force that we currently have, we talked about our annual report. We talked about our educational and outreach efforts. We talk about compliance. Like I said, that becomes a big part of the conversation. And we talked about measuring pharmacist compliance, which is what I talked about with you guys earlier. And finally, there's a new version. I always talk about ASAP standards, and ASAP standards is how the format used by data submitters to report to the PMP. There's a new version out. It's version 5.0. I'm still learning about it. So I don't know if that's a direction that we'll want to go or not, but if you let me do my research, I'll come to you and give you pros and cons. And, the biggest thing about ASAP standards that moving to 5.0, it gives just maybe a little bit better data to help with patient matching. Patient matching is important so that, behind the scenes, you could have 20 different John Smiths, and you sure don't want the wrong drugs on the wrong John Smith's profiles. So that's all done through a matching algorithm, and our vendor has that algorithm. And with a little bit more data that coming in, of course, more data you increase your chances of having a better patient matching. And it does happen sometimes where we have to pull profiles apart because they just get merged together. So that's some of the benefits of ASAP standards. I enclosed in the book the materials that we used during the task force meeting. Ms. Walmsley was there and chaired the meeting. It was a good meeting, and I guess the only other thing I could really say that feedback that we got from the other boards was, please don't give us more.
So quick question on the SAP 5.0. How do you make the determination? I mean, do you do some kind of cost benefit analysis? Like you described the potential for better data, but what if it costs $1 million to make that particular change? Let's wait for the next one.
You know, what I'm most interested for our own use is how's that gonna make our data better? What I worry for industry is what's the impact on industry to be able to submit in this new format, you know, because there might be some upgrades that they have to make. And if we, once I did figure out if it's going to be that beneficial for us, I'll bring it to you and, you know, maybe we bring industry in on any concerns that they have. And then historically, when we make an upgrade like that, we give industry 6 months, you know, something like that. So, but just putting it on the radar for you that, you know, if that's something that we want to do, I'll share with you down the road here. There's only been a couple states that's went to ASAP 5.0. So I'm letting them be guinea pigs right now. That's all I have.
Thanks, Doug.
Thank you.
Let's go to Jennifer's report.
Good afternoon, board members. Jennifer Gelnavong, Deputy Director. So I am bringing back data that I presented to you for the first time last board meeting about some of the truly tireless efforts of our staff. I'm going to again hone in on public records requests, contact questions, and phone calls that the team is dealing with in the phone queue. The first slide here is on public records requests. The new data here is for August and September. So 11 requests in August, 15 in September, 79 public records requests year to date. Okay, on the next slide, we have contact questions. There is a feature on the board's website where you can contact the board with questions. This is just one of the many ways that the board gets questions. As I discussed at the last meeting, we can receive one-off emails. We receive questions by phone, sometimes questions by mail, but there is a feature on the website that collects contact questions, and these are all distributed to our staff. And so this is not inclusive of every question that staff gets. But in the month of August, we had 100 of these questions through the website, and then 169 in September, for a total of 1,051 year to date. I do believe many of the September questions came from the emergency rulemaking process for the COVID vaccine. Final slide here. This is data on our phone queue. So again, we have a phone queue that our licensing team uses to address phone calls that come into the office. And we also have many other ways we can be reached by phone. There are other landlines, there are cell phone lines. So again, this doesn't tell the whole story, but it tells part of it. In the month of August, there were 792 calls that came into the queue. 764 or 96% of those were answered. And I'll like to point out September. I think this is particularly impressive because this is when renewals started. 983 calls came into the queue, 951 or 97% of those calls were answered. So year to date, we have a 96% answer rate of calls from the queue, a 30-second average speed of answer, and the team is really just doing a phenomenal job managing all of these calls that are coming in. So credit to them. Are
Quick
there any?
question.
Yeah, are there any questions?
Yes, I have a question on the 97% call. Is that measured after a certain number of rings, or is that even if it's one ring and hung up? How do you have a way to tease that out?
I believe we do have a way to tease that out, and I can look into that for the next meeting for you.
Dr. Kianavong, regarding the public records request, do we assess a fee to request any records or charges per page? Do we do that?
I'm not familiar with any fees we've assessed. No, we've not collected any fees for that.
Do we have the authority to do that?
I believe you do, but most agencies today, given that everything is kept electronically, it is often just a matter of pushing a button and sending it along.
Okay.
Appreciate it. Thank you.
Yeah, thank you very much.
Truman, you're up, man.
Or Liz, give him a hard time.
Hello, board members. Thank you for your time. My name is Truman Leong, Chief Compliance Officer with the Arizona State Board of Pharmacy. On our first slide, we have a total number of inspections by compliance officers. In August, a total number of 110 inspections, and in September, a total number of 90 inspections for year-to-date 1,011 inspections. Next slide, please. Violations. Permit holders are doing well. In August, we only issued 1 citation, and in September, a total of 5 citations. Year-to-date, 113. Next slide, please. Permits visited but not inspected or other activities by compliance officers or board staff. Of note for the board, some of our staff worked really hard. I'm not allowed to disclose names, but some of our staff did participate in the MPJE item review. Arizona had about 3,000 questions to review for accuracy, and we were able to accomplish that activity, dedicated about a week, about 4 compliance officers total in staff. Next slide, please. For CE audits, complaint investigations, and permit reviews for the month of August, we totaled 57 CE audits, and in September, 59 for a total of 571. For complaints completed, investigational files in August, 47 were completed, and 19 in September. For permit reviews, compliance staff completed 25 in August and 17 in September. Next slide, please. On the last board meeting, board member Mr. Hogan had inquired about the pass and fail rate for pharmacists and technicians, or combined, that we're seeing throughout the year. We ran a quick swath on calendar year 2025. You can see on the first column there, pharmacists are in blue, technicians are in orange, and total number audited in green. You can see a total of 627 combined audits. For pharmacists, we had a 90% pass rate with a 10% fail rate. For technicians, we had 84% pass and 16% fail. As a combined licensee, 87% passed and 13% failed. Most of the fails were due to opioids, being missed special CE audits. A lot of times technicians would have misalignment between their PTCB renewal dates for their continuing education and the state requirements, and or the other more common factor is usually they had no CEs at all.
So I thank you for doing that.
Absolutely.
If I can ask some questions about that
Sure.
and make some comments. So I think we have, just to take pharmacists, we have about 12,000 pharmacists. So if 10% are in this sample are failing, then that's about 1,200 pharmacists that potentially failing CE. Seems like a lot to me. I'm not sure what to do about it, but let me think about it and I'll get back to you.
Thank you, Chairman.
Thank you so much.
Hannah.
Yeah, we're almost done. Do we need meeting tomorrow? Just kidding.
Thank you. Hannah Bolts, Licensing Division Manager. I just have a couple things for you today. First on the agenda is basically the ratification of the address of record that we added to our applications. So we need to be in compliance with this statute. Basically, it requires us to record an address of record to keep on file that may be disclosed to the public. So we put this address of record question on all of our initial applications and also on renewal applications, so people can tell us, do they want their employment address as their address of record, or do they want their home address? If it's their home address, you're able to opt out of that disclosure. So we added that to our applications, and now we're in compliance with ARS 3226.
So you need a motion to approve?
To ratify the changes that we made.
Anyone?
Since I already applied for my license and I checked the opt-out, I'll move that we accept that recommendation.
Second.
I have a motion and a second. All those in favor?
Aye.
Any opposed? Hearing none, motion carries.
Alrighty, and then we're on to my activity report. All right, so this first slide here is the number of issued licenses, registrations, and permits for year to date. So year to date, we have quite a few pharmacy technician trainees there. Very exciting to see. Hopefully we'll see those people getting their technician licenses. For the month of September, we did a really fantastic job with interns. Of course, interns went into school about at the end of August, and we got 134 interns licensed. And we also got 39 in September, maybe a couple more stragglers left. So really, really proud of all of the team's hard work.
Thank you.
Next slide, please. Here's the number of closed licenses, registrations, and permits. You probably won't see too many until October 31st when all of the licenses in the odd renewal cycle expire. Technician trainees and interns just expire. Trainees expire after 3 years and interns expire after 5. So they don't have the same expiration date that other people do. Next slide, please. All right, here's our number of pharmacy technician trainees who obtained licensure as a technician. In the month of August, we had 58, and in September, we had 112. So that's really awesome to see. Hopefully, we'll see that number climb more and more. Next slide, please. All right, these are our oldest pending applications in business days. So, and this is a single day snapshot. So on October 8th, 2025, in our pending queue, the oldest application for a pharmacist was 10 days. Interns and technicians was 1 day. Very, very exciting. I'm very proud of my team. We had 3 new people join back in right after Memorial Day, and they're coming along really nicely, learning how to process all the different application types. Really inspiring to see how far they've come along. Looking forward to sharing the numbers for the rest of the year next time I see you all. Next slide, please. So this is the oldest in progress applications in business days. So I know we've discussed this multiple times. Pharmacists are our oldest applications. People can apply when they haven't taken their pharmacist exams yet. So we have a lot of people who are just sitting in progress. We're waiting for them to test, pass their exam. So 230 was the oldest pharmacist application. That's almost at a year. 235 is a full year in business days. Or I think 235. But as you can see, the rest of the applications, are a lot lower. And hopefully with the guidance on the website, people will, wait to apply until they've passed their exams, and then we don't have to worry about their applications timing out, them wasting their money. Yes, so thank you. Next slide, please. And here are the number of in-progress applications. Did I get my slides mixed up maybe? That's a single day snapshot from October 8th. My apologies, guys. And I think finally we have our renewals. Yes, so I pulled the numbers of renewals from 9/2 to 9/30. So we're halfway through the renewal season. At this point in time, we have renewed. At this point in time, we had renewed almost 7,000 pharmacists, technicians, manufacturers, medical gas, durable medical equipment suppliers and distributors, pharmacies, remote pharmacies, third-party logistics providers, and wholesalers. A lot of those are done in the renewal online, but anyone who answers questions affirmatively in those applications, they may be routed to a renewal processing queue, and we're working through that queue right now. Any questions?
No, thank you. Again, really great to see the wonderful processing times. I think your team is doing a tremendous job. Something to be really proud of. Thank you.
Thank you. Appreciate your time today.
Dr. Gandhi, other than call to the public, have we covered everything today? I think we have.
I believe we have, Madam Chair. Great job.
Let's open it up for call to the public. I can call on you by name, except for one person that I don't know their name, I think, but.
If you want, Madam Chair, I can speak on behalf of Roger Morris.
Did he send you a
No, no,
call to
but
the public?
I can figure out what he wants to say and I can probably chime in. I think we'll give it another 30 more seconds. I don't see anybody dialing in, but there's a lag. I think we're good, Madam Chair. We don't have
Okay.
anybody dialing in.
We will recess for the day. Appreciate everybody's attendance.